Welcome back. It is Tuesday, October 25th, just before 2 p.m. Central Standard Time. We are going to be rejoining the Brooks trial. This is the individual accused of killing 6, injuring 60 plus more during a Christmas parade in Waukesha, Wisconsin. He is representing himself. We are getting into closing arguments. There is a lot that has been going on in court. He is sitting in the courtroom now. The judge is not on the bench yet. We have a poll up to see how long it will take before we actually get the jury in the room for closing arguments. He is sitting in court, not in the timeout. This has been a very interesting trial with him representing himself on such a serious case with so many counts. We are going to get right into live trial coverage. I will not talk too much through the closing arguments, but we'll be giving live commentary as I do. So let's roll the intro. Let's pull up the court feed and let's just get into it. Thank you for being here. Thank you for being a law nerd. They're just coming back, so let's go. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. All right, we are back at court. The judge just took the bench and is flipping through
There's one on here.
something. I don't know what. Hopefully you guys got some lunch. Let's see what we got today for provisions. I learned during Depp v. Heard. I have gummy bears.
All right, it's 2 o'clock. I'll call the case. State of Wisconsin versus Darrell Brooks.
Cookie.
Case number 21 CF
2 cookies.
1848 may have the appearance.
I needed a
please.
cookie. I was joking about cookies earlier. I wanted a cookie. Smokehouse almonds. 3 things of water.
I'm here without prejudice by special appearance. Beneficiary, I'm here under fraud, menace, duress, and extortion. Judiciary, Jennifer R. Darrell.
Oh, he's under here under duress and
This is a
extortion.
Social security, sesquique, trust action, which you are a real party and interest to, as jurors and propria persona. This is a
just
military
fixed the sound.
admiralty tribunal and maritime law.
This is not a military
Title
tribunal
4 of
under.
the United States Code, Section 1,
That's not what's happening here.
which you can see,
False.
which states
False.
placing a fringe on the national flag is within discretion of president acting as commander-in-chief of the Army and Navy. Is this a common law court or an admiralty court?
Sir, it's not how this
The records
works.
reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing a
Oh, you don't,
dress
Shelby.
shirt.
I talk in the back.
I
I run
know it's a
commentary
suit
when I'm
coat,
in
but it's
class.
not
I run
on.
commentary
He's
when I'm
also
watching
wearing
sports. I run
a mask.
commentary when I'm
The court
watching a
is
movie.
not
I
going
can't
to
stop.
address any of the issues that he is raising.
We're on
as
slow
they
mode.
are
We just have
meritless.
15,000 people.
And I would also say the same as to the notes that
The
he
United
passed while he
States
was in
Constitution
the
grants
other
you a lot of
courtroom.
rights that you don't
For the
necessarily have
record,
to
I did
exercise.
provide a copy of all
Representing
of those to
yourself's
the
one of
state
those.
as well. They are also uploaded
So
into
he's
the
on his
file
sovereign citizen things.
and are made part of the record to the extent that he raises objections or lack of consent. It is noted for
Here we
the
go.
record.
I was about to do that and say that I don't consent to being called that name or identity.
We
That
know.
is
We know.
the trust name, and it is not me, myself.
Oh, he's
I don't
saying that he's a
recognize that
trust.
name,
Darrell
nor do I
Brooks
consent
is a
to being called by that
trust,
name.
not an
With all
individual.
respect, Your Honor.
No, the trust is not being
Still
sued.
have yet to address subject matter jurisdiction, what has yet to be proven.
It's
on the
not
record.
happening. Jurisdiction was proven. Jurisdiction was proven. I like doing live trial
May I
coverage too. It's
receive
one of my
those
favorites.
Original copies time-stamped.
They are. No, you may not. That request is denied. We're just
All right, I need
sending.
to make a record of one part of a jury instruction that I do need to advise the jury. It will
We're just-
also be corrected in the packet.
Sending energy to the court.
I believe within the last year, the jury instruction on credibility of witnesses was modified by the jury instruction committee.
5.1 is a
And
good,
it was
a
just an
good,
oversight
a good
on the
shake,
court's
Darcy.
part to not
Hope
include,
all's
it's
well.
really just one paragraph. It was read to the jury at the beginning of the case with the preliminary instructions, but it is a
The jury is
paragraph
not in
regarding
there yet.
implicit bias, and so I do think it's important to advise the jury of that.
But this is all
intend
counting
to
towards,
do that
this
when
is
they
counting
come
towards
out. And then
how long it
again,
takes the jury to come out.
The
This does
full
not count
instruction
against
will
their
be amended so that
closing.
it's in the packet that goes to
This is
the
all
jury.
before the jury comes in.
And Madam Clerk, if you haven't already, if you could print off page,
Yes, subject matter
72.
jurisdiction is not magic words that he thinks they are.
it's the, it adds a paragraph before the last paragraph that starts with, "There is no magic way for you to evaluate the testimony." And again, I wanted to be consistent with the most recent version of the jury instructions and consistent with what was instructed.
Did it get rid of the magic
provided to
word?
the jurors at the beginning of the case. And so I will make sure that they have that, and so advise them when they come out. Also,
This kind of clerical stuff is really
I will
typical.
read instruction 160, closing arguments.
Are not evidence.
Madam Clerk, if you could just make the change so that it's of parties.
Yeah, he does not
missed that,
consent
correction as
to being
well.
prosecuted
So it's
for
the closing
murder.
arguments of the parties, not the attorneys. And so I will just make that correction and make sure it's,
I accept for value in return for value this document, and Your Honor, I requested that I have copies of my filings from earlier, time-stamped.
Mr. Brooks, I'll
No.
provide you with
That
the
is
copies
denied.
later on. I need to continue with the
We need to move.
instructing of the jury and have the parties make their,
No, people
Closing
don't consent to being
arguments.
prosecuted.
Your Honor,
They-
with all
I did-
respect, the
There-
state received copies. How come I can't receive the copies of my filings?
You wrote it,
you know
bro.
what, we'll give, I can give you the
That's why there's
print-offs, but I can't give you
due
the originals
process,
right now.
because people
That's
don't
what I'm
consent.
referring
There's
to,
due
and you'll
process to
absolutely get
prosecute
those
them.
back. I guess I was mistaken that you wrote copy on it. I thought you retained a copy for your records. So with that, Madam Clerk will print
don't write
off
copy
from
on it if it's not the original.
record. It won't be the yellow copies just yet. I'll take that up later outside the presence of the jury after the case has been given to them. Now, in terms of the closing arguments, I did set a time limit for the
Rules.
parties yesterday.
Rules.
Each side will have a total of 1 hour. Mr. Brooks, so that you are fully aware, the party with
He
the
doesn't
burden
give
of
a
proof,
fuck.
which is the state of Wisconsin, goes first. Then you, as the opposing party, will have an opportunity to respond and argue. And then time
That does
limit
not mean what you
willing,
think it means, Brooks.
the state also has the opportunity to present rebuttal, because they have the
Burden of proof.
And that is provided with the excerpt from the bench book that was provided to you yesterday. It has, the purpose of the closing arguments is to summarize
Oh,
the facts.
they gave him the
marshal
rules.
arguments, focus the issues for the jury.
more than an attorney would
I
get.
just talked about the order of the arguments.
Yeah, he only heard the word
The
argue,
scope of
chat.
the arguments are, the content, duration, and form of argument are within the court's discretion. That's why I set a time limit of 1 hour for the parties. And
They set a limit to rein him in. The prosecution was like,
Mr. Brooks,
I
I
can
will
do this in
advise
30.
you that I certainly will wait and see how you present your argument today. I will certainly wait to see if there are any objections raised, but I also want
Oh,
you
there
to
will
be
be.
aware that if I feel the arguments are improper, I may simply, without an objection, say, please move on, as a clear indication from this court that what you are stating is not proper under
He's making
the
the I'm not listening face.
various rules and case law that govern
Literally, I'm not listening.
closing arguments.
No, he'll be allowed to
Again, Your
stand.
Honor, without prejudice, I'm here by special appearance. I don't consent to being called that name for the record.
It's noted, sir.
Okay.
All right, then with that, I will have the looks like Attorney Upper has some issues.
The
she
except
wants to
for
raise.
value,
Yes, I just have one question,
is
Your
a
Honor.
sovereign
Would
citizen
I
thing.
have permission to put the easel up and display some of the poster boards? I did confer with Captain Dussault as far as security is concerned, and he agreed to it if the court would give me that authority.
Where would it be displayed?
He's gonna put it like right here, and then you want me standing at this table during.
I do.
they're
Yes.
limited
So
to
I
where
would
they
just
can be during
position it
closing, which is
right
not normal procedure
And
when
I
you don't have a
to leave
pro
it up
per.
through the whole thing. I realize it blocks the view of people in the courtroom.
You're
Like
allowed,
Stacy
you need to be able to
and
use your
assisting
exhibits,
and
your
removing them when I'm
exhibits.
done with them, if that's okay with you.
It should
I
be.
trust it won't block Mr. Brooks' view of the jury, and
That's
as long
what
as,
yeah, I was gonna put it like right.
Because
above there
they're,
so that
normally you
you
can
still
go into
see
the well
me and
in front of the jury to argue,
that caveat,
like
yes,
they
I will
did
allow
in
that.
Depp v. Heard. You saw
Objection, what
them
is that?
right in front of the
What is
jury.
supposed to be put up?
It's an easel, sir, to put exhibits up. They're allowed to do that during their closing.
Previously admitted, Your Honor, it's exhibit 15.
They can
and
use whatever they want in closing. They could,
So
they
are
could,
they exhibits? I'm confused to what they are.
ask your
Mr.
lawyer,
Brooks, I made a
sir.
ruling. The state has made a request, I've granted it.
Yeah, but
In
I'm
terms
Ask your
of-
lawyer.
I don't understand what's being shown.
Bummer.
Should not have the right to ask, to object and ask what it is that's actually gonna be shown.
No, they're allowed to, they
The
just
state's
told
put on
you.
the record what it is. They, or I should say, they are exhibits that have previously been received by the
they're
court
using
during
in
the
their
course of this
closing.
trial. That is
Stop
proper for
explaining.
a party to do that during its closing.
Sir, the state put them on the
arguments.
record.
Can
The
I
record
put
is
up
clear.
exhibits?
Yes? If you brought an easel to put them up with.
Mr. Brooks, I don't know what you have planned for your closing argument.
I can't advise
so-
you.
I'm making a request, the same request. May I be able to put up?
I can't advise
Well, I guess
you.
it depends on what it is, sir.
Only if
So
they're proper
I'm not gonna
exhibits.
take up any more time, because what I intend
Yes,
to
we
do is,
are.
once the state.
We're almost 10
goes
minutes
through
in.
Its closing, I may take just a short comfort break, depending on how long it is. And if there's something in particular, what are
Nope.
you will need to tell me what it is. As long as it's an exhibit from this case, then I wouldn't have an issue with it.
Unless he
It
starts
they
trying to
would
write
be
on it.
From this case, obviously.
Obviously.
It's just not nothing that the state has.
Well, no,
I'm
because
not
you
aware of exhibits
didn't enter any
the state wouldn't
exhibits, sir.
have, that you would have.
Yeah, that's the thing. You
Everything
can also
that's
use
been received, we
demonstratives
have a
during
list.
closing.
Um,
There's a lot you can
So
use
if
during
it's not
closing.
something that was received during this trial as an exhibit
And
by
we've
the
got weather
court,
coming through. Perfect.
unless you tell me what it is so that I can make a ruling, I can't see how it would be relevant or appropriate for your closing argument.
Because it's not.
They're
Because both. Because facts.
part of my filings that you filed.
No, that's not exhibits.
Filings
Those
that would
aren't
be relevant
evidence.
to the issues that are before the jury. The closing arguments are to direct the
Because
jury
it
so that
isn't
they have your arguments,
evidence.
so that when they go back to determine the issues in this case, which are related to
I'll answer this in a sec.
whether you're guilty or not guilty of the 76 charges. Things like subject matter jurisdiction.
Irrelevant.
Or like that would not be something that would be proper before this jury. Those are legal issues. that
she
the
opened
court
the
would
door.
decide. The jury is the judge.
He's
of
going to
the
just
facts.
run right through it to argue with
Court is
her.
the judge of the law. That's why I
I'm not-
have all
Stop
of these jury
explaining the judicial
instructions
process
give
to
the
him.
Jury.
I'm not referring to subject matter jurisdiction.
What are you
Great.
referring to then? Be very specific so I can make a finding and
I
ruling.
was specific, my
No.
other filings.
No.
It's not specific enough. sir.
Filings
What
are
you referring to?
not
Which filing?
Evidence.
Let me know when you're done, Your Honor.
Which filing,
Ooh.
sir? Not
Rude.
generally, but specifically.
Rude.
Are you done?
Oh, fucking hell. Oh, sir. Are you done, Your Honor?
Are you done?
Sir, that's very rude. And
Ooh,
I
the
didn't know if you was
control.
gonna say something.
I
That's why I'm
paused.
asking, are you done?
Which,
Are you done?
what
Your
filing
Honor, how
are you
come
referring
every
to?
time
You are
I
not
try-
arguing with
even
your
when I try to err
girlfriend.
on the side of caution, you find some way to make it to be something it's not. I didn't know if you was gonna say something else.
Are you
I've
done?
asked a question, sir, so when I do that, I would hope it would convey to you, I'm looking for an answer. So which filing
You know
are
this is how he
referring
argues
to?
with people all the
All
time,
my
right?
filings, my notice of appearance, my statement of particulars, my bond, the court docket sheet,
Those aren't
all of those filings.
evidence.
The request to display those to the jury is denied. It's not relevant.
And
How's
it's
it
not evidence.
relevant? Not even your
That's my
oath of office?
determination, sir, so I am going to start this.
It's not
Not even
evidence.
your oath of office can be shown?
I'm gonna
No,
start this.
that is
Good
not
luck.
relevant to these proceedings. sir.
Good luck.
It is.
It's not relevant in front of the jury.
It's
Why
not
is it not relevant? Can
proper argument. It's
Mr.
not
Brooks.
evidence. Move on.
Can you
You are
explain why
not
that's not
going to
relevant?
be able
Yeet.
to raise those types of
Yeet.
issues and present a
He's gonna get
closing
yeeted.
argument based upon my oath of office, whether I'm licensed to practice law in the state of Wisconsin.
I said your oath
whether
of
there's
So
office, I
subject
didn't
matter
say anything.
jurisdiction,
ridiculous.
Whether you consent to this appearance or not, none of those things help the jury.
Stop explaining to
determine
him.
the
Your
issues
record's
in this
clear.
case, which are related to
Move on.
whether you are guilty or not guilty of the 76 charges that have
The
been
jury
filed
should
in
know
this
that,
case.
they should know the truth in their duties, in their rights. They
They
should know
did.
that at least.
She read them in the jury
Mr.
instructions.
Brooks, I'm putting you on notice that if you continue with this
One.
insistence upon presenting information that's not properly before the
You know
jury
that's what he's
as
gonna do.
Evidence in this case,
Please.
that I will instruct you during your closing argument to move on and potentially ask the jury, have the jury leave so that
This
I can
attitude
admonish you.
of his.
And if you keep insisting on that, sir, that will be
Yeet.
in direct violation of the court's direction
So
to
they
you.
can't even know that I got a shock device on my ankle?
Ask your lawyer,
They
sir.
absolutely do not need to know that. So
Why
it's
not?
relevant to the determinations of guilt or
To
innocence. in
protect
this
It's the
case.
you.
truth.
To protect
Mr.
you.
Brooks, your custodial
To
status is not on
protect
trial here.
you.
I would argue that it
Your
is.
conduct from November 21st
To
of
protect
2021
you.
is
That
what's on
hasn't been
trial.
proven.
You may not bring up
Just a reminder that self-promotion will be
the
deleted
way
in the
that you've
chat.
been
Thank
shackled.
you.
It's not relevant, sir.
It's
And
the
if you
truth.
do so, you do it at your peril, but here's the
There
thing,
is
the
no
jury
peril.
is specific.
It's my right,
No,
though.
let me go.
Let me go.
It's my constitutional
is-
right.
They're trying to
Just
protect
like under
you.
the First Amendment, which I preserved, my First Amendment right.
Your
when I
First
came in
Amendment
this
right
morning,
is
I also
curtailed in a court of
preserved my
law,
Sixth
sir.
Amendment
Mr. Brooks.
right.
Sir,
Please
sir,
stop.
there are
You do not
rules.
have an unfettered First Amendment right. That is very
Facts.
clear based upon
What do you
all
mean
the
by
case law.
unfettered? What do you mean by unfettered? I
It means
don't.
it is not absolute. It can be
Don't
restricted.
define it for
So,
him. Ask
the
your lawyer.
Constitution of the United States can be constricted.
Yes.
Mr. Brooks, I'm putting you on notice that. if
You're
you
gonna get
continue
constricted in a
with your
second.
Insistence on raising issues that are.
I'm gonna
really a
raise issues that the
distraction,
jury needs
that
to
are-
know.
Oh,
they're
fucking
not
hell.
Regardless.
issues.
Are we at
because
15?
they're-
Oh, we're at
they're
15
under
minutes.
the
Everyone who
rights
voted
of the
15 minutes,
United
we've hit
States
that.
Constitution, which
Mr.
is the
Brooks,
law
I
of the
direct your
land.
attention to closing instruction 460.
I'm
which will be
going
read
to
jury
let the
at some
jury
point.
know the truth.
Spam will also be
Their
removed.
duty and their rights. Under the First Amendment and under the Sixth Amendment,
That's in
I
the
have
jury
the right
instructions.
to inform them of their rights, of the truth, and of their duties.
Here we
Under
go.
The First Amendment
Here
and
we
under
go.
The Sixth Amendment.
Here the
of the
fuck we
Constitution
go.
of these United States. You can't.
She
no
can.
state law can override that.
Sir?
Any law,
You intend
any
to
law
bring this up when the
repugnant.
jury comes out,
Your Honor.
because I need to
No, I
let
do
the
not. That's
state-
why I'm addressing this before they
I'm not-
before they come out.
Sir,
That's why I'm trying to address this before they come out.
That's
so
facts.
it doesn't become an
That's
issue
fair.
once they're in here.
That's fair. He wants
But
to argue
under
more.
the First Amendment.
That's fair.
And under the Sixth Amendment
Nope.
of the Constitution, which are rights that I preserved the
No.
moment we stepped in
You
here
don't
this
get
morning
to
when
do
this
that.
proceedings started.
that's not what that
I
means.
preserved those rights for the record. And now you're telling me
What that means.
that those rights are not, would you say unfettered or? I
Correct.
don't know what you say. I don't even know what that means. I don't even understand that.
Sir,
But any law repugnant of the United States Constitution is null and void.
that's not how
Mr.
that
Brooks, I'm
works.
putting you on notice that you can also forfeit by your conduct the right to present a closing argument.
There we
In
go.
appropriate circumstances.
There we go.
The right to present a closing argument, no different than the right to testify, may be subject to forfeiture where your conduct is incompatible with the assertion
He's
of the
trying to
right
address the issues,
at
though.
issue.
Let him finish addressing the
goals
issues.
that this court has attempted to follow throughout this proceeding are multifaceted.
She's
and
let him get away with
multifold.
so much that he thinks he
Number
can just
one,
keep arguing is the
I do have an
problem.
obligation and I have done my best to ensure that this is a fair trial.
She
However,
has.
a fair trial does not mean a defendant has unfettered rights
Facts.
to state whatever he wants, when he wants. This court, not only through the course of the trial, is deemed with the responsibility to control the presentation of evidence as to ensure fairness and reliability of the criminal trial process. It also includes ensuring that the closing arguments
He
are
uses,
relevant,
I don't
are
understand,
appropriate.
as a shield
This
and a
court
sword.
must also be concerned with efficiency and effectiveness, and of course,
She's gone over this
last but not least,
every day.
courtesy and decorum in
Multiple
this
times a
courtroom,
day.
what I would generally refer to as civility in the courtroom. You do not have unfettered First Amendment rights or an unfettered Sixth Amendment right, sir. You must conform your conduct to the rules of decorum.
You
the
must
rules of
bend the
evidence,
knee to the
and
rules of evidence.
procedure. Well, you have a right to present relevant and probative arguments to this
She
jury.
had this prepared because
You
she
may
knew.
not, and you may not present arguments related to such things as
You may not
jury
say whatever fucking
nullification,
shit you want.
subject matter jurisdiction, the court's oath or lack thereof, if that's what you believe, whether this court
Oh,
is a court
Rose,
of
that is a
common law, admiralty,
kind
all of
compliment,
those
but
things
no, I wanna
relate
do this.
to
I
your
like doing
claim
this.
as
This
being
is
a
what I like to
sovereign,
do.
which are frankly
This,
baseless.
I wanna do this.
They're
I don't wanna do that.
meritless.
I wanna
They've
do
been
this.
debunked by many courts, including
Meritless
the court,
and
in
debunked.
the Beneby decision that's been referenced by this court previously. I will give you a fair opportunity to present a closing argument, but
He
again, it
disagrees
is
with
not
that.
unfettered. The simple fact is, sir, this court can restrict
And
your
will.
right to present a closing argument. This court has the authority under 90611, under the various cases, including Illinois versus Allen, including Rock versus Arkansas, although Rock versus Arkansas
Rock versus
and,
Scissors?
Chambers versus
Damn it.
Mississippi dealt with the right
Opportunity
to
missed.
testify. There is a decision, I looked it up earlier.
Was there
Pull it
something
up
in
and
there
tell
about
you the case
admiralty?
site so that
Yes,
we-
he keeps
so
asking
that
if this
you
is an
have it.
admiralty court because there's an eagle on the flag or some shit. I
Would
cannot
direct your
extrapolate
attention
what
to
sovereign
Herring
citizens are
versus New
thinking. I
York, found at
can't.
422 U.S. 853, a 1975 case, although in a footnote, it
He
does
understands on-
stand for the
Versus New
proposition
York.
that a
Every time
defendant
she
who has
pauses.
exercised the right to conduct his own defense has, of course, the same right to make a closing argument. That's quoting state Ferretta versus California. However, following the same logic from
Interesting she pulled
Rock
Ferretta.
and Anthony and
That's
Chambers, a right, even a constitutional right that a defendant has may
Interesting.
be forfeited by
What's the
conduct.
fringe on the flag
This
that was the
court,
problem?
just like it attempted to do with regard to your
left my
right to
gavels and my-
testify and set
my
up
gavels back
reasonable
there.
restrictions so as to meet all of the goals that the court needs to meet, will be as follows, and that is, again, sir, you may not bring up
We're rounding,
matters that are
we're rounding towards
not
30 minutes.
relevant to the determination of guilt or innocence. That means evidence that was not presented
Ferretta's
and
a
not
California
received in this
case.
courtroom is not relevant to your closing arguments. It's not,
She knew this was coming.
the arguments must be based on the law.
Unfortunately, the
you
court feeds do not have
interpret
closed
the law, but
captioning,
as the
otherwise I'd
law
have it on.
is, you must base your closing arguments on the facts that have been established during this case, meaning the evidence, the testimony. As I indicated earlier, the purpose of a
Marta,
closing
you might
argument is to
not-
summarize the facts.
We've got a few more
marshal
hours.
arguments, and focus the issues for the jury.
At least he's letting her finish. I mean, that's
It is fair
good.
that you comment on evidence, including arguing evidence to the conclusion or inference. It is your ability or your opportunity to convince the jury that you are not guilty of these offenses. You may not convey any idea that you have undisclosed information.
Yes.
Neither party may vouch for a witness or otherwise express personal belief or opinion
Yes.
regarding truth or falsity of any testimony or evidence.
Yes.
It would be improper to ask a jury to draw inferences that the parties know are
Yeah,
not
hand
true.
lotion.
And your
Correct.
comments on evidence is limited to evidence in the case. You may not comment on facts outside the record, or peculiarly
Good luck with
within
that.
your own knowledge. And that is just some of the guidelines for
read all of
determining
them.
the propriety of arguments that I am
Just read
guided
all of
by
them.
from my judicial bench book and all of the cases that are referenced therein.
Lauren next made a fair comment
So
in the
you are put on
chat.
notice, sir, that even without an
They are trying to
objection, this
protect
court
him.
may, in an effort to preserve
is
the
not-
dignity, the decorum,
He is
and to
not
keep the issues
seeing it that way.
properly before the jury, may advise you during your closing argument to move on.
He's not going to
If you
listen.
do not honor the court's rulings,
She'll kick out the
then
jury.
you will run the risk of forfeiting your right to be present and potentially forfeiting your right to further present your closing argument. With that, I am bringing this jury out to complete the instructions that I need
Let's
to complete,
see.
to add to the credibility instruction, the paragraph on implicit bias, and to let them know the full instructions that
I'm bringing
they
this jury
receive
out.
will
Let's see how
have
much longer it is before
to
they come
read
out.
160 closing arguments of the parties, and then to have the state go first as they bear the burden of proof.
Now, Your Honor, I just
Yep.
let you make your record. I didn't overtalk you. I didn't interrupt you.
Now I want to be
Is
heard.
that fair to say? I let you.
Now it's my
make the
turn.
record.
What? You're not cross-examining the
With all due
judge.
respect, when will I be able to make the record? As I've tried to do numerous times.
You've
by
made a
saying
record.
I wanted to
He
present
waited,
an offer
though.
of proof for my appeal. That's the chance for me to be able to make the record.
He did wait.
Denying your request to make an offer of proof regarding your appeal. It's
So,
not, I am
I'm
not
not allowed to
required
make
to
the
give you
record at
that
all, Your Honor?
opportunity, sir.
I'm not allowed
Sir,
to make the record at all. As I just let you did, because some of the
Sir,
issues
I
has
have,
been, some
you
of the
have
issues
told me
has
what you
been,
want to do,
Your
I've told
Honor.
you you can't. I've addressed
Your
the
Honor,
request.
some of the issues have been me over talking you and interrupting you. I did not do that.
He's like, look,
Even
look at
though
me.
everything that you said,
I didn't get my way
you
this
have
way.
not proven for the record.
Can I
and
get
it's-
my way
it's
this way?
unlawful law. You haven't shown one time that's
Sir,
lawful for you to do what you've
that
been
ship
doing.
has
as far as your
sailed.
ruling.
Once again, I'm not going to debate with you the prior rulings of this court. There is absolutely no need at this point for you to make an
Honor.
offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
You
I'm
will have an
going to
Sorry.
opportunity, if
I'm
you
Switch
wish
going
it,
quality.
to
inform the
raise
jury.
every issue you want on appeal.
I'm going to inform the jury of the truth, their duties, and their rights, as I have the right to do under the First Amendment and under the Sixth Amendment.
Jury nullification
can't
is what
just
he's going to argue. It's going to.
Disregard the United States Constitution. You can't do that.
Oh my.
Again, any law repugnant of the United States Constitution is null and void.
You can't tell the jury
There's no
that.
state law that you can cite.
That's
There's
jury
no federal
nullification.
law that you can cite that overrides the United States Constitution.
That's a jury nullification
No,
argument.
I direct your attention to State versus Anthony, although that case dealt with the right to testify.
Okay, so
its
we're not talking
reasoning
about the
is
right to
equally
testify.
applicable.
The
We're
reasoning's
talking about
applicable.
the closing arguments, correct? We're not talking about testifying, which you
Mr.
already
Brooks,
made a
I'm not
ruling
going
on.
to delay
Yeet.
You
any
already
further
made a ruling
closing
on
arguments
it,
of
but
the
Your Honor,
parties.
with all due
I will
respect,
address your further request
with all due
once the
respect,
state.
you
I
already
could
made
never.
a ruling about testifying. Did you or did you not?
This deputy, I could
Mr.
never.
Brooks.
So we're talking about now, we're talking about
could never
closing arguments
keep my
that
face
I
like
said,
that.
it's my right to be able to inform the jury of the truth.
Can
their
you just stop
duties,
arguing
and their
now?
rights.
No, you can't. This is
That
jury
is my
nullification.
constitutional right.
No,
Mr.
it's
Brooks,
not.
We
You
are at
can't
the stage
tell
of
me
the
I can't-
proceedings where it is the state's burden of proof where they get to make their closing argument.
You're talking
first.
about me, though.
I understand that, sir, but
I'm going to inform
your
them of the
conduct
truth.
right now is delaying
I'm not intended
the court's
to delay
attention
anything.
Hear him,
I'm
Your
listening-
Honor.
with the
Your Honor,
closing argument.
Listen to
I
him.
just sat there and let
Listen
you make the
to
record.
him.
I didn't overtalk you or
Listen
interrupt
to
you. I
him.
let you say
He
what you
wants to
wanted say.
argue jury
I let you make the
nullification.
record. I didn't interrupt you not one time.
No, but sir, you're attempting to disrupt the proceedings by
I'm not
going off on a
attempting to
tangent
disrupt
into all
anything.
of these other issues.
How-
From my
how am I-
perspective, that is
Ye-
in an
How am I
attempt
being
to
dishonored?
simply
How am I being
delay
in
what we're
dishonor?
doing.
How am I being
So you
in
are put
dishonor?
on notice. I
You
am
put him on notice
done
4
dealing with
How am I
times.
being in dishonor,
issue.
Your Honor? How am I being
This
in
is your
dishonor
last,
of the
last,
court?
last, last,
Mr.
last,
Brooks,
last warning,
I've
except for
made
the
my
last one.
determination.
And have
I'm
I not
going to
preserved my
address
rights?
this further.
Have I
Switch
not
my
preserved
head.
my rights?
If you insist
No.
on interrupting the court and disrupting the flow of these proceedings
Yeet.
by a blatant disregard for the parameters that I've set up, you will
The parameters that
forfeit
the
your
law
right to be
sets up.
present in this courtroom and potentially forfeit your right to present a closing argument.
Under
I
what
think
lawful
that's
law
gonna
can you
happen.
do that?
Sir, I've
You
made
can
my
hold me in
determination.
contempt by Illinois versus Allen. You can do that. You stated that numerous times.
Mr. Brooks, I want you here for the closing arguments, but
Apparently
you
you
do
don't.
not want
Apparently
to
you
follow
don't,
the
Your Honor,
rules.
because all I said was, it is my right under the First Amendment and the Sixth Amendment to inform the jury of the truth, their rights, and their duties. I never once said anything about, oh, I'm going to bring up subject matter, or I'm going to bring
You're
up
right,
this,
sir,
or
and
I'm
I
going to
will
bring
wait
up
and
that.
see what you have to say.
But that's
I
what
thought
you
it
mean,
prudent,
though.
Given your conduct to date. and
That's
your
what you mean, that
insistence
she
on
keeps
bringing
arguing
up
back.
Issues that have no bearing in this case.
This is a new
that are
day, though, Your
relevant.
Honor.
It's a new
This is
day.
a whole new day.
that it was prudent on my part to give you some guidance before
It's a new
you
day.
potentially do that in front of the jury. But
Okay,
you're right,
but-
I will wait and see.
Your Honor, it's
But I
still,
need to get going.
it's still
and I'm going to,
unconstitutional for you to
sir.
tell
So
me that
you
I don't
need to
have
be
the First
quiet.
Amendment right that I preserve. or
That's
the
not
Sixth Amendment right
unconstitutional.
that I
I'm going to have
preserve.
the jury
not how
brought
that
out.
works.
I expect that you will be
Ma'am?
respectful, courteous, and quiet.
Or I'll be
And
held in
when the
contempt.
door opens,
Or I'll be held in
if you
contempt.
insist on making remarks,
Eat.
then I will excuse everyone from this courtroom and you will be removed.
Why
because
put the
you will
jury through
forfeit the
that? You
right to
know
be
what's gonna
present for being
happen.
disruptive.
Under
Your
the lawful
Honor.
law.
That
Because
is
I
my
haven't been
ruling.
dishonorable to the court.
You know what's gonna
Madam
happen.
Clerk, please have the jury brought out.
Well, take
Good
me
luck.
to the next courtroom then. Take me to the next courtroom.
Yep.
Because you're not
Yep.
going to override my constitutional rights just because you feel like you can.
I'm gonna
and-
say
and
what
you
the
don't
fuck I
have no
want.
lawful law to do that.
The lawful law
We
is the
all
law.
have constitutional rights, and you cannot trample
Mr.
on
Brooks,
those.
what you are raising are essentially issues that you can raise on appeal.
No, I'm raising them now because they need to be on the record now.
No,
Because you won't allow me to
they
make
don't.
the record as I've let you do. You've even went so far as to mute
Mr.
me.
Brooks,
Don't bring
But
that
you
jury
can't
out.
even,
Coming
there's no
out.
lawful law to say that you
I'm
can even
advising
mute
you
me.
to be quiet. They're coming
Your Honor,
out.
does Illinois versus Alice say that you can utilize the mute button?
Yeah,
It does
that's
not.
gagging you.
Mr. Brooks,
So
when
you're-
the door
you're-
opens, I expect you to be quiet. You will forfeit.
and I
Your
expect
Honor,
you
your
to
expectations
I expect
are
you to answer
misplaced.
questions as a public servant, Your Honor. You're a public servant.
jury's coming
You're
in.
supposed to serve the people.
All right.
Take me to the next courtroom. Please, take me to the next courtroom. Hold me in contempt. Hold me in contempt. Hold me in contempt.
You know this is what he's gonna
Oh,
do.
you
The
do.
judge looks so annoyed. Like, I'm so shocked, Your Honor. You
I
can't
have
be shocked.
constitutional rights that are being
You can't
trampled
be
on,
shocked.
And you're coming up with ways to make a lawful law where it doesn't say. in
How are you
Illinois
surprised
versus
he's doing
Allen
this?
Anywhere about utilizing the
Records
mute button.
reflect that the jury bailiff is in here. However, the jury is still in the hallway. I'm going to give Mr. Brooks one more opportunity
Why?
to be respectful of the court's rulings,
Your
whether
Honor,
he
I
agrees
haven't-
with them
I
or
haven't
not.
dishonored the court.
I have gummy bears.
I'm merely exercising my rights. Under
To
the
say whatever the
Constitution,
fuck I
under
want.
the
That's
First
not how that
Amendment,
works.
Under the Sixth
Mr.
Amendment.
Brooks,
She
your
knew how this
rights
was gonna
do
go.
not include you disrupting these proceedings
I'm not-
the way
I'm
that
not
you have through
disrupting
the
the
course of
proceedings.
30 minutes,
proceedings.
the jury's
You
not
don't
in the
have to
room
honor
yet.
my constitutional
30
rights
minutes
in
is
so
winning
many
right
words.
now.
You're using a mute button
Mr.
that's
Brooks,
not
the
even in your
jury is
decision.
outside this
Oh, did we
door.
end the poll?
They're not brought in
I'm
yet.
informed.
Let's
that-
end the poll.
I'm
asking
informed
you
that the jury
To
is
be
outside the
respectful of
door.
their time.
They're not in the courtroom.
I'm
They're not
asking you to
present.
be respectful of the court's ruling.
They're
whether
standing
you agree with
outside.
it
These are
or
issues
not.
that need to be resolved
just
before
stress
they're
eating.
present.
Mr. Brooks, they will not be resolved to your satisfaction.
It's not
Ever.
about my satisfaction.
record
It's
has
about the
been made.
Constitution. It's about what's right.
Are you going to
Are you going to
follow the
answer
court's
questions as a public
ruling?
servant on why you're making
I
up
can't
laws that
get
are not
no.
in the Illinois versus Allen and never utilized the mute button? It never
Go back
said
to the
anything
jury.
about a mute button.
She just sent the jury
It's
back to the
clear
jury room.
that
No
you have
shit.
Absolutely no intention
No
of following
shit.
the simple rules of decorum and courtesy. He has repeatedly talked over me. He's
27% of you said
repeatedly
45
interrupted,
minutes with
even though I made rulings.
15,000
He's
votes.
Not respectful of the fact that I made a ruling,
Let's see
even
who
though he
wins.
disagrees with it.
How can you?
I
We're now
attempted
over
to
30
bring the
minutes.
jury out,
How can you
and
utilize a
he
mute button?
continued to talk.
That's
So, Mr. Brooks, you
Your
have
Honor.
forfeited
I
your
need a
right to
bigger
be
box of
present
gummy
for the
bears.
state's
Oh, wait.
is that
closing
not?
I bought two.
argument.
Your Honor,
You will
can
be
you answer
taken
this
to the
question?
courtroom next
As a
door, and I
public
will
servant-
invite you
Yeet.
back over when it's time for
You
your
can't
closing
invite me
arguments.
back over. I can reclaim my right.
I can
So how can
reclaim
you
it.
invite me
All
to
right,
do
the courtroom
anything?
is
I'm
to
in
be
charge
cleared
now,
so that
Phasma.
Mr. Brooks can be removed to the next courtroom.
Ah.
And I'll make appropriate findings when he's in the other
Yeah,
courtroom, when I
and
can
you'll
do so
mute me, which you
without
can't lawfully do.
interruption.
You can't lawfully mute me.
Oh,
So
the
now
things she
now
can
you're
do.
trampling over my First Amendment right.
He's still going. Jesus. I'm so stressed out. This is causing me so much anxiety. It's so confrontational. It's so uncomfortable. It's so circular. And the judge keeps trying to engage with him. And she's like, I will give you one more opportunity. And he's like, I'm going to fuck that up. And she's like, I will give you one more opportunity. And she's like, I will fuck that up. He doesn't care. So now we're at 32 minutes past when the jury was supposed to come in. He is being taken to another courtroom, and we will see. I think those of you in the 45-minute to an hour range might work, but this is exactly what he was going to do. I will inform them of the lawful law. First of all, what is that even? I will inform them of their rights. He's telling her that what he's going to argue is jury nullification. The Constitution says that the laws of Wisconsin are illegal. So you can't convict me under this law that's not lawful law. That's what he's trying to get at. But she knew this was going to happen. Why have the clerk bring the jury down? Why make them walk the hallway? This poor jury is getting their steps in. I mean, most juries just have to sit all day long. Like the Depp Heard jury didn't get to move very much at all. This jury is getting their steps in. They're getting their blood moving. They don't need a comfort break. They've moved. They've stood up. They're in the jury room 90% of the time. That's an exaggeration. It's hyperbole. For those of you that are new here, go ahead and pop a 1 in the chat and let the law nerds welcome you. If you're just finding me, I'm Emily D. Baker. I've been a lawyer almost 17 years. I'm a former prosecutor. Woo! Closing argument, drinking game, anyone. I cannot advise that. I think it is against the health and safety of all of you. But if the chat wants to organize something on their own, I'm not going to stop you. Just remember to include all of our friends that are sober. Get your bleep button ready. It's ready.
I can't with the stress of this arguing.
I can't, as a DA, that type of arguing always made my head hurt, and I will not engage with that with my kiddos. I cannot, that causes me so much anxiety. I cannot. Chase, thank you so much for the kind statements. We've got to peek back in on what's going on with the H3 Ryan Kavanaugh case soon. Allie said, I'm beyond livid. It's embarrassing. Take control. This judge is trying. What would you do in this instance? I don't know. I think part of the problem, and it is so much easier. I just want to make it very clear. It is so much easier for me to sit here in my stretchy pants with my snacky snacks and give commentary than it is to be this judge on the bench after 16 days of this nonsense, living in a community where this atrocity happened. It is much, much easier for me to be here than this judge doing this. This judge has a very difficult job. And though I get frustrated, I cannot step into those shoes because I do not know what that is like for her. I think establishing the ground rules stronger earlier on may have been beneficial to this judge. So by the time we got here, he just knew what it was. She is trying to help him help himself. And that is what she has done this case consistently. It is very frustrating to watch. It's got to be frustrating for the DAs. It is, the jury's not seeing most of this, but it's got to be so frustrating. So what would I do? I would have tried to establish firmer boundaries at the beginning. Truly. And I would have been like, but also this judge doesn't want these witnesses and victims to have to testify again. The coroner cried during their testimony. This is a traumatic case. It's a tremendously sad case of a mass killing. It's a very hard case. The judge does not want to put these people through this again and wants to protect the defendant's rights so that doesn't happen. So what would I do? I would have tried to establish firmer boundaries earlier on, and I wouldn't let him argue back. I mean, you see kind of my reaction is the record is clear. That request is denied. We're moving on. The record is clear. That request is denied. It sounds like you will intentionally disregard my ruling. If you do so, you will forfeit your right to a closing argument, and I will put you where I can mute you so that the prosecution doesn't have to ask for a mistrial because they don't want to do that either. So they're sending him back into the penalty box. Our stress 100 times less than them present. True. He is just on a loop. Can we please get a visit from Lawyer Cat? Oh, not set up on the computer today. I'm trying to keep the computer from crashing again. Lawful law equals buttery butter. Lawful law equals, I don't know. It's now, we've got to figure out our definition of lawful law. Lawful law and exhibities have been given to us from this trial. A grumpy was an exhibitee in the Johnny Depp trial. I think that's an appropriate sentence. These are going in the Law Nerd Dictionary. I've got Black's Law Dictionary here to the side of me, but the Law Nerd Dictionary. Need to take the dog for a walk, but I can't look away. Put me in your pocket. What is, I don't want to see any of this. Is that what you're saying? We can't even lip read because he's got that mask on. EDB, this is the best coverage. I'm giggling, yelling, and all the things right with you. Thank you, Aurelia. That's tremendously kind. I really do try to balance my frustration with the severity of this. Why do judges not use their gavel? I have no idea. I love a gavel. Elaine, how many of you are missing Elaine right now? Just put a 1 in the chat. How many of you are missing Elaine right now. Some of you are. I know some of you are. And it's okay to be like, damn it. At least that didn't feel so traumatic. Like Elaine was handled by the judge. She calmed down. She was kind of funny. She was worth taking some pot shots at with the, I'm trying, Your Honor. This is someone who assaulted or is accused of assaulting, not been convicted, accused of assaulting their ex, and then cross-examined them. Cross-examined the victims he's accused of running into with his car after others had been killed. This is so much more serious that it just makes it deeply frustrating and sad. It's much more infuriating than Elaine that was a little annoying but kind of funny. There's nothing funny. It's just too frustrating. Brooks mistakes kindness for weakness. Clearly. How is she going to control his closing? She's not. There's no way she's going to. There's no way. Emily, I think she's trying to give him a shot since if she's going to have to yeet his closing. I think so too. And he said over and over and over that he's not going to adhere to her rulings. So she knows, and she's going to have to make an extensive record. We're going to get the prosecution's closing. It's kind of better that he's not in the courtroom because I'm sure he's going to yell, you don't know what it is. We saw that when the prosecution made a record about Brooks's previous record. Brooks is a registered sex offender and some other things that are on his record. And the prosecution was making a record. He's like, if you know so much, then he started yelling at the prosecution. So it's better that he's over here. It's better that he doesn't have to deal with it because he probably will try to argue back with the prosecution. So this is probably best for everyone. Question is, are there no sidebars during the trial because he's his own lawyer? Correct. The jury has to be removed. He can't approach the bench. I don't even know if the bailiffs would never allow that. He needs to stay behind the table for courtroom security. So no, there's no approaching the bench. My head is spinning, fam, just took an etc. This kind of yelling, this kind of arguing is not great. I can't remember how I got here, but I love it. That's how I feel on TikTok most days. I've wandered down a side road on TikTok and I can't get back out, and it's great. And now I've started seeing like D&D recreations of stuff. I'm like, how did I end up on like D&D TikTok? How did I get here? I don't know. You go on Lawyers and Dragons over on Hoag's Law channel once. You play D&D once. You do a couple perception checks and all of a sudden TikTok's like, oh, we know what you're up to. TikTok knows way too much. So as we get back into it, I'm going to be answering questions. For all of you that are new here, we do have some chat rules. The mods will remind you of them. It is very, very hard with a defendant like this to maintain our rules of civility and decorum, but that's what we do. No name calling, no mental health diagnosing, no wishing ill. We are here to have a conversation about the fuckery that is unfolding in court. Normally we talk about the facts. Today it's just all fuckery. This is just all courtroom fuckery. So with that, we are in it. But I appreciate you. The mods will always remember or remind you because we really do keep our community a place to have a conversation. And that's why our Nightbot reminds you to taste your words before you spit them out, because that is how we do things over here. And I appreciate it. Those are my rules because that's the corner of the internet I like to be on, where, we can have conversations without aiming us at people. Okay, let's get through some more of these chats. Colleen, I hope you're not going to need therapy after this case. It's okay to step away if you need to step away.
Court's made an evidentiary ruling that will require the preservation of the record by making an offer of proof. This court has been attempting, frankly, all day to get through the reading of jury instructions, to get to the point where the parties make their closing arguments, and ultimately to put this case in the jury's hands. It has been challenging. It has been met by resistance from Mr. Brooks. I would once again
the jury is still out of the room.
As being stubbornly defiant. Although at times he may wait for me to make my ruling, he continues to not respect the fact that a ruling has been made, and he wants to argue and re-argue and re-argue points that this court has already gone over. And in an effort to simply put him on notice regarding his behavior, given the history of this case, the court was attempting
gonna switch
to set
seats.
some parameters regarding closing arguments so that they are focused, so that they are proper, and that they follow the law. That was met with a considerable amount of resistance and repeated statements by Mr. Brooks that he has First Amendment rights, Sixth Amendment rights, 14th Amendment
First
rights.
Amendment rights.
He has all of those rights. That is not in dispute. But those rights do not come in a vacuum when we are in a court proceeding.
All right.
The rules of evidence, the rules of procedure.
that's so much
the
better.
rules of
Thank you,
courtesy
chat.
and decorum.
Thank
all
you.
apply.
All right.
And this case has demonstrated
Yeah, law and
that
crime.
a stubbornly defiant
I don't
defendant
use their feed.
can forfeit even important constitutional rights
peanut butter
by
whiskey.
conduct. That
Peanut butter
includes the
cup
right
whiskey is
to be
even better.
present.
I
It
love
included
whiskey.
the right to present further witnesses.
Now let me gain up
testimony,
this a little bit
and it
louder.
included the right of the
and we'll be
defendant
set.
to testify on his own behalf. I hope that I do not have to go through a decision that forfeits his right.
I know you don't
or that
wanna do
makes
it.
a finding that he's forfeited his right to make
There we
a
go.
closing argument. I will
is so much
certainly
better.
wait and see how that goes.
Oh,
I
yeah,
would
you're gonna
note
have to do that.
he was very respectful when
In
he
opening.
did his opening
was.
statement.
He was good in opening.
It was clear. He made a variety of points.
He argued intent.
He
It was so much
did
better.
so
It was
in a way
good.
that I would say was very
Respectful?
conscientious of
Yes,
people's time.
it was.
It was cogent.
Yes.
It was concise.
All of that.
It was probably about 35 minutes. I may be off a little bit, but that's what my memory
was a good opening.
is. It wasn't overly lengthy. I would hope
It was
that
appropriate.
he follows some of those same things here when he does his closing argument. But he has been removed from this courtroom because
much
of
better.
his stubborn defiance and disrespect of this court, of courtesy and decorum. And what I truly believe is an effort on his part to continue to delay and lengthen these proceedings. I've said it before, I'll state it again.
Jessica, this is
It is
rage.
essential to the proper administration
my
of
face
criminal
being red
justice
'cause I was
that
angry.
dignity, order, and decorum be the hallmarks of all
My
court
neck is red too.
proceedings in our country.
I'm very fair, and I
The flagrant disregard in
blush
the courtroom of elementary
and flush.
standards of proper conduct should not and cannot be tolerated. And trial courts and trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one
She's
formula
trying to meet
for
the
maintaining
circumstances
the
here.
appropriate courtroom atmosphere
Oh,
will be
we're over
best in
46
all
minutes.
situations. They noted 3 constitutionally permissible ways to handle such a
Oh, she's
stubbornly
setting the law
defiant
again.
defendant. But they also indicated that no one formula for maintaining the appropriate court atmosphere will be best in all situations.
another one that's called
I've
embarrassment.
noted this before. This is a case from 1970. The technology
there's a
that
color
we
when I'm
now
talking about
have in
stacks.
this
The
brand
stacks
new
color is a little
courtroom was
different than
not
embarrassment and
available
rage.
Then
different kind of flush.
I have the ability
That's
to
a deep
have
Blonard
Mr. Brooks
inside joke.
appear from the
The
other
chat will
courtroom
explain.
by way of audio and visual means.
Back to
We
defiant
can see
face.
him, he can see us. I've confirmed prior to calling the case that the audio was working, that the video is working. The one camera, there's 4 cameras in my
Team 1
courtroom,
hour.
there's 4 cameras in his courtroom. However, it is set to 1 camera since he's the only individual there. Other than the bailiffs, but I'm talking about as a party to the litigation. So
Team 1 hour entered the chat with a lot of confidence right now.
courtroom- The cameras
Oh,
in
he's
my
counting the
courtroom
cameras.
include one that would normally be on the witness stand that has been zoomed out so as to capture the large majority of the jury box. I even adjusted the camera that's on the state's table.
Debbie, I
so
think the
that,
public defenders are probably
the
sad.
exhibit that's currently up to the
They had their
my
case
left or
prepared,
right, Attorney
and they're just
Opper
watching
is,
someone
viewable,
throw away their rights, or they're mad. They're
in
just like,
the
this is
camera
appalling.
angle. And
Team 1 hour
she
is
is still
all-
present within, meaning viewable within that as well. And although I've made a finding that he has forfeited his right to be present for the state's
Control.
closing argument, I'll find that the technology that I have available it is that his
about control.
appearance from the other courtroom is the functional equivalent of appearing in this courtroom and being present.
This jury's been back from
due
lunch
to
for an
the,
hour, almost.
technology that is available. I do have him on mute for the time being because I needed to make a record, and there is a very lengthy history with Mr. Brooks during this
The
case
record is
of
clear.
him talking over me and my inability to make an adequate record if I am in a constant back and forth
sounds
with
tired.
him and trying to talk over him. And so I, yes,
he
made the
can absolutely
decision
hear in that
to
courtroom.
utilize the mute function on the incoming audio. I know he disagrees with my ability to do that, but I believe it is consistent with ensuring
he's turned his back to the
dignity,
court.
order, and decorum.
Dignity, order, and decorum.
That when appropriate, he be muted.
I'm not listening to
I will
you.
advise Mr. Brooks once again that although he has lost his right to be present in this courtroom, he can reclaim the right to be present as soon as he is willing to conduct himself.
This is why he was like, "You can't order me to be present. You can- I can reclaim
inherent in
it."
the concepts of courts and judicial proceedings. That includes not interrupting the court. That includes respecting when the court renders a decision.
Put on the
by
record
way
that
of
he's
an
standing
oral
with his back to the
ruling,
court.
even if he disagrees with it. So
Sorry, we
with
just got a little
that,
feedback. That was from the court.
I will advise
Put it on the
him
record that he's
once
facing-
the jury is
put it on the
brought
record.
out, I will unmute him. I expect
I know,
that
this
he
this
will
case is making me
be
anxious, too.
Respectful of them.
People fighting
And
like that is
I
just.
expect that he will not interrupt as the court goes through the couple of final jury instructions
Not
I
if the
need to
court
go
does it right.
through,
No.
including the reading of jury instruction 160, closing arguments of the parties.
Oh, Senko, I would be
And
exhausted.
then I will turn it over to the state, but I will unmute
I would
him
be
at that
exhausted.
point. So should he have an objection, he will be able to state objection. I will be able to rule on it. And again, I expect him to honor whatever the ruling that is made. And if he does not do that, then I will utilize the mute function.
I've never
If he
seen a
doesn't
pro-per
have it,
behave
we'll
quite
make
like
sure
this in
he has
trial,
the objection
personally.
sign, and if I see that, I will unmute him to hear what it is and then make a ruling accordingly.
It's going to take quite a lot for him to lose his right, but she has to protect this
Harper.
case. He can say things that would cause a mistrial.
Could you confirm that the audio and video are working in the next courtroom? And the clerk's shaking
Oh,
his
yeah.
head on that. Thank you. I don't know if you want to do it now or at a later time, but I think we should make a record, as I will be displaying a PowerPoint during my closing argument.
Team
throughout
1
my
hour is
closing
like, make a
argument,
record
and
now.
I'm not sure how that is projected in the next room or how it affects what we see in this room.
Team 1
Your
hour
Honor,
plus is
but
like,
we
make
should
a record now,
of
just
that
do
at
it
some
now.
point.
Thank you. My
Just do it now.
understanding is Madam Clerk has the ability, so that is displayed not only here, but in the neighboring courtroom.
This is good
Um,
tech.
If you would be so kind as when you start displaying it, just make some type of record, excuse me, so that the bailiff who's over there, if it's
Knows that you're
not
putting on the PowerPoint.
being properly viewable, if it's not viewable, that we can stop and adjust
Sure.
accordingly.
Yeah, just tell the court you're starting your
Thank you.
PowerPoint.
If you would like, before the jury comes out, we could do a test.
Yes,
could you
Team
please?
1 hour plus is like,
Please.
do it, do it. All right, so they're going to do a test of their PowerPoint. We'll get to some questions and some super chats. Question: I thought everyone tried not to object or whatnot during
Madam Clerk, would you
closings.
confirm with the clerk over there.
There are
that,
times where you have
the
to protect your
PowerPoint
case,
is also viewable.
and
All right.
the
and it
judge
should
is
be
trying to.
similarly to what we see. So the
Make sure we're not there.
monitors will display the camera that Mr. Brooks is appearing, that is on Mr. Brooks on the left-hand side of the TV, and then the 4 cameras for this courtroom are on the right-hand side, but it's probably maybe a quarter to a third of the screen, and then the
This judge's
remainder of
water
the
jug is
screen
bigger than mine.
is the PowerPoint.
I have one of those,
The
but I've been using my
monitors
Starbucks
in the
Halloween
courtroom that
ones.
Mr. Brooks is in are no different than
This
what
is
they are here. He would have one at the table, but there would also be the very, very large TV monitor above the clerk over there. Well, it's smaller, and then
Wait,
the
why are
very
we
large
louder?
one over the witness
Yikes.
stand. So it would be very similar to what is here if he were present in this courtroom. And again, I know that the diagram, it's probably not the most easily
Oh,
seen
he
from a
absolutely counted
camera,
all the cameras.
but it's really
He
no
was like-
different than what I'm looking at at the moment.
Absolutely. So with closing argument objections, there's times you have to protect the record.
Asking that I make a record of that.
There are things that this
I would
defendant could
further
say that
make a
could
record
cause
that there are headphones
the
on
prosecution to be in a
table
position
Mr.
where they
Brooks
might
is
have to
currently
consider
standing. He has
asking
not
for
put
mistrial,
them
which
on,
sucks.
But they are available should he want them.
Karen Harris in the chat asked, how many Starbucks
All
cups
right,
do you
then I'm
have?
turning off the.
The limit does not exist. I
PowerPoint.
haven't
Let
counted
us know
lately.
When you need that function, and then
Too
Madam Clerk will
many?
be able to make
There-
that
too many.
viewable in both courtrooms.
Very good, thank you.
All right, with that, the jury is.
The
to be
chat
brought
can
out.
catch you up. The jury's coming out. Is it usual to have this much tech at trial? Not where I practiced, but that goes jurisdiction by jurisdiction and courts. I think during the Panini, we saw because I still can't say that word on YouTube. The courts got very good at technology. Also, some of these cameras are Court TV's cameras. They're offering the pool cameras. Thankful for Court TV for doing that. They're the ones with the pool cameras set up in the courtrooms. So courts have been doing really well with advancing their technology, especially where they can afford it. LA County, I think, is a bit behind, but LA County in their newer courthouses is better than their older courthouses because they were built with the technology in mind. So tech is becoming a much bigger
All rise
part
for the jury, please.
of court proceedings. So it really just depends. We've seen some courtrooms with great tech. Virginia during Deputy Heard had great tech, just great tech. So that varies by jurisdiction, truly. And courthouse by courthouse. The Panini, yes, the 2020 disruptor of all things. Because I can't say things. I am still actively licensed, but I am a full-time content creator. I still do some consulting, but that is a very side thing because I do this full-time and I love it.
Seated.
I get offered jobs a lot.
Ladies and gentlemen of the jury, when I read the jury instructions
55 minutes
regarding credibility,
55 minutes.
I
Team
had
1 hour
a
wins, I
prior
think.
Version of the jury instruction. Now, what I read to you in the very beginning, or at the very beginning of this case, was the most
Oh, look.
recent.
He's
I
angry.
am going to read a short paragraph,
Weird.
but also tell you that in the packet that will be sent with the jurors to the jury deliberation room, it will have the complete instruction, and it's instruction
We might get a
number
tie.
30.
We might get a
300,
tie between
excuse me.
45
And
and
this
an
is what
hour.
I want you to know about
That's fair.
credibility. In your determination of credibility, you must avoid any and all bias based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic.
They're so good.
Consider carefully the closing arguments
Mike the Dad
of the
Crosby, that's
parties,
hilarious. I'm so
but
glad.
their arguments and conclusions
Happy
and
to make the
opinions
flight easier.
are not evidence. Draw your own conclusions from the evidence and decide upon your
Price is
verdict
Right
according
rules.
to the evidence under the instructions given you by the court. With that, I will ask Attorney Opper to start with her closing argument.
There we go.
And then, clerk, if you would please turn on the PowerPoint.
Great. Turn the PowerPoint on now. Can we give Darrell a cat filter?
Hold on
I
one
don't have
second.
the tech to do that.
Mr. Brooks, do you have an objection?
Oh, jeez.
I thought I
Nothing's,
was supposed to be unmuted.
you are now.
The jury's in the room.
All right.
You're going to get muted right quick.
Attorney Opper, you may start.
Thank you, Judge. Good afternoon, everybody. It's kind of nice to stand here in the middle of the courtroom, you know, all week or the last 3 weeks. They shoved me at the end of the table because I'm the lefty in the group. It's nice to be able to look at you all and say thank you.
Lefty
Truly,
problems.
thank you. Each and every one of you, I want to express our sincere gratitude from the prosecution team, myself, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Woodshell.
Wait, what's the difference between a
There's no
deputy
one in
DA and an
this
assistant
courtroom.
DA?
That does not realize
Interesting.
the sacrifice that you've made serving your community in this very important task. You've put your lives on hold. I don't even want to hear from your bosses. Thank you.
It's very down
You've
homey
watched these
beginning.
proceedings, and you've noticed, as we sit at our prosecution table, we don't have a client at our table. But rest assured, we do represent someone.
The state
We
of
represent
Wisconsin.
the people of the state of Wisconsin. It's an entity. I can't bring it to the courtroom. People enact laws. People want to feel safe. People have representatives in Madison or Washington, D.C. that set standards, rules that we all are expected to live by. And when those rules are violated, prosecutors step in and enforce the law. Darrell Brooks does not represent anybody. He does not have a client. Darrell Brooks is the client. Darrell Brooks is the defendant. The state of Wisconsin is the plaintiff. It's really that simple. And it's consistent with any other criminal case you've ever heard about.
Thank you,
at
Veronica.
Any other time, in any other jurisdiction.
So
It
district
runs
attorney,
the same,
deputy district attorney, and then
no matter
assistant
what
district
state-
attorney are the line deputies.
State or federal.
Fair.
I'm going to ask you for your guilty vote at the end of my comments. It's up to you. I
Yep.
can't tell you to do anything. Except I'm going to say one thing to you that I wholeheartedly ask you to obey.
Attorney Hopper, I'm sorry for the interruption. Your objection, sir?
Oh, fucking hell.
Mischaracterization of who I am and the way it was said. I feel like it was talking down.
All right, your objection's noted, it's overruled.
Objection, the DA is demeaning me.
You
Really?
must not consider anything about Darrell Brooks other than his conduct in downtown Waukesha on the evening of November 21.
They're still trying to protect
2021.
him. They're protecting this case,
Nothing he's done before
and
that.
he is going to be,
Nothing he's done since that.
he is going to
Go
be,
back to that deliberation room. Please obey Judge Darrell. Confine your comments.
he has the right to
his
make
conduct
objections.
On November 21 of 21. Is he guilty of the 76 counts that he's been charged with? That and solely that should be your topic of
You're
discussion.
judging his actions, not him as a person. You're judging the acts on that day with the facts.
So,
They're going to need more
what are the
time
charges against
than an
Darrell
hour if he
Brooks?
keeps objecting.
Thank you for your patience in listening to the jury instructions. They must be read for each and every count. But sadly, they can be summarized very quickly like this.
Not
as far as
sadly.
The actual count.
Helpfully.
Counts 1 through 6 are first-degree intentional homicide while armed with a dangerous weapon. Counts 7 through 67, first-degree recklessly endangering safety while armed with a dangerous weapon. Counts 68 through 74, hit and run causing death. Counts 75 and 76, bail jumping, and count 77, battery.
That's the battery of his ex.
Mr. Brooks, what is your objection?
I have 76 charges, not 77.
False. And he said, I. Are you now acknowledging that you're Darrell Brooks?
Mischaracterization of the charges.
That is
Overruled.
correct. It is sustained. It should be count 68 through 73, I believe, and then 74 through 75, and then 76.
Thank you, Your Honor. I do apologize for my math skills.
Lawyers.
68 through 73,
Sustained.
74 and 75 are bail jumping, and 76 is battery.
Oh, because they
I
dismissed
apologize for
something
that
in there. Hey,
We're going to talk about
that
counts
goes to
1
show
through
you how much he
67 in
understands.
detail.
He
Counts
understands.
68 through 73, hit and run causing death, in my opinion, are easily summarized as this.
I think the court might give him a little room if
never
he
stops.
does this. He's had a few sustained.
Never.
You know, he's not, he's
Bail jumping, he was out
he's
on bail.
very competent.
2 files in Milwaukee County facing felony charges there. He was ordered to not commit any further crimes. If you believe he was involved in any of the conduct charging counts 1 through 67, you should find him guilty of bail jumping. Battery, that relates to the split lip and black eye suffered by Erica Peterson. We told the story kind of backwards. We started with the battery for background.
That's not backwards. That's what happened first in time in the day. The battery
First-degree
happened first,
intentional homicide.
and then the murders.
You've seen this in our opening statement. You've heard it from Judge Darrell.
Are they going to play the video?
Did Darrell Brooks cause the death of the victim, a victim? Did he act with intent to kill, meaning either the mental purpose to take the life of another or was aware that his conduct was practically certain to cause the death of another human being? Count 1, Ginny Sorensen. Count 2, Lee Owen.
If they have the PowerPoint up, I'd like to see it.
Count 3,
I imagine they're showing
Tamara
pictures
Durand.
of
Well, I
the
got-
deceased when they were alive.
Count 4, Jane Kulik.
That's what I would do.
Count 5, Bill Hospital.
I think she's clicking. So showing the
Count
faces
6,
of the different
Jackson
victims
Sparks.
that were killed.
Those are the individuals who lost their lives because of the conduct of Darrell Brooks. From there, we go to reckless endangering safety. What is that? In this case, it means that through his reckless driving, he endangered the safety of other people. And he did so demonstrating utter disregard for human life. Now, behind me is State's Exhibit 15. It's also on the PowerPoint. If you choose, you may have this chart with you in the deliberation room to help you walk through each of these counts if you find it helpful. It's up to you. If you don't want it, you don't have to have it. But it will be available for you if you ask for it. And it'll take you
The
as
timeline
we
of what
did
happened.
in our presentation of the case.
It's a very good
right
exhibit
down Main
to summarize
Street
everything.
and address all the counts that
There's
were
a
involved.
there's a joke
All
about it will
counts
take
that
you
were
right down
charged.
Main Street that we will make later when not in such a sad
To
context.
prove reckless endangering safety, and I'm just going to go back one slide, nowhere do you see there that we have to prove any degree of injury to anyone.
Yes,
Never
each
once
person
did
who
Judge
passed
Darrell
is a
instruct
separate
you that
count.
somebody has to be physically injured.
I'll talk about that in a
Now,
minute.
Detective Casey told you that was the standard we used in deciding of all these hundreds of thousands of people who is included in these charges. And a decision was made by the prosecution team to include people who were physically injured to be efficient in our prosecution. And so everybody up and down the street, I would argue, had their safety endangered that day. I didn't
Facts.
charge 5,000 counts. We selected 61 counts of people that we can identify by name in Exhibit 15
That were in the street.
that were injured by the conduct of Mr. Brooks.
He endangered
Those are the
everyone at the
people in
parade.
green,
That's a very
people
fair
in
argument
red
about
are the
restraint.
fatalities. And we presented this case to you in much the same fashion that is presented here on Exhibit 15 as to how the injuries occurred
It's a good
going down
exhibit.
that street. So we are absolutely held to our burden of proof and the elements for each offense that Judge Darrell instructed you on, but we are not required to prove any injury to anybody.
Rob, I
Question is,
think
was their safety endangered?
Yes.
By his reckless conduct?
I
his
think
reckless
if he
driving?
does a closing, we get to it today. Whether he gets to do a closing.
Now, some of the groups, it's pretty easy. They walked in a formation, and you can get a photograph or a diagram, and you can kind of see
Like the
Pretty
dancing
easily.
grannies.
who was located where, right? And you can think back to the videos that you've seen for each of these groups and remember, and you'll see them again, the path of the vehicle as it went through each of these groups. This is South Band, of course. All of these names that are being displayed on the PowerPoint Exhibit 21 are on Exhibit 15 in green for Waukesha South Band. Pretty much the whole left half of the formation was
The whole
endangered
band.
by the safety of Darrell Brooks driving up the side of that band. The extreme dance team, it's a little difficult to read, but
There are
again,
so many people
this chart
injured.
was marked as an exhibit.
We couldn't
It's
get all of their
exhibit
names on
number
the chart.
33. If you want it, you can have it in the jury room.
That.
The names on this chart will
That.
match the names for the extreme dance team on State's Exhibit 15. All of the girls that were struck and injured as they marched with the extreme dance team, plus some people on the back that were handing out candy or serving in support roles.
Our community
as
does Christmas
the,
parades
unit
just
made
like
its way
this.
down the street. The dancing grannies,
Makes me so
State's
sad.
Exhibit 54, the formation that they marched in, who was located where, and your recollection of how that SUV zigzagged through that group. And you can just see the names and match it up to who was injured and killed versus who wasn't.
This is absolutely an emotional closing. Absolutely. I don't know how it
Now,
couldn't be.
One of the big things in this case
Your
has
job as a
always
prosecutor
been,
to do your best not to
why did this happen?
pile on
What was he
emotion,
thinking?
but you're
Why
still
did he do
human.
this?
And when you lose
Again,
your
those are
emotion as a
things I don't
prosecutor, it is
necessarily have to
probably a
prove
day to
you.
stop being in court.
His intent, I do have to prove, and I submit without any doubt.
Years of
There's
practice.
overwhelming evidence that this was an intentional act by Darrell Brooks and an act of utter disregard for human life. I say that for these reasons, folks. Number one, first
They're
and
just not
foremost,
switching back and forth. They switched back and forth earlier.
just stop driving.
That's it. Just stop driving.
That's it.
That's it.
It's really that simple.
Yep, sure is.
Not one person had to be hurt that day if he would have just
Stopped.
stopped driving.
Excuse me, Attorney Opera, your objection, sir?
Good. Give her a second to breathe.
You specifically, I'm sorry, can I be heard?
Your objection, sir?
I didn't know if I was on mute.
Your
or not.
objection?
You specifically said in your jury instructions that intent cannot be, you can't look into someone's mind, I think is what it says, to find intent. So how can
Oh,
that
look who
be
understands now.
characterized as someone knowing for sure intent or not knowing for sure intent?
She's allowed to
You're
argue.
making an argument, you'll have an opportunity to do that later. Your objection's noted, it's overruled.
And
The
overruled.
state may continue.
I apologize.
Oh,
We showed you at the very beginning, remember our first witness was Sergeant Warner, the man who was the incident
he
commander for the
apologized to
parade.
the
We put up another
court.
map. I think it's
He
State's
wants to be
Exhibit
allowed to
1.
close.
You can have that if you want it. Shows all
Huh.
the positions of all the police officers and the
Huh.
reserve officers, the barricades, the squad cars. How do I know it was intentional?
That was,
Because even Darrell Brooks told Detective Carpenter,
it shows
I
you.
could tell something was going on downtown. No reasonable person would
It,
drive
it
upon
shows you
this area,
how intentional his behavior's
see the
been.
squads with their red and blues on, see the officers in the street with their bright yellow vests, see all the people milling around, see the floats lining up and the participants getting ready, and not know to drive safely, slowly, and obey officers. The barricades help us prove it was intentional. The police presence
Going through the
help us
barricades.
prove it's intentional. The parade participants help us prove it's intentional.
The fact that he didn't
and the
stop after he
parade
hit
spectators
somebody
help us prove
show you it's
intentional.
intentional.
Excuse me, Attorney Opera, your objection, sir?
He's just trying to break up a flow.
Speculation as to what the alleged defendant said.
This is
he saw.
closing arguments, sir.
Your objection's noted, it's overruled. This
That
is closing
objection does
arguments,
not
the
apply.
evidentiary phase.
Speculation's a
Go
big
ahead,
part of it.
Your
Ooh,
Honor.
the
How
thunder
can
rolls around
speculation
here.
be made to what was saw? Is
Ask
that
your
what
lawyer,
you're
sir.
saying?
It's overruled. Continue, Attorney Opera.
Ask your
Honking
lawyer.
the horn. Quite interesting that Mr. Brooks asked so many witnesses if they heard the horn honking.
Yes, he did.
Some of them said they did at the beginning of the parade. Yeah, I heard a horn honk. Most of them said they didn't. The horn honking cuts both ways, folks. If he's honking his horn, that means he can see something's in front of him. That means he knows there's an object in the road. You can rely on your common experience in your affairs of everyday life. If you see something in the road and you want to alert the other person to your presence, you will honk. But you do not have the green light to then just keep going if they don't move. He knew they were there. Intent.
She's doing a good job arguing intent and making it easy
I
and
skipped
accessible.
one, Sorry.
She's not getting stuck in
Going
the
back to my
weeds of the law.
Number 15.
It's a very human
I failed to
closing,
include the
which I always prefer.
Catholic community.
I always prefer
That's
very
just one of
human,
the
not
photographs
slick.
Showing the people that will
That's
match
what I
up to
like.
Exhibit 15 from the Catholic community of Waukesha. There's a lot of photographs identifying the people that were marching with that group.
He kept driving. I've had jurors cry during closing.
The
It's hard, especially in a case
parade
like this.
started. This is the starting point, or at least near the beginning, right? This is the area. We showed some videos of the groups passing by in this area. We heard testimony from 4 different police officers
And she's not thrown off by the
standing
objections
in 4
at all.
different
She just
spots
pauses and then
near here,
continues.
telling of their 4 different efforts to stop him. Intentional.
Yeah,
Sergeant Wander's back here.
that's a good point.
Testified that this red SUV blew by me. I waved both arms over my head. I'm in a police uniform. I have an unmarked squad, but I have my red and blues on. And he blew past me. He gets down here to the corner where Detective Casey is standing. Detective Casey runs out into the street, gets close enough to put his hand on the hood of the car.
We love a demonstration.
He keeps going. He comes down, turns onto Main Street, gets in this area of East Avenue to the south and Buckley Street to the north. This is where he encounters Officer Schneider and Officer Buttrin. They each make a separate effort.
These
to stop
prosecutors
him,
have been
And he
great.
keeps going. 4 police officers.
Very
It's
mindful,
intentional.
very restrained, very conscientious.
He had plenty of opportunity to just stop anywhere along the way. One of the officers testified to it. I think it was Officer Schneider. If this was an accident and he mistakenly wandered onto the parade route after passing all this, and he mistakenly wandered onto the parade route at any point, all he had to do was stop. They could have paused the parade. They could have moved the barricades
He
and
could have caught back
escorted
off
him out.
instead of blowing past police officers and speeding up.
It was intentional. He went on for 4 blocks. 4 blocks. It was intentional. He reached speeds of approximately 30 miles an hour. That's intentional. He plowed through 68 different people. 68.
Her pacing, good.
How can you hit 1 and keep going?
Yes.
How can you hit 2 and keep going? How can you
Yes.
hit 3 and keep going?
Keep going.
Phasing it
4,
back. He
5,
kept going
6.
until he got to the end, and there was no more bodies to hit. It's
Eight.
intentional.
8-bit queen, I'm sorry. His objection is he doesn't like what she's saying.
Mischaracterization of the evidence.
No, it's not.
Noted, overruled.
His conduct when he left the parade route, we'll get into this.
He fled.
His flight, his hiding, his panic, his desperation
He knew he was wrong.
to run. get the hell out of town as fast as he could before the cops came. That shows his intent. His interview with Detective Carpenter, we spent several hours playing you snippets of that interview. How telling was that? Never once did he say any of these things. Never once did he say, like he told you in his opening statement, it wasn't an accident, it wasn't intentional. Never said that to Detective Carpenter. No, he came up with some convoluted story about, I got a ride out here from a buddy in a tan Kia, and then I left to go meet Erica, and we got into a fight, and then I went back, and the other guy got into a fight, and he was leaving, so I took off on foot. Absolutely nonsensical story. Does not match up with the known evidence in this case.
And
Overruled.
all the known evidence and all of the witnesses.
He never
I didn't
stopped.
even state the objection.
It's overruled. There's nothing
Closing
objectionable.
argument.
It's overruled. Keep going.
She may continue.
I'm gonna play.
You
this
don't get to
slide,
just
which
talk.
Is a snippet from State's Exhibit number 53.
There's nothing objectionable.
Go ahead and play with sound, please.
I hope they'll shift the court cameras to show what they're showing. I don't know if they will. And if they do, YouTube, don't strike the video.
That was just a snippet that I selected because I thought it really captured the environment that so many witnesses tried to explain to you, right? It's a Christmas parade. People are there with their families, their little kids, their grandkids, their neighbors, their friends, strangers, standing next to strangers. That's what's going on Main Street. While that's going on Main Street, this is going on.
Oh,
Remember
dear.
this? This is the gas station on the corner of Barstow and North Street. While the units are marching down Main Street, entertaining the crowd,
A lot of the
Darrell
people there are
Brooks is
victims, families, and victims.
driving recklessly. He's enraged, and he's arguing with Erica Patterson.
It's a good closing.
Why is this important? This is important because before he even gets to the parade route, this is how he's driving. He drives the wrong way down North Street and then acts like it's everybody else's fault in the world.
Your objection is noted. It's overruled. You may continue.
This is
Attorney
closing argument, sir.
When he finally pulls into the gas station, he rolls down his window and yells at the driver who's properly stopped at the stoplight that it's somehow that guy's fault that Darrell Brooks is trying to drive the wrong way down North Street. And from there, the rage continues. We get to this point, State's Exhibit number 3. Please play.
I'm glad they're showing the clips. We saw this clip in the testimony of the defense, too. The prosecution showed it, and then with witness Kirby, they showed it.
The video is playing. You can see the
This is all
pushing match
before he went
between Darrell Brooks, Corey
to the parade
Runkle,
route.
Erica Patterson, and Nick Kirby. Watch this. He turns to get in the car, flips up his hood, and goes and gets in the passenger seat. I'm
Sir,
sorry,
your
driver's seat.
objection?
How long we gonna mischaracterize testimony?
Sir's argument, I've heard nothing improper. Your objection's noted. It's overruled. You may
You're going to have a
continue,
chance to
Attorney
argue
Allen.
yourself.
Thank you.
Sit there and be quiet.
They need to know they can nullify.
That's it.
Oh, fucking hell.
He drives off onto the parade route. From this moment, right here on Exhibit 15, you're watching it. He's enraged. He's angry. flips up that hood, and he zooms past Sergeant Warner,
Did you say Yooms
past Officer Casey,
or Zooms?
onto the parade route. Now, there's no doubt, for the first 2 blocks, he does not strike anyone.
Oh, he just said
And
nullify.
as we've discussed,
The judge is
some
gonna yell
even
at him
said
later.
He was driving at a reasonable speed initially. By the time he gets past Officer Buttrin and Officer Schneider in this area here,
I agree. Nick Kirby's interview was very sad.
East Avenue, past East
It's
Avenue,
not his fault.
and clearly once he gets past Barstow, that's where it starts, right? That's where it starts. Nicole White, our first victim.
Thank you, chat, for lifting the mood a
walking
little
with
bit.
Remax and hot air
Closing's
balloon.
heavy.
Knocks her over, keeps going, runs up and
very
over
dark over
the
here.
backs of Waukesha South Band. Hits the green children spectating on the sidewalk. Keeps going. Runs over Kelly Grabo and her daughter Adelia, walking with Burris Logistics. Keeps going.
Makes me so sad.
Plows through the entire extreme dance team just before the 5 points. Keeps going. Hits Deborah Ramirez and her son Isaac spectating on the south side of the street. Keeps going. Clears the 5 points area.
We have a 5 points area too.
Hits Jane Kulik.
It's got great Pokemon.
Square on. Causing her to go up on the hood of the car. And then fall off and drives over her body. He doesn't stop. He keeps going. Runs through the kids over by the steaming cup. We heard the parents testify about little Brinley and Kelsey and Owen that were standing there outside the steaming cup. They were struck by the red SUV driven by Darrell Brooks. Keeps going. Plows through the grannies in that zigzag fashion, striking most of them, injuring them,
And killing them.
keeps going. Gets
She's allowed to
down
be
here
mad.
to the end and goes through the Catholic community. The witness, remember Holly Berg, she testified about that mobile gas station incident. She said she was standing down
Does the
there in this
ominous
area.
weather
She
feels
said,
appropriate.
I saw 15 to 20 people fly in the air. They look like bowling pins. And when you saw the video, she's absolutely right.
It's horrible testimony.
Terrible description when you think these are human beings, but
Horrific.
that's exactly what it looked like. When does the intent exist? Doesn't have to be even for a second.
It's a
I'm not
great way to
telling you who
approach
set out
intent.
that morning to cause this carnage.
But
when
once he
became
crossed the
enraged
barriers-
back here, he didn't give a damn
Yeah.
who or what was in his way.
Yeah. Once he crosses the barrier,
He
there's the intent.
intentionally went on. I'll show you.
Once-
Motive. I don't know why he did this. Folks, I don't know why. Other than the rage. He's right. You cannot read minds. Neither can I. But the law doesn't require you to.
You can look at the
law
actions.
gives you a way to
Good
reach a
use of jury
conclusion as to
instructions.
What is somebody thinking? And it's right here.
Good use of jury
Decide it
instructions.
based on his acts, words, and statements, and from all of the facts and circumstances. I've already been through many of them. I want to show you what I mean. Look at this. Was there room for him to get out? This is way back at the beginning. This is Officer Buttrin's squad video. Way back at the beginning. That's Buckley Street here.
If he
that you're
said,
looking at.
I got the wrong
Look at
way, they
those
would have just
barricades.
moved
Look at the
those.
Sparse crowd.
They would have just moved it for him and let him
And
out
there's
over
Officer
there.
Schneider in her yellow fluorescent vest on the left side of the picture,
Would've
about to run
absolutely
into
just
the
left him
street
out
and
there.
stop him. Intent. I'm going to play this
There's going to be
video
hard
for you
video in
because,
this.
folks, for me, this is where it becomes crystal clear.
Y'all just
You watch
heads up
this video, the first thing you're gonna see if you direct your attention
I
to
don't
the
know
left side of the screen.
what
is
she's
you're
gonna
going
play.
to see him hit Nicole White.
Now we do.
Knock her to the ground and keep going. Now,
So
if that
they're
was the
going to
end
show
of the
footage
story,
of this.
you may sit here and say, Madam DA, I don't know
Viewer
how you
discretion
can
is
prove
advised.
intent from that. Maybe it was an accident. Maybe he didn't mean to do it. But watch what happens in this video after he knocks Nicole White down and tell me this does not prove
I'll let you
intent.
guys know when the video is done playing.
Please play.
They might not show this. Court TV might choose not to show this because they don't want to get court. It looks like they are intentionally choosing not to show the video. The court TV cameras are what's choosing kind of how things are done. So they are intentionally choosing not to show the video. You can hear it, which is almost eerier. And I think that that's a fair choice. And I appreciate that choice. So.
Keep watching the left side of your screen.
So there we go. Not instructed not to show it, which is fair. I have not watched all of this trial because I didn't want to see these videos, and I'm glad they're not showing it. But these are you can see the reactions and you can hear it.
That's intent, folks. No reasonable person is going to come across a group of teenagers playing band instruments, drive over them, and keep going. That's a still shot of the same thing. That's intent.
I'm sorry to interrupt your objection, sir.
How can you tell the jury what they supposed to think?
It's argument.
Your objection's noted, it's overruled. You may
I would
continue.
argue that it's,
Attorney Wilbur.
I would say
It's
that
argument.
improper.
No, you can shut the fuck right up.
Once I've made my ruling, I'm going to mute you if you don't follow the rules.
I'm
Exhibit
going
one,
for a mistrial.
Exhibit 152,
Denied. Just deny it. Deny it. Deny it and move on.
clearly intentional.
Deny his motion for a mistrial. Sorry, y'all.
Clearly intentional conduct.
We were good until the
States
band
Exhibit
instruments.
93. We asked the court to take time to have you go look at this car in person because it's remarkably amazing that this
How much
was
damage?
caused by human beings. That's intent.
Yep.
This is an excerpt from States Exhibit 154. Maybe a little hard to see. A lot
Yeah,
of that
there was
laying in the front
no
part of this photo.
there was
are
no
shoes.
horn in that video.
Remember what Dr. Vidritsky said about the shoes and the feet, the scuff marks on the toes and the ankles? Look at all the shoes laying in the street. This is the area at the end when he ran through the Catholic community. All the shoes laying there because of the velocity. Remember, the medical examiner talked about the velocity.
Yeah,
It's
he
not
hit
just
people
the
so
speed, it's the
hard they were
velocity.
knocked out
The
of their
power
shoes.
that these people were knocked right out of their shoes.
It's a very powerful argument.
That's intent. The flight, the hiding, changing his appearance. He had to go through some effort, right? Crawled up
knew.
in this playhouse, ditched his sweatshirt and his sandal. The other sandal seems pretty reasonable. He dropped it when he was jumping over a fence. Changed his appearance.
Yep, because he knew.
Please play.
That's intent. I saw Aurelius, not Marcus, said I'm in my feelings. I mean, the audio of it without the video is almost worse.
Excuse me.
To be fair, I also prosecuted some really horrific vehicular cases.
Intent. What's he running from?
If it's a
What's he
mistake,
running from if he's
If
just
it's a mistake.
lost guy with no ride back to Milwaukee? What's he running from as there's cops, sirens wailing in the background?
her
Whoops.
face also says
That
it
was me.
all.
So, State's Exhibit number 130. Put that up here quickly.
So now they're going to not the videos, but the exhibits that the juries can take back, I think.
I'm not gonna go through this whole thing, folks. Suffice it to say, after Officer Skolton tried to stop the threat at that intersection at the top, Wisconsin Avenue,
Call it what it is. That threat, the defendant. Trying to stop the
drove south on
defendant.
West Avenue, over to Prospect Court, cutting through the yards and ditching the vehicle on Maple.
This is his
Heard
flight.
all the testimony about the commotion on Maple. The eyewitness testimony from Officer Sailors, off-duty police officer who saw the defendant, Darrell Brooks. He identified him for you in this court. Get out and run from this car. And how we tracked him through the neighborhood. And again, the desperation, whether he had to ask or use veiled threats like, I won't hurt you, but I need your phone. He was absolutely desperate to get out of there.
Flight means escape.
Till he took refuge in the home of
The
Daniel
jury
Ryder. Now,
instructions say
remember the
flight,
interesting thing,
and they
folks?
can consider flight.
None of these witnesses in this area knew anything about what happened at the parade. None of them. None of them were there.
No, because that's how he came across them.
None of them were there. So some of them tried to help, some of them didn't. Daniel Ryder did, and it's actually probably a really good thing that he took him in, because it stalled, right? It stalled them from keep running, kept them in one place until the cops could close in and get there.
And they did.
Now, Mr. Brooks repeatedly asked witnesses who had just watched their loved ones get struck by this SUV if they happen to catch a license plate. State's
Over
Exhibit 150,
and
there's the
over
front license plate.
And over, he asked.
Definitely a little blurry, but definitely you
with
can
the-
make it out. State's Exhibit 151, there's the rear plate. State's Exhibit 175, there's Darrell Brooks in his music video with the same car and the same license plate. There's the key to the Ford that was found in Darrell Brooks' pocket.
When you have the key to the
There's
car,
no doubt
it's very hard to
Darrell
say
Brooks
you
is
weren't
the person
driving it.
responsible for this. Because this man in this picture is the same as this man in this picture.
And the same as that man sitting
This
right there.
sweatshirt.
Oh, she
And
brought
again,
it
it's a
in.
little hard to see, but you can ask for these exhibits in the jury room if you want. The photograph, you can see this design on the front of the sweatshirt if you look close enough.
I don't think this jury's
This is a
concerned about
sweatshirt from
identity.
playset that has Darrell Brooks' DNA on it,
I don't think they're worried about that.
according to the crime lab. That's him right there. That's Darrell Brooks driving off into the parade. That's Darrell Brooks driving in the parade. That's Darrell Brooks driving in the parade. That is also Darrell Brooks driving in the parade. And so is that. And he kept asking people about the tints on the window. Well, guess what, folks? You don't need to see the tints on the window when the windows are rolled down. And there's clearly one person in that vehicle in every one of these photos.
Oh, the windows are down.
And it's that man,
She just showed
and
it in the
it's that
still
man,
that the windows are down.
and it's that man. Darrell Edward Brooks Jr., date of birth 2/21/1982, on his identification card issued by the state of Wisconsin. In all capital letters, Darrell Edward Brooks Jr. This was in his pocket when they arrested him. So this entire
Court TV has done a really
shenanigans
good
that
job
he's
of
presented
showing
to
and
you
not showing what they're
through his
supposed to and not supposed to.
questioning of
Thank you, chat, for
witnesses
clearing
about,
that
I'm
up.
not Darrell Brooks, and that's my name, and I don't know who
Had
that is, and
the
I
windows
don't
down.
consent to being called that name.
He would have heard people
It's just
screaming.
nothing but a distraction. It's Darrell Brooks.
He would have heard more than that.
It's the man who
but
drove through the Waukesha Christmas
I'm
parade,
gonna leave that be.
killed people, injured people, endangered the safety of people.
I'm sorry, your objection, sir?
They showed my ID. I don't consent to being called that name.
Your Honor, with all due respect, I would appreciate the quote-unquote, language what does she mean by shenanigans and this and that and the third?
Sir,
Sir, your objection's
This is
noted.
closing
It's overruled.
argument.
The state may continue.
I object to you
Okay.
driving through a marching band.
Because if that was me, if I would've said
Mr.
something
Brooks,
like
your
that, it would've been a
objection
problem.
is noted. It's overruled. These are closing arguments. There's
I
nothing
just-
improper.
This is
It's noted,
closing.
It's overruled. She may
I
continue.
just wanted to be clear.
You'll have
Your
an
Honor, that's it.
opportunity to respond, sir.
The record's been made.
So I can.
Overruled.
Go ahead, Attorney Opper.
Thank you. I'm gonna conclude my comments with this, folks. I'm gonna show you the video, a stitched together video of all the carnage caused by Darrell Brooks.
Oh, God.
And I apologize.
Stitched together.
This is important.
Mute
that
him.
You know
What he
what he
did.
did.
Yeah.
It's important that you think about the women like Nicole White,
This won't be
Kelly
shown,
Grabo and her daughter, and Jane Kulik, who were just there
but the jury has to know.
with friends and co-workers supporting a local business. The teenagers marching in the band, representing, wearing their school colors. It's important.
It is.
Boys and girls with the Blazers baseball team and their coaches
The grannies.
doing nothing more than handing out baseball cards. The young girls in the extreme dance team. Can you imagine how many hours they spent practicing that routine? We drove right through them without a care in the world. The grannies dancing their way down the street.
Mute
Perfect
him.
step, every one of them. Catholic community there, as Father Matt said, spreading the light of Christ in the weeks before Christmas. He snuffed it out. It's time for Darrell Brooks to stop running. It's time for him to stop
Playing
lying.
games.
It's time for him to be held accountable for his actions. Darrell Brooks cowardly rammed his way through this parade, violently killing and injuring so many people. I'm going to stop talking and play this video, but please, I ask you to add up the evidence, use the map, 15. You can check off the names. We've covered them all. Walk down that street like we did with you. Return guilty verdicts on all counts.
Part of the power of this closing is it didn't need to be overstated.
Please.
Screen back up.
No, I need one more.
That they didn't need to go through every single count. The chart has it all. The evidence was proven. The evidence is straightforward. And now they're showing a photo slideshow, or will be, of everyone that was injured. That's not going to be shown on TV. Because he drove through this parade. He's accused of driving through this parade. I think the DAs have proven that. I think they spent the right amount of time on intent. I think that the types of objections he made shows his level of understanding and manipulation of this courtroom. I think this is going to be very difficult for this jury to watch, but they've seen it. This is all the evidence they've seen. But the audio is so much different than just photos, because it transports you there. So this courtroom is pin silent as they're watching this closing. I thought it was a very, very powerful closing. I think being restrained is what was needed. This jury has been there for 16 days. They don't need to go through every single count. That chart had it all, and it showed the progression of what happened of all of the crimes that are accused. It's going to take this jury time. Listen to how quiet that courtroom is. Look at the judge's face. Those are some long blinks. absolutely silent in that courtroom as this plays. It'll be interesting to see if the court takes a break after this. I think they probably should take a little bit of a break after this. Oh, you can see it on the ADA's face. See, her face is going to kill me, absolutely kill me, but you can see it on her face. You can see the judge also just reining it in. Look, my trial face is long broken. I've been out of trials since 2017. My trial face is long broken. There's just no reining it in at this point. I also turn bright pink when I try to, so. I don't know if that's the jury or an audience member that was crying. I don't hold it against anyone that would, because we know that there are people in the courtroom. I imagine that they left because I heard footsteps. This video is still going. That's how many people were injured that this video is still going.
Thank you. Before we continue with Mr. Brooks's closing arguments, I'm going to take a short break.
Yep.
All rise for the jury, please.
Yep. Everybody needs a minute.
Am I muted?
No, you're not muted. Let the jury
Should know that they can nullify.
let the jury leave the room. Oh, she's going to be pissed. Look at it. I see the anger. I'm ready to be pissed. I'm ready to feel something other than sorrow. I'm ready to be angry too. Let's do it. Let's switch emotions. Anger is way easier to process. Rage.
Thank you. We'll be in recess for about 10 minutes.
She's going to have to address him. I saw the judge close her eyes. All of this would be hard to sit through. Rage. I can't. Am I unmuted? The jury has a right to know they can nullify. Twice he's said it. Twice he has said that. I don't know why Court TV chose the camera and not the clock. So we are going to get to some of the questions and super chats. I told you we have different colors of blush for the face. This is not cute crying. Turn the whole face pink. That was a very long video of the damage that he's alleged to have caused. She said 10-minute break. He is going to keep saying shit that he can't say. So we're going to talk about Nullify. I see all of I see you. I see your comments. I see you asking about jury nullification. I'm going to take a moment to ask for something as well. Have you liked and subscribed? I'm just trying to lighten the mood. I don't like all the emotion. I'm ready for it to move through my body. We're just going to let it go. So do the YouTube things. Okay. Jury nullification is when the jury disregards the law, disregards the jury instructions, finds the law is not lawful law, and says, yeah, we think he did it, but we don't like the law. I told a quick, back in my day, story before the lunch break about a jury nullification case where the jury decided, you know what? No, we're not going to prosecute this. Jury nullification can come into play in circumstances where really the members of the community are like, that's not a crime, or we get it, or we're just not convicting you of this. We just don't want to do that. So the jury's told they have to take the facts and the facts and the evidence and decide whether it's been proven or not. And he's saying, even if you think it's been proven, you get to choose to not. You get to choose to not. And he's not allowed to bring that up. He said it twice. I don't know if it's going to matter to this jury at all. I don't know if nullification is even something that they're going to consider based on this defendant's own behavior. So jury nullification is probably not going to happen. No way nullification happens after that closing. I don't think so. I think it was a very, very good closing. And it was, the thing I appreciate about it is the power and the restraint. There's no need for dramatics. Some closings can be very dramatic. There's no need for a lot of props. It was very much, this chart shows you what he did. His actions show you his intent. This is the injury he caused. It honored the victims. It talked through their story. It showed you what intent was and really focused on intent for those first-degree murder charges, because the charges, all the, 7 through 66 or 67 of the people he endangered, he drove a car through people. Those are going to be easy to find. It's the intent for those first-degree murders that they're looking for. And if the defense had defense attorneys, what they would have done is try to argue down from first degree to the hit and runs with injury and try to get rid of those first degree murders on intent. That would have been their strongest argument. That would have been where they can really make a difference in how much time he's facing in sentencing, whether he gets parole, things like that. That's what I think a defense attorney would have done in this case. You're not shooting for a not guilty on everything. You're really trying to limit that intent and try to reduce those first degree murder counts, first degree intentional homicide counts. So let's go to some of our super chats and questions while we have this 10-minute break. I'm so glad I brought sugar. I mean, coping mechanisms that stay with you for a lifetime. I'm not saying they're healthy. You're not here for for life advice. We're just here for legal commentary. Ho, good to see you. I suspect the jury's going to be doing some nullifying, all right, but it's not going to be of what he thinks. I mean, this jury's all going to want to drink. They're staying in a hotel tonight, so the jury brought a bag. The jury is sequestered. This is the first time the jury's going to have a chance to talk with each other about the case. The jury's going to need to go home and like hug their loved ones after all of this. But I imagine if the juries will treat it like I did. I mean, I talked to my coworkers about this stuff at work, but I didn't tell my family about everything at work. People will ask me all the time, what's some of the worst stuff you've seen? And I'm like, let me tell you some of the silliest or craziest things I've seen. Like the dude who was prosecuted because he had the 2 dancing girl emojis tattooed above his eyebrow. And everybody's like, oh, it was a guy. He had the 2 dancing girl emojis above his eyebrow. Stuff like that. A 3-way that ended with scissors. Like things like that we'll talk about. But the worst stuff? No. Nope. We keep that in a box of, trauma. We just bury that deep down and talk about it with other people who have also seen equally horrible and horrific things. We try not to traumatize the normies. And I imagine this jury will do the same thing, trying not to traumatize the normies. I totally forgot about John Grisham's A Time to Kill. Thank you, Katie. That's very helpful. So he's going to try to argue that the jury should just disregard the law, that they have the power to do whatever the fuck they want. That's not going to fly. And the judge is going to have to shut it down. He's going to have to stay in the other room with a mute button. If they pan back to this courtroom and he's sitting in the courtroom, I'm going to lose my damn mind. Jury nullification is when the jury disagrees with the law. Yep. I don't think that's going to happen here. This defendant is the definition of agent of chaos. I mean, he thinks he is. Angie has said, Wisconsin resident here. Thank you for covering this. You are welcome. It's part of the reason I kept covering it. I wanted to cover a little bit of this trial and talk about sovereign citizens a little bit, talk about pro per defendants, talk about trial. I really like covering trials. Some of the testimony I knew was just going to be really, really rough. So I jumped into it with the defense's case, and the amount of emails my team and I got, not just emails, DMs on social media, comments on the post of those of you who live in the community or who were invested in this case and found this community a place where you could watch this without feeling so alone, is the reason I kept doing this day over day. I am here to be in this community of law nerds. I love this community. Y'all are the greatest group of folks on the internet, and I appreciate you. And that is why I continued covering it, because our community deserves to have a place to chat as we go through this without in a safe place where you can be in the chat and say, this is making me cry. Sames. It's heartbreaking. It's heartbreaking. And the audio of it is simply chilling. We will absolutely fluff, honey. It's just, once again, when you are highly empathetic, criminal prosecution is maybe not the place for you. All of this lays like not very far under the surface for me, but that's okay. You know, I don't think I apologized too much for the emotions this time. I'm getting better at it. I've been yelled at court for being emotional. It's very hard. The victim impact statements are going to be very, very difficult. We will cover it. It's just going to be very, very difficult. So, FPS Stang said, as a paramedic, I would come home. Oh, it just jumped. I would never come home and tell my family the horrible things I'd seen. We talk to each other, not to our families. Yeah. You know, you keep the trauma with the other people that are already traumatized. It took me 2 different therapists to actually feel comfortable sharing it. My therapist is like, you know, I have a therapist to like help process. You can actually tell me the things. And I was like, I don't want to do that to you. I don't want to tell you the things that I know because they're that bad. Francis Cox said, I'm crying. The judge did him a favor. It would have been the straw that broke the camel's back to see him with no remorse making his comments. It would have been, the jury's seeing him and seeing how he acts. What's the legal basis for mentioning of nullification that creates cause for a mistrial? There are lots of things in a closing that can create cause for mistrial. Telling the jury things that they can't legally be told can prejudice the case for the prosecution, can harm the case because the jury was never supposed to hear that. And at some point, the shit's out of the horse. The bell can't be unrung. The toothpaste can't go back in the tube because you can't undo what's been said. And he knows once the words are out and the jury hears it, you can't undo what's been said. I don't think anything undoes the video that the DAs have shown in that closing. I don't think anything's going to override that. But it's going to put this judge in a position where the prosecution might have to say that's too far. We'll see. This judge is probably going to come out hot and with a stack of case law because he's said nullification twice now, and we're not even into his closings. Him closing his eyes and praying during that sideshow pissed me off more than anything. I don't know if he was praying or if he was just trying to block his face and make it look like he was praying, but so. Oh, let's see. He was sitting there watching a video of carnage with no freaking remorse. I don't know. I don't know how he does it. If you complain that I'm emotional, that's a you problem, not an I problem. Well, in court, sometimes it felt like a me problem, but I'm working on it. Deanne said, as a psychologist, I'd like to say that you can tell us anything. We are trained. I know. I was always afraid. We are trained to hear the bad stuff. We also get counseling from our coworkers. I know. And I've been told that. It took me a while. Because you don't want to, you don't want to do that to people. So I get it. But yes, thank you. I always try. What trial are you watching next? It is my intention to cover the Murdaugh case, which is not going to be lighter than this. The Murdaugh case is going to be lawyers, but the Murdaugh case is the next one that I want to cover because it will stream. But don't worry, we're going to do a whole episode of like a drinking Q&A, and we're going to talk about food lawsuits. We're going to do at least a full episode. We need to check back in on the great Utah cookie crumble situation. We need to talk about the hot sauce that's made or not made in Texas, New York City. We have a whole episode to do of food lawsuits. None of those are videoed though. So, T Horseman said, first time joining you. Well, thank you. What a breath of fresh air you are in the legal. Well, thank you. I'm definitely unique within my space. It looks like we might be going back to court in just a second. I had a pro se once on like 6 or 7 R cases, a rough case. Yep. I can imagine. Pro ses also, well, certain individuals also like to represent themselves in family law matters and sexual assault cases and domestic violence cases. And then they cross-examine their victims. Michelle said, can't they strike it from the record? Yes, it can be struck from the record, but it's also the same as looking at your kid and saying, you didn't hear that. They're like, it's in the vault now, motherfucker. The hell I didn't hear it. And that's the problem. Because once you say move to strike, then it just highlights for the jury how important it is. So that's also a strategic decision that a lawyer has to go through at the time. Do I ask to have it stricken? Do I make an objection? Do I ignore it and hope that they were half asleep? It's and you're making those calculations in real time. Florida T-Bird, the judge should just let him do his closing, say whatever he wants to say and crucify himself. There's no way a jury will nullify or come back with a not guilty verdict. I understand the desire, I do, but the judge also and the prosecution also have to think about, but what if? He could cause a problem and hang the jury, and then you have to do it all over again. There's a worry. There's a worry with that. So Peter said, God forbid the mainstream media be scrutinized for being sensationalistic of mass shootings. I mean, and everything at this point, and producing copycat crimes. There's a much larger conversation to have about mass killings in the U.S. Much larger conversation to have. Why wouldn't the judge remind him of the waiver he signed? She did yesterday or the day before that he signed a waiver, but he says that he signed. It's word games. It's all word salad games. Like, oh, I signed the waiver, but not as Darrell Brooks. Darrell Brooks isn't me. I'm not Darrell Brooks. I signed it as a conscientious objector. This is me, just conscientious objector, third party, reserving my rights. I didn't really do it. So Shell CD said, my mom and I are going to sit in the Murdaugh case. Law Nerds meet us there January 23rd. If it doesn't get postponed, but it should be streaming. So I'll cover it from here. Miss Christie said, yeah, being a nurse for years upon years left me with some hella trauma. I mean, that it is. Always listen to heavy metal on the way home, try to drown out the day before I got home. A commute home was always helpful. Yeah, metal's very helpful. So please cover the recent case about Heineken. Yes, we're going to do a whole food stream. Big hugs to all. Congrats on 667. Thank you. I know we banged. Just don't forget to like and subscribe. My dad is a retired general surgeon who handled lots of victims of gang violence. He still has night terrors and PTSD, but he's getting better. It's one of those things that doesn't leave you. So yes. Blow those body thetans. I don't know what that means, but my brain is also kind of jumbled at the moment. As a trauma ICU nurse, I have the same shit. We don't talk about box. Yeah, I'm not saying it's a healthy coping mechanism. Therapy has done wonders. I love therapy. But yes, there is a lot of squish it down. First responders, military person. There are so many of us that deal with trauma in our jobs, and we don't talk about it enough. I am so happy to talk about it. It's one of the reasons I really, really try not to apologize when I show emotion, because that's something I had to stuff down for so long. So, okay, we're going to keep going through questions. This feels like a long break. Chat, I have no concept of time. Has this been more than 10 minutes? Oh my God, it's 4:00. What time did we? Oh, it's only been 2 hours. So I thought the judge said 10 minutes. So, and then I was chewing ice. Sorry. I run and see a therapist. Christine, a lot of people run. I wish that was my coping mechanism. It would be such a better coping mechanism than peanut butter cups. I am trying to shift coping mechanisms, y'all. I'm working on it. Can the jurors deliberate at the hotel? This is a great question, Chicken Wang. I hope I said that properly. I think I saw that something's happening. Yes, the jury can deliberate into the night, or the jury could say, I need 15 minutes by myself to cry. Can we just do this in the morning? The jury gets to decide. I don't know what time. The judge still has a few hours of jury instructions to read. The judge has at least an hour or two of jury instructions to read. Will Emily be covering the Danny Masterson case? Emily has been covering the Danny Masterson case in last week's podcast, and I'll be covering it in this week's podcast that will be out tomorrow. I just kind of update. Deadline is covering it in much more detail. There's a lot of detail about the assaults on Deadline. It is not streaming, but there is a lot of reporting. I have been covering I have been covering it at a more higher up view. So, Scott in Nebraska, do you think the DA proved intent? Yes. I think intent is there. I absolutely do think intent is there. Question, when is it time to go over, when it is time, are you going to cover the, sorry, my chat keeps jumping, the Harmony Montgomery, when it's time? I have no idea what that case is. I will make a note. I don't know what that case is. So I don't know. All right, let's keep going. So for jury nullification to work, is the jury supposed to come out to this consensus of their own? Jury nullification is not really an option. It's not really a thing, but it happens when the jury looks at all the facts, looks at convicting someone and goes, nah, it's just a not guilty verdict. Even if they find it's just a not guilty verdict is really jury saying, no, we're not convicting someone of that. So Princess Tigress said, your channel has been a blessing for me. I have ADHD, dyslexia, PTSD, depression, anxiety, nightmare. Finding your channel has been a game changer. Thank you so much. That's very kind. It's once again why we have the rules that we have, so that this community is a kind and compassionate and welcoming community. We're welcome unless you're welcoming. People are like, Emily, you said your community was welcoming, and then you said like no name and calling, and then you said don't be a dick. I'm like, yeah, sometimes we contradict ourselves. Oh, fucking hell. He's in the courtroom. What is she doing?
What is happening? Why are we in the courtroom? This is not going to be good. I don't see how the judge thinks this is going to be okay. This is going to be an unmitigated disaster. Putting him back in the mute box. What are we doing?
I'm sorry. We haven't had appropriate time to use the voice changer. It felt like now was the moment. Okay, good. Sadness to rage. Sadness to rage. I'm used to this switch. We can switch back to rage. We can switch. I need a fan. I need to ask Peter Mom where he gets his fans. I cannot believe it. I cannot believe. This room full of people, a lot of them victims, family members, I'm assuming, are now in this room with this and has to sit
The
there.
record should reflect that Mr. Brooks is now present
Why?
in the main courtroom.
Why? Why is he in the
Prior to
courtroom?
Reopening following the break, I did invite him back into the courtroom.
Why?
And he is here.
Why?
I trust you are ready with your closing argument.
No, yell at him.
I'm ready to address subject matter jurisdiction as well, too.
No, fuck off.
Denied.
Just for the record, I was addressing it for both courtrooms here in courtroom number, I think it's 20.
Mr. Brooks, I'm going to bring the jury.
Look
Are
at how
you
calm.
prepared to present your closing argument?
He's going to talk right over you.
I would like for you to prove subject matter jurisdiction on the record, Your Honor.
No, fuck off.
I'm not addressing that any further than I've addressed already, sir. There's a written decision. I remind you.
There
of
is a
that.
time and a
That
place, and
written
it is not now.
decision, Did I receive, actually, I didn't receive anything. Was there copies made?
Oh.
Mr. Brooks, I'm going to ask you one more time. Are you
Stop playing
prepared
games.
with your closing argument? I'm going to have the jury brought out. There's
One.
no other legal arguments I
I'm
need
in
to
for
address
two.
at this time.
I'm informed of what
Three.
you're saying. I was merely asking, was there copies made of your,
Stop
you said written
fucking
decision?
around.
Sir, my written decision has been filed into the record. That is done electronically. You were provided with a written copy previously. Are you asking for another copy of that, sir?
Yeah, because I don't have it.
As a courtesy,
You ripped it up.
I'll have my clerk print off a copy and
You ripped it
provide
up. You
to
ripped it up.
Is it proven subject matter jurisdiction?
She gave him a written ruling.
Your objection
He
to the
ripped
lack of
it
jurisdiction
up.
has been noted repeatedly on the record. It is a meritless argument. I've indicated that in my written decision as
And then
to
you
why
ripped it
there
up.
is subject matter jurisdiction. And I will continue forward with the final stages of this trial.
Mess. This is going to be a mess. I should have gone to
Which
the
I hope
bathroom.
include your closing argument and then the final instructions to the jury.
Tana,
Oh,
one more time,
yeah,
5 more
yeah.
times, 10 more times.
Prove
Yep.
subject matter jurisdiction on the record, too.
It's been
All right, I will
proven.
instruct the jury to come out for the
This happened in
record.
Waukesha.
The written decision is once again being provided to the
I accept
defendant.
for value in return for value this document.
Oh, we don't
As
care.
it is not based in lawful law.
The
It does
the
not prove subject matter jurisdiction
restraint
whatsoever.
of those in the courtroom
Refers to
is impressive.
some complaint.
They've just
That was
watched
filed
what we
in
all
the-
just watched and are
The name
sitting
of a
there,
trust, not my name.
civilized,
Were you aware of that, Your Honor?
restrained, members of a
Mr. Brooks, the
civilized
jury
society
has been asked to be
with
brought out.
rules
I mean, I
protected by the
requested that they be
Constitution.
Brought out, they're on their way.
Were you aware
Please
of
be
that?
prepared with your closing argument.
Were you aware of that, Your Honor?
I'm aware that you have the right to shut the fuck up.
Was that a tacit agreement that you don't have to answer?
Oh,
any
he is
questions
testing
as
her
a public
patience.
servant?
She looks mad.
All rise.
How could you not be?
So that is a tacit agreement.
Stop trying to assert your dominance over this courtroom. You're not the one in control here.
Record to reflect the jury is coming out.
You're the one on trial for murder. I like that she ignored him. That's the only option. They're gonna have to object. Did the judge plan on wearing the matching glasses on purpose? Oh, I always wear these glasses, and I imagine the judge always wears hers. Yes, somebody told him how to pronounce tacit. He might have been watching Natalie Lawyer Check.
Thank you, everyone. Please be seated.
I have snacks. Do y'all have snacks?
ahead,
Are we
sir.
prepared? I'm not
You may
prepared.
begin your closing argument.
Oh
I'm
God.
not ready to begin closing arguments.
Did he just say I'm not ready to begin?
So this is your
Sir?
opportunity to provide your closing argument to the jury. Please start. I've started the timer
I'm in-
of 1 hour.
This goes against his
informed
time.
of that, Your Honor, but I'm not ready to proceed as I don't understand the reason why the questions asked before the jury was
Tough
present
shit.
were not answered.
Sir, I've
There-
explained.
There are issues that needed to be addressed outside
Noted
of
for the
jury,
record.
as you always say, which I don't understand why the jury deserves to
Mr.
need
Brooks,
to
this
know.
is your opportunity to present your closing argument to the jury. Please do so.
Sometimes
I'm
rage is
informed of
nice.
that, but the jury needs to understand the truth.
Strong
their
emotion is
rights, and
good.
Their duties, as they have not been informed of their truth, their rights, and their
Great.
Mr. Brooks, the court has begun the instruction process. I read 73
Stop
pages
answering him.
this morning, and into the early afternoon, I have another 30-plus pages to read.
Did you inform
They will
the
be
jury-
informed of the law.
Did you inform them that they can
Mr.
nullify
Brooks?
the law?
Mr. Brooks, you do not have that
Do
right
not
to request that.
Speak.
And
Were
I'm
those
advising
words.
you
I like
one
that
more
she's not
time,
making it a big
This is your
deal.
opportunity to provide your closing argument. Please begin.
I like that she's not
intend to
making it a
when
big
ready. I
deal.
just want to know if the jury was informed that they can nullify the
Sir,
law.
sir,
Mr.
they are-
Brooks, you
that
have
they
no
have
right
the
to
This
make
is
that
inappropriate
argument to
argument.
the jury.
she needs to say that. This
It's
is
true. They
inappropriate.
have the power.
This is inappropriate.
I'm going to
argu-
excuse the jury.
Ah!
They should know that they
Ah!
have the
What
power.
happened? I don't know what
Please
happened.
rise for the jury.
She's kicking out the jury. We knew this was going to happen.
It's not like we just said this is exactly what was gonna happen. Because that's what we said.
Oh, I'm an angry chipmunk. We said this is what was going to happen, and here we are. This is exactly what happened. Put him back in the mute box. So you can mute. That's my censor button. We knew this is what was going to happen. He brought up nullification like 6 times. Who was counting? Somebody was counting.
Thank you. Please be seated. Mr. Brooks, you do not have a right
Mr. Brooks, who the
to
fuck do you think you
request
are?
jury nullification directly from this jury. I direct your attention to the Bajorkas case, BJERKASS, that's State versus 163 Wisconsin 2nd 549. While you are not incorrect that the jury has the power to nullify,
Roger.
they don't have the right to do so, and no party has the right to
To
instruct
ask.
or to request
Good to
an
see you, Roger.
instruction or to argue jury nullification.
Thank you for the super chat.
You may talk in terms of fairness, in general terms, but you may not
All right,
go
I'll take a look.
further. You may not argue that the jury should discard the instructions in the law.
The jurors are
and
residents
find you not
of
guilty
Waukesha,
for
Wisconsin.
that reason. You may not use the phrase jury nullification. You've done that now at least 3
I think that's what a guilty
times
verdict does.
in earshot of the jury, twice while you were in the other courtroom. I was able to mute half of what you said the second time, and then, of course, you raised that once again while in front of the jury just now. You also indicated you weren't ready to give your closing argument. Sir, the time has come
They're playing.
for you to give your closing argument. If you choose not to do so at this time, then you will forfeit your right to present a closing
Oh,
argument.
that's been brought up
for your
once.
Conduct.
I haven't made any such choice,
Good.
so you can't
Oh, she can.
coerce me into a constitutional right.
That's not how that
waiver when I have
works.
not waived the constitutional right.
Then make your
And I will
closing.
not allow you as a public servant to do that.
I won't allow you.
Not made a choice.
Mm-hmm.
So the time has come for you to present your closing argument.
Are you making a judicial determination that you're
She's
denying
giving you
me
the rules
the
of fuck around and
constitutional
find out.
in
I have
open
not
court
made such
on
a
record?
determination as of yet, but you can forfeit your constitutional
If you
rights
keep going.
by
What lawful
conduct.
law?
That's the find out.
Illinois versus Allen, state
No,
versus
stop
Anthony.
Illinois
entertaining
versus
under
Allen
what
does
lawful
not
law?
reference anything
Don't entertain this
pertaining
shit.
to, rights when talking about
In
closing
state versus
statements.
Anthony, the
Illinois
Supreme
versus
Court of
Allen.
Wisconsin referenced both.
There's no
that
logical argument with
decision,
this.
When it essentially extended the
No, no,
reasoning
no, no,
or
no, no, no.
adopted the reasoning of Illinois versus Allen to then find that a defendant could forfeit an important constitutional right by conduct. In state versus Anthony, it was not the right to be present in the courtroom, it was the right to testify.
Okay, so none
And
of
the
those that you just
reasoning-
named have anything to do with the closing arguments, Your Honor. You've used Illinois
You're
versus
not
Allen
arguing
repeatedly
case law
to-
right now. Come
when
on.
it comes to me being removed.
No, you're not.
From the courtroom. Not one time did it bring up anything dealing with a closing statement or a closing argument.
Sir,
So how's that same
he's trying to argue case
statute
law with this judge right now.
being used for something that
Coherently.
it doesn't even refer to or pertain to?
Mr. Brooks, the Allen decision, Illinois versus Allen, and the Anthony decision, which is state versus Anthony, are two examples of cases where a defendant lost a very important constitutional right because that right was forfeited by the conduct of that particular
And
defendant.
that was to be present in trial, correct?
The right to present a closing
Okay,
argument is
that's
no
not how
different.
that works.
Because it is not evidence,
Case law doesn't like always line right
it
up.
could be said that it doesn't even rank as high as the right to testify,
Stop
which
engaging.
is guaranteed by the constitutions.
Which
Sir,
I was
ask your
denied
lawyer.
the
I'm
right
not prepared to
be
make
able to
that ruling
testify to.
here yet today, but I will tell you this, sir. The time has now come for you to present a closing argument. There will be no further delay.
The time has now come to
I
shit.
not a
will not be
delay.
taking
Or get off
any
the pot.
further adjournment
Shit.
for you to prepare.
I will not be taking
You were
any further
advised yesterday
nonsense.
That this court would proceed
4:15
today with instructing the jury and with the
Central.
parties making their closing
And you
arguments.
made that while
It is
violating
up-
my constitutional
Sir,
right.
please don't interrupt me.
That's
'cause
like
you
an
now
opinion.
interrupted me a couple of times.
That's your
No,
opinion.
once. So let's
Twice.
make that correct. Once.
That's the third time.
Sir,
Okay, now you can say two.
So, Mr. Brooks, I'm advising you yet again, the
I
time
don't
has now
consent to
come.
being called
That's
that name,
another
Your Honor.
interruption. The
4,
time has now come.
5, are we
for
counting
you to
now?
present your
How petty are we
closing
gonna get?
argument
I feel like we could
to
get
this
pettier.
jury. You were
And-
brought back over to this courtroom for that purpose.
I'm going to let them
That's
know.
another interruption.
Put 'em
I'm
in the
going to
timey
let them
outy
know
box.
That they have rights and they should be told, informed of the truth. It's
Your
not
Honor,
me trying to
I am
give-
not
Sir,
going to
that
follow
you're
your
trying to
ruling.
give-
Let me ask you a
No, hello.
question.
I'm not trying to give any
Sir,
jury
you're
Don't
interrupting
yield to
me.
him.
You haven't let me finish. So are you telling me that
How
you are
could they
going
not
to
be angry?
disregard my very clear directive to you to
Yep.
not bring up the topic of jury nullification?
That's not what I said.
Yes, that's
I'm
exactly what
that's
you
why I'm asking
said.
you.
I don't understand that question because that's not what I said.
It's exactly
Sir,
what you said.
may not argue jury nullification
I'm
to
going
this
to
jury.
inform them of the truth.
So you're going to inform them that they have the power of jury nullification.
They do have the, you just said on the record that they have the power.
He's gonna
to-
waive his
I
closing.
direct your
You
attention
just said that.
once
Did you
Ooh,
again.
we're
not
getting
just
close.
say that, Your Honor?
Sir,
You
the
said I
jury-
couldn't
Oh.
instruct them.
We're getting
The
close.
jury
on
has
that.
the power,
She
but
might
not
shut
the
him all the
right
way
to
down.
Right.
nullify. A
You said the
party-
power. You said the
Listen
power.
to me, sir. You're interrupting
Not the
me
right.
once again.
So I'm going to inform them that they have the power.
No.
Are you telling
This
me,
is
sir,
not
I'm not
fucking
telling you no such
He-Man.
thing. I
Disregard
just told you what you just
my
said.
directive to you to
I
not
have
raise
the
the issue of
power.
jury nullification during your closing argument.
Sorry, that
Not
was
what
probably
I said.
loud.
You just read and said that they have the power to. That's what you just said, Your Honor.
Sir, State versus Beef Jerky
Timeout box.
says, and stands for the
State versus
proposition
beef
that
jerky
although the
is where we're
jury
at now.
has the power of jury nullification.
They have the power.
No party
Don't teach him.
has the right to argue for jury nullification.
I'm not arguing for it, Your Honor. I
In
just
that
want them to be
case,
informed.
the-
I just want them
Sir,
merely to be informed.
He's done more
That's it.
trials than some lawyers I know.
Informing, making
be
them
fair.
aware.
I know lawyers that have never done a
they
trial.
They should be aware.
Lawyers
of
that
You
have
are
never
not
done a
allowed
jury,
to make
jury
them
trial.
aware
Lawyers that have never
of
done a murder
their
trial.
power to nullify.
The District
That is
Attorney of
an
Los Angeles County has never tried a trial.
argument.
Your Honor, how can I not inform them that they have a power? How
Because
can I
that
not
is not a
inform them
right
of a
that
power
you
that they
have, sir.
have?
Because there are rules.
I'm not giving a new jury instruction.
Ask your
That's not what I'm
lawyer.
There's
arguing.
no jury instruction for jury nullification,
Yeah, I'm
sir,
not-
because it's not allowed.
I'm not attempting to give them a new jury instruction. I'm merely attempting to inform them of the power that they have.
Mr.
That's not
Brooks,
against the law.
I'm
just trying to
advising
lighten the
you one
mood.
more time. You may not raise the issue of jury
I'm
nullification
going
before
to
this jury.
inform them of the power that they have.
Oh, he just said it. He's
I'm not
You are
giving them-
explicitly.
telling me
I'm
that
not
you
giving
are
them a jury
insisting
instruction.
Yep.
on telling them
Yes,
about jury
yes.
nullification.
Yes.
That's what I hear you saying.
That's not what I said.
That's
though.
exactly what the
Don't
fuck you said.
mischaracterize what I'm saying.
That's what the fuck you said.
You just read and said that they have
That's
the
what you said.
power. They have the power to do that.
You are
So
playing
how-
with words,
how is
sir.
It's an
informing them-
inherent power that they have. They are not to
Ma'am,
be instructed on it. That is very
stop
clear in the law. In
authorizing
addition to-
this.
No, let me finish. In addition to the case that I just cited, I'd cite to you from the jury instructions, the law note on jury nullification 705. What that says, sirs, I'm not going to read it all. It's many, many pages. But the bottom line is, it is improper for a court to allow a defendant or a defense attorney to
Correct.
make an argument or make the jury aware
A lawyer could never do this.
that they have
He
the
can't do
power
this.
to nullify a verdict.
And Your
I
Honor,
think-
you just added this last night. That's why I had to sit there for an hour in the holding cell and wait for you to change the whole paperwork because I
No.
brought that up. So
No.
we never intended for this to even be an
No.
issue.
Mr.
It
Brooks,
never was brought up.
if you
It wasn't
think
supposed to be an
that I
issue
raised
because
the
you're not a
issue,
lawyer.
Your
Lawyers
Honor,
can't do
let me
this.
finish.
I'm not prepared to deal with an argument on jury
I
nullification.
didn't say,
then you
that's not what I
She was
said.
letting him dig.
That's
Chad.
not what I
missing the
said. In
mark.
all fairness, that's not what I said.
The record should accurately reflect that you were kept in that holding cell.
Why was I kept
so
in there?
that my clerk could finish
I feel like
Adding
I'm
a
watching
jury
a
instruction
domestic
that was
argument.
not there.
6 verdict forms, and it's times 2 because there's a guilty and a not guilty
Okay.
for each. No, let me finish. Sir.
So how
You've
did
interrupted
why did
me
I have to
repeatedly.
sit here for that where I could have just went to my cell and had it delivered?
Why are we going backwards? She's letting him
We had
dig
this
into
at the
not
end
getting
of
a
last-
closing.
At the end of last night, before you called recess,
I'm not going to
we
debate
had
the
a whole
topic with
we
you
had a whole
further.
conversation about
Mr. Brooks, you
me
are
bringing up about the jury
defiantly
nullification.
I'm guessing she doesn't have a gavel in her hand, so she won't throw it at
this
him.
court. You
Here we
you
go
can
with this.
roll your eyes at
Here
me
we go with
all
this.
you want.
It's ridiculous.
This
Your
isn't
Honor.
your ex. This is
You-
the
You
judge.
just stated that they have the power to nullify
Would you
any
like,
law,
if you would like,
but then I
will
said-
read this to you, sir, the part of the case that's important, but you're not letting me get a word in edgewise.
David, it was a little
I'm
weak.
trying
My gavel's
best
back there and I didn't
not
want to hurt
remove
everybody's
you
ears.
To the other courtroom.
You're right.
But that is oftentimes what I need to do in order for this court to make a full record without you interrupting me. But you need to be fully
She looks
aware
so mad.
that you may not
Oh, the gaslighting is
raise the issue of jury nullification in front of this jury. It is not an allowable argument or an advisement or
the
making them aware.
DAs
However
are getting
you
a
want
great
to
practice
describe
in
that, sir,
sitting
whatever
there and
verbiage you
shutting
want
up.
to put in front of it.
the hardest part of legal
you
practice
may
is
not
to stop talking.
do so, and this court has the
I'm very bad at
power
it.
and the authority to limit what you say to this jury, even in a closing argument. And if you're telling me through your conduct, through your words, that you are going to
That's what he
disregard
said.
that direction, you will forfeit your right to present
That's
a
what he said.
closing argument.
Under what lawful law?
That's what he said.
Under
Under the
State
lawful law of
versus
I just
Anthony.
fucking read it.
That it doesn't refer to that.
State versus
That's not how that
Anthony may
works.
not have dealt with
It hasn't
Stop
dealt
explaining.
with
the
closing
right
arguments.
to a closing
Stop explaining.
argument, sir, but the reasoning
You just said it right there.
nonetheless is
That's not how the law
fully
works, bro.
applicable,
No, you
because the more
can't change
general
the law, Your
principle-
Honor. You can't change the law. That's
I'm not
practicing law
changing
from the
the law,
bench.
sir, but the general
I
principle.
know you used to be in legislation, but you can't practice law from the bench.
Sir,
Sir, I'm
everything
not
she
do
does is
that.
practicing law from the bench.
You
She's a
are, if you're
judge.
changing, Your Honor,
I'm not
you're
making-
attempting to make a separate case pertain to something here that it
Does it
that
work if I
doesn't
do it?
even
Stop.
pertain to it.
K-
It has
Maybe if I
nothing
make
to
it bigger.
do with a
Stop.
closing argument.
Stop now.
Nothing that you
Does that
just
work?
named. Not
Mr.
Illinois
Stop,
versus
stop, stop.
I would
Allen.
like to make a record. Would you please show the
Damn it, that
courtesy
didn't
and
work.
respect for
I
me
will,
to
Your
do
Honor.
that?
I will.
All right.
I should have printed out an
So,
objection sign.
Looking at the Anthony case, all right? And that case, starting at head note 7, paragraph 54, says the following, and you need to let me get all the way through it. We have recognized two distinct ways in which a defendant may give up his rights.
I have a thought.
Waiver and forfeiture. State versus Pino is the first citation that
Which
they
kind of
reference.
Pinot? Grigio?
Waiver is
Noir?
the intentional
I have questions.
relinquishment or abandonment of a known right. Multiple citations there, I won't repeat them all. Waiver typically applies to those rights so important to the administration of a fair trial that mere inaction on the part of a litigant is not sufficient to demonstrate that a party intended to forego that right. State versus Soto. Forfeiture, on the other hand, often involves the failure to make the timely assertion of a right. That's a cite to the Dina case and Olano. Rights that are subject to forfeiture are typically those whose relinquishment will not necessarily deprive a party of a fair trial and whose protection is best left to the immediacy of the trial, such as when a party fails to raise an evidentiary objection. However, there is a second aspect of forfeiture, doing something incompatible with the assertion of a right. State versus Vaughn, 2012 Wisconsin Appellate 129, citing Illinois versus Allen, 397 U.S.
Wait a second.
337.
I'm going to do this better.
They went on, the court, that is the Wisconsin Supreme Court in Anthony. As previously noted, we have held that the right to testify is subject to waiver, not forfeiture, insofar as a defendant's inaction in asserting the right is concerned. We now conclude that the right to
My
testify
Apple
may,
Pencil's not
in
working.
appropriate cases, be subject to forfeiture.
Oh, he's getting ready
for
to just
conduct
argue.
Incompatible with the assertion of the right is at issue. They go on to discuss Allen, which was not a right to testify, but was a right to be present. And I am utilizing the guidance from Illinois versus
Does that work?
Allen and State versus Anthony. It directly
I think it
guides
works.
this court that a defendant
I'm gonna make it work.
may forfeit a right by conduct by doing something incompatible with
around.
the assertion of a right. In this particular case, you are very clearly telling me you are going to disregard
I didn't have any printer
what
paper.
I told you about notifying the jury about nullification. You have absolutely no right to raise that in front of the jury. It is
Unfortunately, my
improper.
iPad-
And unless you're
my iPad's
willing
not charged.
to tell me you will honor this ruling of mine, then you will forfeit your right to present a closing argument.
This jury's going to be there
That
all
is my
night.
ruling.
I object to that ruling, Your Honor.
Fine. It's noted. Oh, the people behind him
Object
changed.
to that ruling.
Are you willing to make a closing argument, sir, that does not reference jury nullification?
I'm going to inform the jury of their power. Again, I never stated that I was making.
He's not gonna get a
jury
closing.
Instruction.
He's not gonna get a
Never
closing.
Stated anything like that.
He's not going to get a
Every
closing.
Case law that you just stated made no
He's not gonna get a
reference to
closing.
Arguments. It
Oh,
was
yeah, let's
all
close the poll.
Pertaining to being present for the proceedings of trial and for testifying.
Sir, what
Not
I'm
one time
telling
did you, hold on, I let, Your Honor, with all due respect.
That's not
I
how that
let you
works.
Make your record. I didn't interrupt.
Y'all aren't equal.
Go ahead.
That's not how that works. Judge.
One case law that you just cited made any reference whatsoever to a closing argument.
That doesn't matter. The reasoning
one.
stands.
So how is me merely
Y'all, we took a
informing
poll.
the jury
22,000
of the
votes.
power and the rights that
Will
they
Brooks
have.
get a closing? 74% of you said no.
How is
25% of
that
you said
a
yes.
forfeiture of being able to give a closing argument?
Sir,
In addition to the cases I just cited, sir, I'd also
the principle
point
of
you
fuck
to State
around
versus
and
Majerkis,
find out.
163 Wisconsin 2nd at
Come on, that's a
549.
lot of-
That's
that's
a
a
Court
lot
of
of
Appeals
cases,
case
Your
from
Honor.
1991.
Yeah, she
That
came
is the
prepared.
first
These are the
published appellate
receipts,
decision in
sir.
Wisconsin to consider directly
Prepared.
several issues relating to the jury nullification issue.
She's working
In
towards
that particular case,
denying
the
him his
court
closing, and that's why
very
she's making
clearly
such a record.
said
That's
that the
why.
defense counsel in that case was allowed to talk in
Trying
terms
very
of
hard not to chew
fairness
ice.
in general terms, but
But I need some more fizzy water.
not to go further.
Where's
And
Dr.
could
B?
not
We need-
argue
we need
that the jury,
provisions.
quote, should disregard the instructions and the law and find her not guilty because it seems fair. That's a description of jury nullification. To use the words jury nullification would run afoul even more. And so I am telling you that given my inherent authority in controlling the mode and order
I'm in
of
control
this
now.
court, to ensure courtesy, decorum,
He's trying to
and
hijack this court, and it's
civility,
not going to work.
and to ensure that this jury
She's making a record.
is presented with arguments that are
Sensational finds. I'm
proper
going to talk
under
about
the
this when
law.
she's done making a
I am
record.
hereby telling you,
She is. It's like a housewives reunion.
creating a rule
All the receipts.
for your closing argument that you may not raise the issue of jury nullification in any way.
Your Honor, hold up now.
Hold
I'm
up.
the only one that has to
Hey.
be made rules for closing arguments.
No, those rules
but
apply to
not the
lawyers. They-
prosecution.
No, those
How's
rules
that
apply to
fair?
everyone.
How's that balanced?
They have rules.
Brooks, I'm squarely faced
They followed
with your
them.
defiance regarding the issue of jury nullification
It's
that
not
is
defiance.
requiring
It's
me
not defiance.
to address
She needed
this
to just
issue
say,
and
these
to
are the
tell
rules for
you
everyone.
very
They followed them.
expressly
You must.
That is the
Vehemently-
rule
I
for
vehemently
your
object to
closing
that.
argument.
Vehemently object to that.
That's not a separate
Your
objection.
objection is noted for the record, but
May
my
I ask
rule
for a legal
nonetheless
reconsideration of your
stands.
ruling?
No, denied.
That request is denied.
She needed to just say
May
these
I,
rules are for everyone.
respectfully ask for, matter of fact, I reject that ruling and take exception to that ruling.
Fine. You may.
Your
For the record, may I
Your
request a
exception
legal
is
or
noted.
factual basis for your ruling?
No.
Not
Denied.
one pertaining to being present in the courtroom or testifying.
Denied.
One that specifically talks about a closing argument.
Denied. Denied.
all of those requests
Are
are
denied.
noted. I will not reconsider. I've put my findings and my reasoning on the record, and I stand by that record.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law?
The request is denied.
Denied.
For the record, may I respectfully move for an interlocutory declaratory appeal on this
This
matter?
is not the right place to appeal.
I'm not the forum for which an appeal would be
Um,
sought, sir. I cannot
Well,
answer.
How long has this been
You
going on?
referred to it before.
You would need
So
to
now I'm
direct your
confused.
appeal to
I'm confused, Your
to
Honor,
a court of
because-
appeals, not this court.
No, this is.
You said
I'm
that if I
supposed to be in
cleaned
this
my room,
admiralty court.
I
'cause
could
you
get
haven't- you
my
haven't-
allowance. No, I
If
said
it-
clean your room
if
and
we're
unload
under
the
Article
dishwasher.
3,
No, no, no,
we
no,
should
no,
be
that's
in
not what you said.
Common law court, that hasn't even been addressed. If we're in a common law court or an admiralty court.
Are you on a ship?
That's a baseless argument, sir. I don't even need
And
to
what law
address
and
it.
fact? Based on what law and fact?
It's meritless.
Based on what law and fact?
Sir, are you ready to make your closing
Sir, I
argument?
intend to bring this jury out and give you
I'm
an
informed.
opportunity
I'm informed of that.
to present a closing argument.
Yeah,
If
but
you
you're
violate,
also- you're
please
also-
let me,
But
sir,
listen,
you're
you just
interrupting me
made a
yet
rule-
again.
You just tried to put me under a rule that no one else was put under.
That's not true.
The circumstances require that I implement this rule, sir, given your
The
stubborn
circumstances
defiance
don't.
on
Your
the
Honor, that's
issue
a
of jury
prejudice to my
nullification.
defense. You can't place me under certain rules and not place the prosecution under the same rules.
Sir, the
It has to be
circumstances of
fair.
this
The
case
prosecution
and your insistence in
has
arguing
to
jury nullification
adhere to the
has
rules
resulted
I
in this
haven't-
court
of
creating
evidence.
this
I
rule.
haven't argued it. I said that I wanted to inform
You said you were gonna.
the jury of their power. I never once said, I'm gonna make an argument, I'm gonna give them a jury instruction.
You may not
never
advise
said
them
that.
or make
Yes,
them
you did.
aware in any way.
Oh, this
that
is
they have
just
the power
shenanigans.
And why
of
not?
jury
Why can't they be
nullification,
informed of their power?
Because it would violate the Bajorkis decision, sir.
The
Violate
beef
what
jerky.
decision?
The beef jerky
All
decision.
right, sir, I am going to bring the jury out.
And I'm gonna inform them that they have the power.
And if you do that, I will dismiss the jury and I will declare
Out.
that your right to present a
can't do
closing
that.
argument
Under what
has
lawful
been
law?
forfeited based upon
Then I make a
how
oral,
I've
I'll make
outlined
an
that
oral
today.
There's no
motion
way.
for.
He's not gonna get
I'm
to
not
make a
gonna
closing.
declare that at
I'll be
this point
shocked if he makes a
because
closing
I
at this
wanna
point.
see what you will do. But if you raise the issue of jury nullification, I will immediately dismiss the jury. You will forfeit your right
You can't do
to
that.
present a closing
Under what
argument.
lawful law can you,
And then if you continue to
under
interrupt
what
me,
lawful
How long
law?
have we been doing
you will be
this?
removed to the other courtroom as I
so tired.
So I'm
complete
being
the
held in contempt
instructions.
again. Is it civil or criminal?
All right,
You've never been held in
go
contempt.
ahead.
I apologize. May
Yep.
I ask
You
the
have
court
to make a
consider
record.
Perhaps an alternative, and I
Mute
fully
box.
respect the ruling.
Put him in the
court has
penalty box
just
and
made,
mute him.
I understand the basis for it. We all know
They're
the
trying
defendant
so
in his
hard.
petulance will say jury nullification in the first 3 seconds the jury's in the room.
Facts.
Objection to
The
that.
Facts.
Proper
Facts.
I don't
thing
think
to
that
do,
I
I
should be
think,
talked
Facts.
down
Stop
to.
interrupting,
I don't
Attorney
think I
Ocker,
should be
please.
talked down to.
allow him to make his closing argument.
And then
I
instruct
will
the jury to
object if
disregard.
he misstates the law. You can instruct the jury to disregard any misstatements of the law.
She doesn't care. She's like, let him say
Continue in
it.
that fashion, if possible, for a reasonable amount of time. And if it becomes to the point where there's no reasonable, legal, credible argument that's being made, then the court can decide as to whether or not he's forfeited his right to a closing
Wow.
argument. But we could at least try to, by merely
The prosecution is trying
objecting and
so
the court
hard.
telling the jury to disregard and instructing Mr. Brooks to move on to the next topic, we could try to allow him his
She's not
opportunity
worried
to
about
provide a
it.
closing argument. If that's unworkable, then I think this record will be very
Sufficient.
clear as to the efforts of this court.
Wow.
And I think
That's generous.
there is materials in the bench book, or I'm sorry, the jury instruction 705, that talk about
Disregarding.
jury instruction. This court could even give, telling the jury that they are not at liberty to disregard the law, but we're not going that far yet because, frankly, you have told them and you will tell them that closing arguments are not evidence. And
We're not
I
worried
think they
about it.
will abide by that.
She's
So
more
I
worried.
know it's going to require
She's like, just let him say it. It's not going to undo this jury.
effort for the court to allow this to.
And we've seen Chanley Painter
Allow Mr. Brooks
from
to
Court
try
TV
and
tweet
proceed,
that it was one of the
but
jurors
I
who was
think we
crying
should
that we heard.
Try that or something similar to
This
that.
DA
in an
knows
effort
that.
To get through this.
That whatever
next step,
fuckery he
or else
spews is just going to
we'll
hurt him and
continue
not them.
At this pace forever.
That's a very fair point.
I'm certainly willing to try that.
And it's the prosecution at this point
That's
whose
about all we could come up with, Your Honor.
case needs to be
I'm certainly
protected.
willing to try it in this courtroom, and then if he disregards that, to excuse the jury, and then have him present from the other courtroom would be the second step, and then third would be a forfeiture.
Your Honor, I object to that.
Of course you do. Dr. Patrice, it's very fair. I don't think he's ready.
Your objection is noted for the record. That will be the course of action.
He
that
did
this
okay with his
court
opening.
takes.
Let's just see.
The first time you violate the rule, you may be subject to forfeiting your right to be present, where you will give the closing argument from the other courtroom. And if you continue in a blatant disregard of the requirement that you not reference in any way jury nullification, I may make that final determination outside the presence.
The DA is trying
I
to
object
protect
that, Your Honor.
any conviction.
All right, with that, let's bring the jury
For the
out.
record, may I respectfully request the legal reconsideration of your ruling?
Denied. All right. Will Brooks get his closing argument with 22,000
Tacit
votes?
agreement that you don't have to
74%
answer
said
my
no.
question, Your Honor.
25% said yes. I don't know if he'll get his full closing.
Inclined to reconsider.
She's bringing the jury in. The DA was
I
the only
reject
one
that
who could
ruling
bring
and
that
take
up.
Exception to that ruling.
Great.
Your Honor.
The DA was the only one who could bring that up because it's their case.
For the record.
And they
For
would be the
record,
ones
may I
asking for a
request
mistrial
legal
based on his
factual
shit.
basis for your ruling, Your Honor.
Denied.
For the
I want a
record, may
cookie with my
respectfully
objection.
request a written judicial finding of facts and conclusion of law on this issue, Your Honor.
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on
This
this
is not the
matter?
right venue.
I'm not the court to address that.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction, which this court has no subject matter jurisdiction.
Denied.
I think it depends on my
Under-
supervisor.
Based on
Jury's
what
coming
law
in.
or
All
fact?
eyes for the jury, please.
Based on what law or fact?
It's my understanding that this DA in court is the elected DA, so they don't have to run that by anybody,
Going to
which is helpful.
inform the jury of their power. They deserve to know.
Yeah, he's just going to fuck around and find out. But the DA had the authority within their chain of command to say, this is what we're willing to try. So would that have made me nervous without running it by a supervisor? Early in my career, yes. Later in my career, maybe not. But later in my career, when you have 6 deceased victims and 60 others, would I have would we have wanted to run that decision up a chain? Maybe. But I also worked in a very different DA's office. They don't have to run it up the chain. This is the chain. The chain of command is
Go
sitting
ahead,
at the
Mr.
table
Brooks,
trying this
closing
case,
argument, please.
which I respect tremendously when the elected DA is the one in the courtroom trying that case. That lets the people of the county know who they've elected.
It's been a long day.
No fucking shit.
First off, I'd just like to start by
Thank the jury.
letting you guys know that it's a lot of information that you guys should be privy to, I believe.
Here we go.
And one thing that I believe that you have not been privy to is the truth of your rights and your duties,
Objection.
being the jury.
Okay, they're just ready to
Fact that
object.
you and you alone have the power,
Fair.
not well-prepared DAs with well-prepared and clearly rehearsed speeches and exhibits and a lot of theatrics.
They're lawyers. That was not theatrical.
Frankly, not the judge.
Yeah, the jury decides.
You and you alone
Fair.
have the power. You and you alone
Decide.
decide what is truth and what isn't truth.
Fair. That's fair.
You should be informed that
She's
you
waiting.
have the power
They're informed.
to nullify any law that
Yep.
you don't agree with.
Objection.
Objection, move to strike misstatement.
Misstates the law.
Sustained.
Objection.
I will strike from the record the last.
That misstates the
Statement
law.
made by
He's
the
allowed to say
defendant.
you have the power to
Just
decide this
disregard it.
case. You have the power to
Which is
determine what the
clearly
facts
what I've
are.
been saying.
You have the power to decide. He can't say nullify.
I believe that not only is it fair, but it's essential that
Look at them. Look at them.
you be privy to all knowledge,
Look at this jury.
not knowledge that certain people feel that you should hear and shouldn't hear,
That's not how this works. It's the law.
disguised under the color of law.
This is not going to help him.
The fact of the matter is, just like I did with my opening statements, I don't have a well-prepared or rehearsed speech.
You had nothing but time, my guy.
I didn't look in the mirror and say certain points to myself over and over again to make sure I have them right or anything like that.
You're assuming
I've
that the
chosen
DA
to
did?
speak from the heart
Okay.
in my opening statements, and now I'm going to speak from the heart.
Do it. We'd like to see it. Go for it.
What you won't hear me do is argue facts.
I can try to turn this up a little
And the reason you won't hear me argue
because
facts
he's standing up.
is because I believe that it takes away from what should be recognized.
That the law is
The
illegal.
tragedy of this event. It should be recognized. Trying to argue facts of this, facts of that,
You can't argue the
I'm not
facts.
gonna waste your time doing that.
They're not on your side. What's the tragedy, sir?
It's a little emotional. I apologize for the long pause.
That's theatrics. That's theatrics. You accuse the DA of theatrics.
It's hard to keep everything together emotionally.
You were fine watching the
Honestly, I
video.
don't believe that I have any more tears left. It's been a hard year
Let's hear more about how hard it's been for you.
for the families, mostly. And that should not be lost on anyone. It shouldn't be taken away.
Now he's arguing sympathy, which he really shouldn't be
I said it
arguing
before,
either.
And I'll say it again. It's a lot of people that are healing, that are attempting to heal.
Arguing sympathy really doesn't work, sir. They're not going to object, but you shouldn't. Y'all chat, thank you for not name calling or diagnosing. I know it's
That
hard.
opens the door to talk about forgiveness for a little bit.
Oh, you want to be forgiven?
With every healing process, there comes
I didn't have that on the bingo
forgiving
card.
process.
You want the jury to forgive you. That's arguing
It's
sympathy.
not an
They
easy thing.
should probably
for
object at some
anyone.
point. He has nothing of substance to say. He can ask for mercy. I no,
What
he
you've
really
been
can't.
hearing
He can't argue for
from
mercy.
The prosecution, and not to take anything away from them, but
You just tried to belittle them.
let's call it what it is. You've been hearing a lot of rerun. Same things over and over and over. No different than
That's rich.
when you turn on the radio and you first hear that song that you don't like when you first hear it, but they play it so much that eventually you start saying it, the words to yourself before you even realize it.
That's not a bad
And
analogy.
then you sit and you go, I hate that song. Why am I singing it?
Grounds.
That's what's been happening. Rerun,
No.
over and over and over and
Yes,
over and over
every
and over
time
and
you
over.
talk. This is rich.
Attempting to make things stick in your head that simply aren't true.
That misstates the facts, but it's argument.
Why do I say, what am I saying? I say, look at the testimony.
Good. Let's talk about the testimony.
The thing from the prosecution here has been intent, 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 intent.
It's the most, well, the rest of it kind of speaks for itself, doesn't it?
We all know what's been said. We all know the picture that's been painted.
It's not a picture. Look at them. Look at this jury.
Even the prosecution said themselves.
Look at the jury.
How can you look in somebody's head and say, this is what they intended to do?
By their actions. Arguing intent is his best bet.
For a year, I've sat and gone through this.
What?
Feeling so powerless.
You can object.
Letting other people run with the narratives.
You could have testified.
Sitting back helpless while other people paint a picture that has zero truth.
Then testify. That
Zero.
misstates the facts.
I understand about healing myself, tragedy, pain, all that. A lot of it, there's no need to get into.
I wonder if the
I
prosecution will
myself
waive
in my
his
own
rebuttal.
life have had to do a lot of healing. As a man with children myself,
He's trying to humanize himself to this jury.
I find it hard to believe
There were kids who were victims. Kids.
that anyone who's really had conversations with me, spent time around me, would
This
think for 1 second
is getting a little far afield.
that this is an intentional act.
They could have
I've
objected. They're
never
not going
heard
to.
of someone intentionally trying to hurt someone
Sir,
while attempting to blow their horn.
sir. You could have testified.
While, attempting to alert people of their presence.
Sir, you are now getting very close to testifying and they can object.
Which brings me to
They could object.
more information that I believe that you should have been privy to.
Red alert. Red alert. At least he gave them a heads up that fuckery's coming.
And I'm sure that the prosecution will
Object
beg to
immediately.
differ. But the fact of the matter is,
I haven't had a fair trial. Is that what's
vehicle
coming?
in question, make a model of 2010,
No. Do not bring
Ford
up.
Escape.
Don't bring up the recall.
The vehicle in question,
Objection.
actually 2008, 2009, and 2010 of that model was in fact recalled.
Objection.
Objection.
Misstates
Misstatement
of the facts.
not
Assumes
Was
facts,
it
not
facts?
evidence.
Argument, Your Honor.
Sustained.
Was in
Strike
fact
it.
recalled.
Strike it.
Was in fact a class action lawsuit against
Ah!
Ford
Objection.
for those model vehicles.
Sustained. The juror will disregard.
Information
No.
that
Move on.
you should have been privy to,
Make him move on.
that you weren't allowed to be privy
Make
to.
him move on.
Why? I don't know.
Make him move on.
That information.
He's just going to keep talking over the judge.
malfunctioning throttle box.
No.
Mr. Brooks, move on.
It's information that you should have been privy to.
No. He is misstating the law. No.
Vehicles that malfunction and accelerate, not being able to be stopped.
Objection, that is.
It's
completely
information.
inaccurate.
It's
Mute box.
information.
Objection. Hold on.
Remove the jury.
Go ahead.
Remove the jury immediately.
Statements by Mr.
Sorry for the
Brooks.
interruption.
They are facts, not an evidence, Your Honor, and it's a complete misstatement.
Sustained. Strike
How's it a
the-
misstatement when I have
Remove.
the information?
No. No.
Mr. Brooks, move on.
Move on. He's not going to
This
move
is
on.
information that
Yeet. Yeet.
I feel like you needed to know.
The
You
jury
should
is
have known.
there. Yeet.
Information that was taken away from you.
That information
Why?
was not
To prove
taken
the
away
case?
from them.
Information that you definitely should have been
No.
privy to.
He's not moving on, Your Honor. He is not moving on. The prosecution has been much more restrained than I would have been. At that point, I would have been like, nope, 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 I'm done. But the prosecution can see the look on the jurors' faces that we can't see. Because the
DA says
all of you that are pissed about this, the jury might be too. They know what evidence they
defendant
heard.
has an utter disregard for human life. Utter disregard for human life.
Look at them when you say it then. Is somebody getting up and walking out?
Not realizing that they're talking about someone that has children.
You didn't testify. Look at this
Talking
jury.
about someone that watched their children come out of the womb and be born into this world, cut the umbilical cord,
And
held them before their mom even did.
you didn't testify. They could have objected to this too.
Moments that I'll never forget.
You'll never forget the
And
birth
yet
of
they
your
say
children.
disregard, utter disregard for human life.
They've charged you with killing 6 people and injuring 60 plus more. You drove through other people's children. Utter disregard is what you say. The jury is going to be just as angry as the chat is. Chat, I understand you're angry. Thank you for not name calling.
They made reference to a rage,
It was my rage.
as if they
Because despite all my rage,
or if this
I am
particular
still
DA
just
was
a
right there,
rat in a
standing right
cage.
there, As if this DA is a psychiatrist.
Oh, I'm pretty sure they think they're
I
not.
said to myself, what rage? What do you mean rage?
You could have testified, but you didn't. But you're trying to now.
How can you characterize that?
By your actions?
How can you have the audacity
Over it, withholding rage.
to diagnose what someone's brain is?
Just-
where it's at, what it's thinking,
It's-
why it thinks the way it does.
It's argument, sir. But you're pissing off a whole lot of people with this closing, I'll tell you what.
DA makes references to
The government's
blocks
bad.
of no one being injured,
The DA's
but
bad.
then says it's intentional. You add that up with the supposed rage,
The supposed rage.
the supposed intent to harm and kill.
Just say it. They don't even know what they were talking about. They weren't even there.
And it doesn't kick in until well within blocks.
Sir? No.
Maybe it's just me, but I would think if I was characterizing someone with this intent to kill and this rage and this anger,
We've seen it. We saw the looks you gave the judge.
then why weren't people immediately harmed? Why would someone with
That's a
intent to kill and
fair
rage
argument.
try to alert people of their presence, repeatedly honk their horn?
That
You heard a
mistakes.
detective, if you recall, testify that
He's trying to get to the intent element and argue that there's no
the
intent for
vehicle
first
that
degree
he
murder.
observed was not only honking his horn, but was not speeding.
This is not a bad argument. If the defendant's not in a rage,
So where does this rage kick in?
look,
Where does this
an offensive but cogent
insatiable
argument.
intent to kill kick in?
A cogent argument. Look at that. Weird.
They speak as someone who's known someone for years.
Look at the jury. Wait, is he talking about himself in the third person?
Which brings me back to the vehicle. What if the vehicle couldn't stop because of the malfunction?
Objection.
Fact, not in evidence.
What if the
Disregard.
driver of the vehicle was unable to stop the vehicle?
Objection. You could have testified, but you would have been cross-examined, and you know
Because of that fact, what if the
What
driver
if?
may have panicked?
What if is not an argument? I mean, what if technically is an argument?
Does that make the driver a crazed, or not crazed, a
Rage.
rage?
Rageful.
Does that make the driver in a rage and intent on killing people? DA played a exhibit 17. You don't see anyone struck in that vehicle. On that exhibit, you don't see anyone struck.
Oh, they've seen the video where people were struck.
Was someone who had this intent to kill, this rage, as she says. If that was their intent, wouldn't they have taken the opportunity to hit as many people as they could?
That's a fair argument.
Target people, mow down people.
It's a fair argument. If the intent was to kill, why not kill everyone? And that's probably what his defense attorneys would have argued.
Reference was made to this vehicle, the damage. Says this was all caused by bodies, but then later turns around and says hits barricades and other objects. For her testimony about hearing
A
loud
fair
crashes and things
argument.
of that nature, but the DA wants you to believe that this all came from people. Evidence doesn't support that.
Rage. Look at him arguing what the evidence supports. It just reminds you at
If I
how
go back to
manipulative he
trying to
was
wrap
throughout
my
this
head
trial.
around everything that's happened in the last year.
Ridiculous.
Praying for those families, praying for the people that tragically lost their life, because that should not be lost either.
That tragically lost their
The
life.
fact that there was lives lost, and all the emphasis has been put on the alleged defendant.
Where else would you put the
and
emphasis?
People have been disregarded. Makes me wonder, does the DA even care about those people?
Are you fucking kidding me? Oh, the
And
rage.
prayers going up every day.
The gaslighting. Just
It's been suffering on both sides. It's been threats, hate mail. Because of the narratives that's been put out there. The misconceptions that have been put out there.
you could have
The
testified.
lies that's been put out there.
Objection. I would have objected. I would have
Lies
absolutely.
that have
Objection.
caused my children not to be able to go to school. To be bullied.
This is hard for you?
For my mother to have to leave her home and stay at a hotel because she's afraid for her safety.
Objection.
Because she gets
None
hate
of this
mail
is in
shoved
evidence.
through her mailbox.
His mother shouldn't get hate mail.
My nieces and nephews to fear for their safety.
This is an argument for appeal that he couldn't get a fair trial in this venue. Isn't it awful that the people that you're close to are so impacted
And what's
by
been
what
equally hard.
you're accused of doing?
It's not only having to answer the questions from my daughter, who was 7 at the time.
I'm glad
My
we get to
baby-
learn how
my
hard
baby
this is
girl,
for
who was
you.
7 at the time.
The families in the
Now,
courtroom must be outraged. The jurors who just watched that video are probably outraged.
Attempting to answer her questions that she's asking, and still continue to shield her from what she sees, what she hears. Having a newborn son
You should have thought of he's asking for mercy. You should have thought about
that I
that
haven't even been able to meet,
during this trial.
haven't been able to hold, touch, kiss. Having to navigate everything that comes with this whole situation.
He's trying to say the vehicle wasn't working.
While still attempting to wrap my head around it. I can't honestly say how many times I've sat in my cell,
Oh, no, he's talking about being in custody.
especially during lights out, alone, where it's just you.
Contemplating your life choices?
And just been praying and asking myself, how could this happen?
That's what everybody on the jury wants to know is how did this happen? You could have
Not
testified.
just
You
for the
did.
people. but for everybody involved, the community too. How could this happen? How?
You could have testified and explained it. You
The
didn't.
hardest questions you can ask is those that don't have an answer.
Oh, there's an answer. He is testifying. The DA is not
No
objecting.
matter how much thinking you do, no matter how much you try to
The DA has shown tremendous restraint,
look at it from different perspectives and
but he's testifying.
listen to other outside perspectives and listen to people that you trust and that you love,
He might just keep talking till his hour's
still
up.
coming up with nothing.
He is not adhering to all the rules of a closing, but we knew that was going to happen.
But to think for 1 second,
His
one
demeanor
question
is so
I
different.
never had to ask was if this was intentional. That's something that I never asked
He's
once
testifying now, and they should object.
because I know it wasn't.
Objection. He could have testified and been cross-examined, and he didn't. He can't testify now. And they might need to do a
As a
curative
matter
jury
of fact,
instruction.
it never even crossed my mind to even attempt to ask myself that because I know it wasn't.
It's a little too far for me. But I think he's admitting that he's the one driving. She does need to make a note of that because that needs to be
And I
direct.
know sometimes during this trial probably doesn't show.
There needs to be a curative instruction on that.
May be hard to believe. But trust me when I say
No.
one outside of the families that had to go through this, no one's heart is more in pieces than mine.
Sir. The DA is going to have to ask
So
for
again, I
parts of
go
this to
back
be
to all
stricken.
these exhibits.
He gets an hour. I don't think this is going to gain him the sympathy he thinks it is.
Go back to everything that's been shown, everything that's been testified to.
I brought cookies. I didn't bring enough for the class, I'm sorry.
Everything you've heard during this whole process, this trial.
Kelly, I hear you.
And again, I say the same thing that I said earlier.
This is his
Same
community
thing I
too.
said in opening statements. I'm not reading from any paper.
Which doesn't
Books.
matter.
Everything you've heard in opening statements, everything you're hearing now is from right here.
Okay.
Everything.
And
You have the decision.
facts. I don't think there's any intent
You
here.
and you alone. All of you.
I ask you
You
for a
have the
verdict of
decision.
not guilty and sit down.
I'm sure you've taken a lot of notes during this process. Some days are longer than others.
Yes.
A lot of movement in and out of the courtroom for various reasons.
For you, because of you. It's because of you. You. Those are black and white cookies from Trader Joe's. They're very good. I think they call them Half Moon.
Remember the power that you have.
Okay. I don't think that's going to go in your favor.
Don't for 1 second let it be taken away from you.
I wonder what kind of looks they are giving back to him.
I can never understand the position of sitting on a jury in something of this magnitude. So I'm
Just-
sure there's a lot of pressure.
Deciding someone else's fate, perhaps?
I pray that the right decision is made.
I think your definition of right decision
The right decision.
and their definition of right decision might not be the same. It's a different look than earlier.
It's almost like that message.
Are you going to quote the Bible? You've been reading it a
Message with
lot.
That writing. When we're in our vehicles and we have that rearview mirror and it said things are closer than they appear. But it's also another way of saying sometimes things aren't as they appear.
I think they could object to that as being stricken. Insinuating that things are hidden from the jury is improper. Insinuating that the jury doesn't have the full evidence is improper.
I can't speak for anyone else, but me, myself, I believe in Jesus Christ.
Great. And
That's how I was raised. That's what I believe in.
you're going to offend the Christians on the jury.
None of us are perfect. But I try every day to make sure that I acknowledge him. That's why every time I step in this courtroom, I have my Bible with me everywhere I go. I even read it on breaks, recesses.
I think the jury's
This is not something that started at the beginning of this incident. This is something that has been instilled in me since I came out of the womb.
I don't
This
think
is how my family lives their life. This is how we was raised.
I don't think this is going to go the way you think this is going to go. You drove through a Christmas parade. I don't know why you're bringing Jesus into this.
For whatever mistakes that I myself have made in my life, I've made peace with God.
Yeah, salvation is about all you got at this moment.
Made peace.
Great. He's at peace, ladies and gentlemen. You are welcome to not consider sentencing in your conviction of this defendant because he has made peace with his personal Lord and Savior, Jesus Christ. Great.
I'm happy to say that my conscience is clear.
What? My conscience
And because I believe,
is
I trust him
clear.
with my life.
We don't.
Nobody will never know why it was his will for this to happen.
I'm sorry. What? You are blaming Jesus?
A lot of lives were changed that day, mine included.
What?
God's way is not our own.
God's will is not our own?
Sometimes we want to question. We have to have faith.
This jury's going to have faith in their decision. I have never, ever, ever, ever heard that as a defense. Yeah. I appreciate all of the Jesus Take the Wheel references. Thank you for helping me break my mood. The anger I am feeling at the moment. I am really trying.
Look inside yourself.
Oh, they're not going to have to look very deep. That rage is brimming right under the top.
Look inside yourself and make the right decision.
I think they're going to be good with it. If your conscience is clear, their conscience is clear. We're all good. I think everybody's going to feel good at the end of the day. I don't mean that way, but I think they're all going to feel settled with their decision. You can try to stare them down.
Inside your heart.
I just want to yell, he's not a Christian like Peter Mon. But it's too snarky for the moment. You can hear it in your head.
You have everything in your hands now.
Yep, sit down. He can ask for a not guilty verdict. I don't know if he's going to. He said the DAs were dramatic, but
Everything. He
yep.
was right.
Okay, Bragg. Queen. Thank you.
Dude was right.
This is the statement we all needed. Chat is bae. He looks more.
Don't let the smoke and mirrors
Oh, fuck.
take away your power.
He looks more angry.
Don't let the theatrics take away your power.
You just blamed God. Who's theatrics? You waved a Bible at them. Who's theatrics?
Each and every one of you has
Those DAs could have been way
Decision.
more theatrical, and they weren't. They were refrained. They were positively Midwesternly restrained. Not once did they say he murdered children. Refrained. They were positively refrained.
Dude was right.
Great. You can ask them for a not guilty verdict. You can say no intent was
Make
proven.
the right decision.
You've said that 6 times. I think they're going to feel like they made the right decision. Sit down. I don't think we've hit a time limit yet. He's thinking about what else he wants to say.
It's hard to think about.
He should have just stopped.
My younger kids getting older and at some
Objection.
point having to explain everything to them.
This is improper. It's improper argument.
Kids don't stay kids forever.
And this trial was on the internet, sir.
And nowadays, kids is frankly a lot smarter than we were when we was kids. I'll tell you that much.
And
I got a letter the other day.
nope. Objection. Improper
My
argument.
youngest daughter,
Objection. Improper argument.
and
Objection.
She's still learning cursive right now, so she's the best writer when it comes to cursive. She's
Objection.
rapid friend.
Do they really just still teach cursive? My kids didn't learn cursive. This is all improper argument. And the DA is also being restrained.
She said, Dad,
This is all improper.
and this is from the letter. She said, Dad,
Yeah, that's not admissible. None of this is relevant.
why are
And
people saying all these mean things about you?
why are people saying mean things about you? What? Because I'm accused of killing 6 people and injuring 60 plus more? Is this your
I haven't read the rest of that letter yet.
daughter with Erica? One of the victims in this case? Is that your daughter with her?
The rest of that sentence said,
No, you just said you didn't read the rest of the letter. Are you just
"That's
making
not
this
the
up?
Dad I know."
You just making this up? You said I didn't read the rest of it, and then you're saying what the rest of it said.
Throughout this year, I've been called a lot of things.
I don't doubt that.
And to be fair, I am a lot of things.
Isn't this the argument that Amber Heard made? People are mean to me and I'm
Murder
getting
is
death
not one
threats?
of them.
Are you trying to argue you're a good guy? You've argued
Never
you're
has been, never will be.
I'm a Christian and I'm a good dude? Is this your closing? This is the end of your closing? This is frustrating to watch. Give him a time check. Just, sir, 5 minutes. Aren't we done?
So before I close my
Closing.
statements,
I also wish I could speed up this closing, but we are watching
I
in
just
real
want to
time.
say, open your hearts.
To your Lord and Savior, Jesus Christ.
Go inside yourself when making this decision.
They're not going to have to go that far. The jurors were crying during the prosecution's closing. They're not going to have to go that far, sir. And if you had been in the courtroom, you would have seen, and then you could have read the room. But you're not looking at them, so you can't read the room, because I imagine the looks that they are giving back to you are ice. Which is probably why he keeps saying, open your heart.
I have no fear.
I don't think they're afraid.
Pray and do what you know is right.
Yeah, I think they will.
What you know is right.
Okay. I cannot wait to hear the types of looks he was getting back.
Think about everything you've heard. Think about everything you haven't been privileged to hear.
No, that's improper argument. Objection. That needs to be stricken. They can't consider things they haven't heard.
Think about the whole entire picture.
Yeah, they watched the video. my God, it's 5:22 Central.
And above everything, whatever you decide, make sure you yourself can live with it.
Huh. It's an interesting choice.
Make sure you can live with it.
It's a very interesting choice.
That's the magnitude of the power that you have. Just like this tissue is in my hand, this is
Another analogy.
everything. You have everything.
It's a song like that by Dave Matthews Band. Captain.
Be at peace with what you decide.
Oh, I think they probably will be. Because I think the chat's ready to convict you now.
No regrets.
I think they're at peace with that. He just literally said no regrets. At least he didn't say no regrets, but still.
Don't let this decision
Your conscience is
weigh on
clear.
you after it's over.
What regret are they going to have?
Hopefully we got a long lot of living ahead of us,
Yeah, your state doesn't have a death penalty, so there's that.
Lord willing.
Lord willing, this is a murder trial.
Don't
For
look back and kick
6
yourself in the behind.
I think he's arguing for guilt. This is a guilt argument. That's a guilt argument.
It's been about 3 weeks with you. And took a lot of courage and a lot of guts to pause your life for this.
He's talking about the jury's courage to show up and do their civic duty.
To put important things on hold.
Oh, is he going to thank them?
To basically stop your life.
Yeah, they did that.
You should be commended for being able to sit up here with this amount of pressure.
Maybe you could have respected their time just a wee bit
I
more.
want you
Sid?
guys to know that's not lost on me. I'm sure it's a lot.
Maybe a little respect for their time when you were busy arguing with
You
the
all
judge
should be
over
commended,
nonsense.
because it took courage to do this.
Okay.
I don't know, but I would bet a lot of people wouldn't want to be sitting in your position right now.
Oh my God. Are you trying to remind them of how unpopular their verdict may be? What are we getting at?
And you guys had the guts to do it.
I think they feel pretty strongly about being there.
Thank you for that.
The alternates are
Thank
going to
you
be
for taking
pissed.
pretty much a month and setting it to the side
This case wasn't supposed to take so
for
long.
this.
You doubled the amount of time with your nonsense. But the DA is going to get a rebuttal, but they're not going to finish jury instructions today. This jury's not going to
I know
deliberate
it's probably
tonight.
not proper, but you guys deserve a round of applause if you could get one.
Are you done? Because I don't think you can read the room.
Thank you guys sincerely. And I know, and I have faith and I trust that you guys know what's right.
You've said that like 6 times.
Ladies and gentlemen, I don't think it's fair to just say guys, but
Actually, it is kind of fair. I got yelled at once for a judge by saying you guys about the ladies and gentlemen of the jury. I think you guys is fair. Truly.
I believe in your heart you know what's right.
I believe they do too. We're all in agreement. You've talked about the DA talking round and round and round. Okay.
Thank you, sir.
They're going to take
Before
a
I
break.
give the state an opportunity to present rebuttal, please stand for a minute, so please stand.
Oh, they're going to take a comfort break. The state's going to have a chance for a rebuttal. There's like 2 hours of instructions left. That's delightful. There's a lot of jury instructions left. It's 5:25. This jury is sequestered tonight. They might not get to start deliberating if this judge doesn't finish jury instructions.
And Attorney Opper, I did time both closings. You have 13:28 left.
The instructions have to be finished before they can
Thank you, Judge.
deliberate.
I don't think that'll be an issue.
There's 13 minutes left for the prosecution. You can only consider the evidence.
Folks, let me just say this.
Folks works better than you guys in the Midwest, I think.
Mr. Brooks stands here and professes to speak to you from his heart. He plays on your sympathy.
It's the Midwest,
Talks about
y'all.
his children. He talks about the hardships that he's encountered.
They're going
and
to talk
his
about the
family's
victims.
encountered. And he brushes over the loss to the community. He wants to talk about how he's never held his newborn son. Never once acknowledges the Sorensen family,
Yep.
the Owen family, the Duran family, the Hospital family,
Yep.
the Kulik family, Sparks family. Never once. It's nice that Mr. Brooks can get letters from his loved ones.
Yep.
I don't know why he did this. I told you that. But actions define a person. It's that simple. You can stand with the Bible in your hands all day long and profess to be the finest man under God that you can be. But when you drive through a parade route and roll over children with band instruments to the extent that your vehicle heaves up and down, your intent is known, Mr. Brooks. It doesn't have to be guessed. It's known.
Yep.
You don't have to stand and wonder as he claims to. For him to keep going after he drove over those children in the band and have Jackson Sparks fly off the front hood of his car, lifeless, and keep going. And have Jane Kulik fly off the hood of his car, run her over, and keep going. I'm not going to go on. You get it.
She can probably
You
see it
need to look in
on
the
their
mirror,
face.
Mr. Brooks. If you want to accuse me of practicing my closing argument, you need to look in the mirror, sir. Your actions are that of a murderer. You murdered these 6 people. You endangered the safety of 61 others. There are 68 victims in this case, folks. That's not an accident. That's not a, gee, I woke up one day and don't know how I found myself in this position.
That's intentional murder.
If you have some explaining to do to your children, Mr. Brooks, I recommend you do it.
Yes! I hit the table. That was me. Oh, you don't get to say shit. Sit.
Now, members of the jury.
That
the
was a
duties
good
of the
rebuttal.
parties and the court have been performed. The case has been argued by the parties. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the
God.
great burden
There's
of reaching
so
a
much
just,
more.
fair, and conscientious decision of this case is to be thrown wholly upon you, the
There's
jurors,
so many more
selected for this
jury
important duty.
instructions left.
You will not be swayed by sympathy, prejudice, or passion.
I'm going to go full
You'll
screen.
be
I
very
have to run to the
careful and
restroom.
deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 76 forms of verdict will be submitted to you concerning the charges. against the defendant, Darrell E. Brooks. Count one. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count one of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count one of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count two. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count two of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count two of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no.
She's going to try
Did
to
the
get this to
defendant
this
commit
jury
first-degree
today.
intentional homicide while using a dangerous
These
weapon.
are different
Count three.
jury instructions.
One reading, we the jury find the defendant, Darrell
This
E.
is not
Brooks,
all of them.
not guilty of first-degree intentional homicide
She's
as
going
charged
through
in count three of the information.
All of the
Another
verdict
reading,
forms.
we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide
Every
as
single
charged in
form.
count three of
I'm
the
going to turn her down a
information.
little bit.
If you find the defendant guilty of first-degree intentional
This is all the
homicide,
verdict
answer
forms.
the following question, yes or no. Did the defendant
So she went through
commit
the instructions,
first-degree
she's going through the verdict
intentional
forms.
homicide while using a dangerous weapon? Count
His closing. Yeah, she said it's
Count
30
four.
pages. That's probably right. I'm gonna go through
Count four.
questions.
One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional
Also,
homicide. as
hey
charged
to the
in count four
38,000 of
the
you here on
information.
YouTube, and hey to
Another
the
reading,
1,500
we,
of
the
you
jury,
over on the
find
Facebooks.
defendant,
Do the
Darrell E.
YouTubey
Brooks,
things.
Guilty of
Thanks.
first-degree intentional homicide as charged in count four.
I will
of the
try to get to as many
information.
super chats as I
If you
can.
find the defendant guilty
And
of first-degree
questions.
intentional homicide, answer the following question, yes or no.
They're going to have to go through
Did
each
the
one.
defendant commit first-degree intentional homicide while using a dangerous weapon?
After the
Count five.
reading, the
One reading, we,
jury
the
will
find
be
the defendant, Darrell E.
dismissed
Brooks, not
to
guilty of
deliberate.
first-degree intentional homicide
Once she
as
gets through the
charged in count five of
charges.
the information.
Oh, now he's reading his
Another
Bible.
reading, we, the jury, find the defendant,
Once
Darrell
we
E.
get through
Brooks,
the
guilty of first-degree
these
intentional homicide as charged in
verdict
count five of
forms
the
and we get to the
information.
final instructions
We
to
find the
deliberate,
defendant guilty of
I'll stop
first-degree
talking so we could do that.
intentional homicide.
That was a
Answer the following
great,
question, yes
I'll
or
give you
no.
my thoughts on the rebuttal. I
Did the
thought that was a
defendant
great
commit
rebuttal.
first-degree intentional homicide while
Newsflash,
using a
great
dangerous
rebuttal.
weapon? Count six. One reading. we,
That'll be the
jury,
jail
find
that
the
determines where he'll be
defendant, Darrell E.
housed.
Brooks, not guilty of
They'll
first-degree
determine what's best for his
intentional
safety.
homicide as charged in count six of the information.
What I know a lot of the
Another
custody
reading, we,
custody
the jury,
locations
find
are
the
doing is
defendant,
keeping people
Darrell E.
pending
Brooks,
trial
guilty of
separate
first-degree
because of COVID
intentional
precautions.
homicide as charged in count six
So
of the
that'll be really
information.
up to them. He's
If you find
been,
the defendant guilty of
since he's
first-degree
representing himself, they
intentional
generally get
homicide,
housed
answer
somewhere
the
different where they have more
following
access to their
question, yes or
papers
no.
and stuff.
Did the
So
defendant
that'll
commit
happen probably till he
first-degree
goes to prison
intentional
or
homicide
till he's
while
sentenced
using
and
a
then
dangerous
transferred
weapon?
out to prison.
Count seven.
Does this jury reach verdicts
One reading, we, the jury, find the defendant,
before the jury
Darrell
room?
E.
The
Brooks,
jury
not guilty of first-degree
can deliberate at the
reckless
hotel.
endangering safety as
This
charged
jury
in
can
count
deliberate
seven of
wherever
the
they want to.
information. Another reading, we, the
Thank you
jury,
for your
find
time
the
as always,
defendant,
Kelly. I
Darrell
really
E.
enjoy
Brooks,
doing live
guilty
trial
of first-degree
coverage,
recklessly
even though they're
endangering
long days.
safety
It's a huge thank you
as
to the
charged in count
mods,
seven of the information.
to Miguelina,
Find
my
the defendant
producer.
guilty of
These are long
first-degree
days.
recklessly endangering safety.
It's on the record
Answer
that he
the
never
following
touched a
question,
Bible.
Yes or no? Did the defendant commit first-degree
He's reading it
recklessly
now.
endangering safety
Kelly,
while
thank you
using
for
a
the super
dangerous
chat.
weapon? Count eight.
I don't think he
One
helped
reading,
himself.
we, the jury, find the
He doesn't have
defendant,
contact
Darrell
with
E.
his
Brooks,
kids and they
not
don't have
guilty of
his
first-degree
last name.
recklessly
Wish the
endangering
prosecution could
safety
put
as
that in.
charged in count
They
eight of
can't
the
because he didn't
information.
testify.
Another reading, we, the jury,
They could
find
have
the
objected, they
defendant,
didn't. They
Darrell
were
E.
very
Brooks,
restrained.
guilty of first-degree recklessly endangering safety
Never
as
once said the
charged
words,
in
"I'm
count
sorry,"
eight
that's
of the
right.
information.
Because he's saying it
If
wasn't
you find
me.
the defendant
And
guilty
if it
of
was, it was the
first-degree
car.
recklessly endangering
And if it wasn't the
safety,
car, it
answer
was
the following
God.
question, yes or no.
Or
Did
Jesus.
the defendant commit first-degree recklessly
Take your
endangering
pick.
safety while using a dangerous weapon? Count nine. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety.
Yeah,
as
I don't think
charged
the
in
DA
count
needed
nine
much
of the
more. They saw, the
information.
jury
Another
saw that
reading.
video and
We, the
cried.
jury, find the
Not much
defendant,
more is
Darrell
needed.
E. Brooks, guilty of first-degree recklessly endangering safety as charged in count nine of the information.
If a jury member were upset at
If
what
you
he
find the
said
defendant
and were to
guilty
show it by
of
flipping him off,
first-degree
would that have an
recklessly
impact?
endangering safety, answer
The evidence
following
is
question,
closed.
yes or no.
So
Did
it
the
could, they
defendant
could be
commit
removed.
first-degree recklessly
In this case, they might be
endangering
for
safety
safety,
while using a
but
dangerous weapon?
It's generally not
10.
advisable.
One reading, we the jury find the defendant, Darrell E. Brooks,
Oh, thank
not
you.
guilty of first degree.
Yes, we
recklessly
do have over
endangering
30K
safety,
watching.
as charged in count 10 of the information.
Lindsay's like, and may peace be
Another
with you in
reading,
jail.
we the jury find the defendant.
This is a
Darrell
sentencing
E.
statement,
Brooks,
not a closing argument.
guilty
That's
of
very
first
fair.
degree recklessly endangering safety,
He
as
can't
charged
make
in
that
count
sentencing statement to the
10 of
judge, though, because the
information.
judge knows his fucking
Find the
fuckery.
defendant guilty of first degree.
The judge has seen it all. He can't beg for mercy with the judge that he's, no.
Did the
Hey,
defendant
Runkle.
commit first degree recklessly endangering safety while using a
They
dangerous
need to hurry up and send him to jail. We've got a watch party to schedule. We do have a legally
Either
blonde
jury
watch party
find
to
the
schedule.
defendant, Darrell E. Brooks,
We
not
absolutely
guilty
do.
of first degree recklessly endangering safety as charged in count 11.
I'm
of
sorry I'm
the
sitting here so hard on you
Another
today,
reading.
sir.
We the jury find the
You
defendant, Darrell E. Brooks,
wasted
guilty
2.5
of first
hours
degree
today.
recklessly endangering safety as charged in count 11 of
Oh,
the
you're welcome,
information.
Melissa.
If you find the defendant guilty of first degree recklessly endangering safety, answer the following
JL, I
question,
get the
yes or no.
impact it would have for the
Did
DA to play that
defendant
video
commit
again, but
first
the
degree
DA does not
recklessly
want to do that
endangering
to the
safety
jury.
while using a dangerous weapon?
Whenever you
Count
have
12,
really graphic
one
stuff,
reading. We the jury
it's
find the
hard
defendant,
to put
Darrell E.
people through
Brooks,
it.
not
I
guilty
imagine the
of first
prosecutors
degree
in like
recklessly
the
endangering safety as charged in count
Duggar
12
case
of the
apologized to the
information.
jury for what they had to see.
Another reading.
As a DA, it made me feel I felt bad. Like, I'm sorry I have to ask these questions. I'm sorry I have to show you these photos.
If you find the defendant guilty
You
of
feel
first degree
bad.
recklessly endangering safety,
So I
answer
don't
the
think they'd wanna
following
put the jury through that
question, yes or
again.
No. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 13. One reading.
This
We, the
judge,
jury, find the
I
defendant,
think, could have
Darrell E.
controlled the
Brooks,
courtroom
not
better,
guilty of first
but I
degree
think she's been
recklessly
very
endangering
careful
safety
and very
as charged in
mindful.
Count 13 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly
The jury,
endangering safety.
it's going to take an
as
hour
charged
to
in
read these
count
verdicts,
14
if
of
not
the
more.
information.
The jury can
If you find the
absolutely take an
defendant
immediate
guilty of
poll.
first-degree
And if
recklessly
they all agree, they
endangering
can.
safety,
They have to go
answer the
through
following question,
76
yes or no.
different charges. So
Did
an
the
immediate
defendant
poll
commit
on each
first-degree
count
recklessly
will
endangering
probably
safety
take them an
while
hour,
using a dangerous weapon?
if not more.
Count 14. One reading. we,
Jury
the
for a person.
find
Everyone
the
meet at the
defendant,
bar. Bring a
Darrell E.
pen.
Brooks, not guilty of first degree
Fair.
recklessly endangering safety.
Morgan Tremaine
as
tweeted
charged
that
in
guilty
count
people
14 of
sure
the
like to complain
information.
about the jury not
Another
being given
reading,
mystery
we, the
evidence.
jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 14 of the
Morgan, that's
information.
cheeky. I don't
If you
doubt
find
that
the
at all.
defendant
That's
guilty
very
of first
cheeky.
degree
Thanks for the
recklessly
laugh.
endangering
Thank you for letting me
safety,
know.
Answer the following question, yes or no.
He never said I didn't
Did
do
the
it or he was
defendant
sorry.
commit
No.
First degree recklessly endangering safety while using a dangerous weapon.
There is proof of
Count
intent here.
15. One reading,
Intent
we,
is
the
always
jury,
by
find the
circumstantial
defendant,
evidence. I think
Darrell
there's
E.
plenty of
Brooks,
proof of
not
intent here.
guilty of first
Plenty of
degree
circumstantial
recklessly
evidence of
endangering
intent.
safety as charged in count 15
Was
of
that the
information.
Jesus take the wheel defense?
Another reading.
I think so.
We, the jury, find the
I think this
defendant,
was
Darrell E.
officially the
Brooks,
Jesus take the wheel
guilty of
defense.
First degree recklessly endangering safety as charged in count 15 of the information. If you find the defendant
I don't
guilty of first degree
think
recklessly
guilty
endangering
AF,
safety, answer the following
but if the
question,
jurors ever
yes
speak
or no.
after the case, they
Did
might
the
talk about how
defendant commit
this
first-degree
impacted them.
recklessly endangering
It's
safety
not my
while
fault, it's
using a
God's
dangerous
fault.
weapon?
It's God's fault.
Count
Who saw that
16.
fuckery coming? Not
One
only
reading,
is his
we, the
conscience
jury,
clear, but
find
really
the
it's God's
defendant,
fault. Yeah, it's
Darrell
not
E.
him.
Brooks, not guilty
This is really
of
all,
first-degree recklessly
this is the
endangering
God
safety as
version of the
charged in
Shaggy
count
defense.
16 of the
It wasn't me.
information.
Oh, my sky's doing
Another
weird
reading,
things.
we, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged
Tennessee
in count
keeps me on my
16 of
feet.
the information.
I gotta tell
If you
Dr.
find the
B.
defendant
I gotta be
guilty
like,
of
Dr. B, come here. The
first-degree
sky's doing
recklessly
crazy
endangering
things.
safety,
Not
answer
spinny
the
things.
following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 17, one reading. We, the jury.
I gotta
find the
tell Dr. B and my
defendant,
little one to go
Darrell
look
E.
at this guy
Brooks,
out front.
Not guilty of first-degree recklessly endangering safety as charged in count 17 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 17 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 18, one reading, we, the jury.
Sorry, I'm a
find the
nerd. I like
defendant,
weather.
Darrell E. Brooks,
I like
not
weather. I
guilty
need people to
of
witness weather with me.
first-degree recklessly endangering safety as
Moving to
charged in
Tennessee was
count
one of the best
15 of
things for my nerdy
information.
love of weather.
Another reading,
We have a
the
weather
jury find the
station in
defendant,
our
Darrell
house.
E. Brooks, guilty of first-degree recklessly endangering safety.
My favorite
as
Twitter
charged in
account
count
is
18 of the
Nashville Severe
information.
Weather.
If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety?
This
while
is the
using a
same judge that will
dangerous weapon?
sentence him. Yep.
Count 19. One reading, we the jury find the defendant.
This judge
Darrell
sounds
E. Brooks,
exhausted.
Not guilty.
But they
of
got through
first-degree
closing.
recklessly endangering safety as
He
charged
said
in
shit he
count
wasn't
19
allowed
of
to
the
say,
information.
but it wasn't
Another
that off
reading,
the rails.
We the jury find the defendant, Darrell E. Brooks,
So.
guilty of first degree recklessly
'Cause it's over now.
safety as charged in count 19 of the information.
It's over.
If you find the defendant guilty of first degree recklessly endangering safety.
It's just
answer
over.
the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 20. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree
rainbow out there
recklessly
somewhere.
endangering safety as charged in count 20 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first
Yes,
degree
this judge
recklessly
will do
endangering safety
sentencing
as charged in
if
count
there's a
20 of the
conviction.
information.
And this
If you
judge will
find the
need to
defendant
sit
guilty of
through
first-degree recklessly
all the
endangering
victim
safety,
impact statements, which will
answer the
be
following question, yes or no.
difficult.
Did the
I'm
defendant
surprised you didn't bring
commit
up subject matter
first-degree recklessly
jurisdiction. Me
endangering
too.
Safety while using a dangerous weapon.
He wanted to have
Count
his say,
21.
though.
One reading.
And the judge
we
was going to
jury
deny
find the
him of that.
defendant, Darrell E. Brooks.
She
not
actually had
guilty of
something to take
first-degree
away
recklessly endangering
that he
safety
wanted.
As charged in count 21.
It was
of
the only thing
information.
she could take away was his
Another reading.
moment.
We the jury find the
And he
defendant, Darrell E.
wanted
Brooks,
that
guilty of
moment.
First degree recklessly
That's the reason
endangering
he
safety
didn't.
As charged in count 21 of the information.
No,
If you find the
Runkle's not
defendant
there. I
guilty of
believe
first
Chanley
degree
Painter from Court
recklessly
TV is there. I'm going to go check her
endangering
Twitter when this
safety,
is
answer the
done.
following question,
We'll pull it
yes
up
or
because she
no.
talked about a
Did
juror
the
that was crying,
defendant
so she's
commit
got to be in
first
court.
degree
Or
recklessly
someone is.
endangering Safety while using a dangerous weapon.
Could have argued
Count
temporary
22.
insanity. No, that's a
One
legal
reading.
defense.
We,
That
the
wasn't
jury,
there.
find the defendant, Darrell E. Brooks,
I just saw
not
one that asked
guilty
thoughts on
of first
appeal.
degree
I haven't seen.
recklessly
It's going to
endangering
happen if he's
safety,
convicted.
charged in count
We'll
20.
look at the grounds if it
Two
is.
of the information. Another reading,
We don't
the
stop
jury
covering
find the
cases.
defendant, Darrell E. Brooks,
We don't
guilty
stop covering cases
first
just
degree
because
recklessly endangering safety
there's a
as
verdict.
charged in count
There's so much that
22 of
happens
the
after a
information.
verdict.
If you find the defendant guilty
Thank
of
you so much,
first-degree
Crystal.
recklessly endangering safety, answer the following question, yes or no. Did the defendant commit
Jennifer, we
first-degree
do
recklessly
have a Tempest
endangering
weather
safety while
station.
using a dangerous weapon?
No
Count
faulty
23.
car explains the
One
blindness
reading.
of
We, the
roadblocks
jury,
and cops,
find
not
the
a defense.
defendant, Darrell E.
Agree.
Brooks, not guilty of first
Would the
degree
jury take a
recklessly
poll before they
endangering
even started
safety as
deliberation? They
charged in
can.
count 23 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty.
He doesn't want to
of
admit to
first-degree
anything.
recklessly
I don't think he
endangering
can
safety
just say that.
as charged in count 23 of the information. If you find the defendant
Generally,
guilty of first-degree recklessly
the
endangering safety,
foreperson fills them all
answer the
out.
following question, yes or
They
no.
have to go through
Did the
every
defendant commit
single
first-degree
count.
recklessly endangering
It's gonna take
safety
them
while using a dangerous
An hour to vote,
Count
time to fill
24.
out the paperwork.
One reading, we the
They're
jury
not going to
find
come
the
back
defendant, Darrell E.
fast,
Brooks, not
There's a
guilty
lot for them to go through.
of first degree recklessly endangering safety is charged in count 24 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged
My
in
router went
count
down when he was
24 of
telling the judge he
information.
was
If
going
you
to
find
tell the jury the
defendant
truth.
guilty of first
I
degree
got back.
recklessly
Why is he
endangering
looking like a
safety,
poor misunderstood
answer the
puppy?
following question,
Oh,
yes
Barbara,
or
you're going to
no.
have to watch the whole
Did the
closing.
defendant
It was
commit
about an hour.
first-degree recklessly endangering
Could the jury
safety
turn
while
their
using a
chairs
dangerous
while
weapon?
he was giving his closing so that it didn't face him?
Count 25.
I think the jury takes
One
their duty
reading,
very
we the jury
seriously.
Find the defendant, Darrell
And
E.
I'm sure
Brooks,
some of them wanted to look at
not
him.
guilty of first degree recklessly endangering safety.
I
as
don't know
charged
what
in
count we're on.
25 of the information. Another reading, we the jury
So,
find the defendant,
I don't know what count we're on.
Darrell E. Brooks, guilty of first degree recklessly endangering
There is an order of
safety
appeals
as
for
charged
criminal
in count
cases.
25 of the
So yes,
information.
there is a
You find the
limit.
defendant guilty of first
In
degree recklessly endangering safety.
Of course, there are
answer the
exceptions, but
following
yes,
question,
generally,
yes or no.
especially in a case
Did the
that's not a death
defendant
penalty
commit
case.
First degree recklessly endangering safety while
So
using
I
a
think
dangerous
tomorrow,
weapon.
sometime tomorrow, we'll get a verdict.
Count 26.
I agree.
One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 26 of the information.
Computer is starting to get
Another
cranky.
reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 26 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question.
Thank you,
yes or no.
Sammy.
Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 27.
They're on count
One
27
reading.
out of
We the jury find the defendant,
70.
Darrell E. Brooks, not guilty.
They have to go through
of first
each
degree
one of
recklessly
these.
endangering safety as charged in count
All right, I'm going to turn
27
this
of the
down just a
information.
little bit.
Another reading, we the jury find the defendant, Darrell E.
hold
Brooks,
on.
guilty of first degree recklessly endangering safety.
Ah, that's not what I wanted to
as
do.
charged in count
Emily,
27
this was
of the
pure
information.
user error.
If you find the defendant guilty of first degree reckless
All right, we're going to keep an ear for what charge they're on.
No. Did the
but
defendant commit first degree recklessly
let's
endangering
see.
safety while using a dangerous weapon? Count 28. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 28 of the information.
Sorry, my browser is starting to freeze.
The defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 28 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no.
Sorry, y'all. My computer is done with Darrell Brooks today. It's always right about, sorry, I'm on audio only. It's always right about this time when my computer, it's always right about 3 hours and 45 minutes into it. So I'm going to get back to pulling up this stream as they finish up jury instructions. They were on like count 20 something out of all of it. So we're going to pull that back up. Thank you all for dealing with my tech fuckery today. It's a lot.
Count 30.
So
Reading,
let's make sure we're caught up.
not guilty.
Count 30. I wish we could
Recklessly endangering
zoom this faster, but we can't.
in count 33.
Ugh, and now it just doesn't want that added. So let me share the screen again. Sorry to all of you. They are going through like count 32.
Another reading, we the jury find the defendant
Darrell is still just reading his
first degree
Bible
recklessly
or
endangering safety
staring at
as
his
charged in
Bible.
count
And yeah, I don't know what's going on with the
32.
tech, but this trial is just about done. We won't have a day like this
of the
before.
information.
So
If you find the defendant
it's not
guilty
just
of
my
first
browser, it's
degree
my
recklessly
whole
endangering safety,
system
answer the following question,
that's
yes or no.
having issues. But you guys
the
know I'll always
defendant
come back if my computer doesn't
Commit first
melt.
degree recklessly endangering
But we're gonna
safety
have to
while using a
figure that out.
dangerous weapon.
So let's add this to stream. Let's,
We're going to have you take a short stand break
oh, now we're standing.
while I confer with Madam Clerk.
Oh, there must have been an edit. This will not let me. I don't know why this won't. This other window, when I pull up the second window, it keeps freezing. So the court is on a stand break. Let me try one more time, and then, and then we'll try to figure it out. Let's see if we can do this and if this will work. I'm just trying to limit the whatever is pulling on the memory. Let's see. I'm going to find a different feed and see if this will work.
Fight arthritis.
Yeah. Because now there's ads, because now I'm not logged into YouTube. But that's okay. I can skip it. I hate that there's ads before the news live streams. That's annoying. All right, let's get us back up. We are now at the court taking a stand break. He is saying something. No, this is not caught up in time. All right, let me find one that's live real quick. And we'll get back to it. And now YouTube is like, who are you? We don't know you. You're not logged in. Live. Sorry, y'all. It's not easy when I'm not logged into all my stuff, but we're making it work. We're making it work. I appreciate the patience. All right, now we're back.
Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 34, one reading.
right, we're on count
We, the jury,
34.
find the
We've not
defendant,
gone far.
Darrell E. Brooks.
We've not gone
guilty
far to get to
of
count
first degree
34.
Recklessly endangering safety as charged in count 34 of the information.
We're only on count
Another
34.
reading, we, the jury, find the defendant, Darrell E. Brooks.
All right,
guilty
thanks,
of
y'all.
First degree recklessly endangering safety as charged in count 34 of the information.
Only on 34.
If you find the defendant guilty of first degree
Good Lord.
recklessly endangering safety, answer the
All right, I'm going to
following
answer
question,
questions
yes or no.
and talk over the
Did
court
defendant
until we
commit
get to the
first
final
degree
closing
recklessly
instructions when she
endangering safety
dismisses
while
the
using a
jury
dangerous weapon?
and then talks
Count
about when they're
35.
coming back.
One reading, we the jury find the
let's
defendant,
put this
Darrell E.
to-
Brooks, not guilty of first degree recklessly endangering safety as charged
Okay.
in count 35 of the information. Another reading, we the
Let's
jury
keep going.
find
Yeah,
the
we're not even
defendant,
halfway through yet.
Darrell E. Brooks, guilty.
Did you all take a
of
stand break
first-degree
when the court
recklessly
did?
Endangering safety as charged in count 35 of the information. If you
right.
find the defendant guilty of first degree recklessly endangering
Question
safety,
for
answer
defendants
the
like that,
following
does the
question,
courtroom
yes or
sort of
no.
erupt after a
Did the
conviction is given?
defendant
It
commit
depends.
first-degree
Do people
recklessly
feel free to
endangering
yell?
safety
No.
while using a dangerous
No, the audience, sometimes there might be
Count
tears,
36, one reading.
but
we,
there's
the
generally
jury,
a lot of
find the
bailiffs.
defendant, Darrell E. Brooks,
But
not
no,
guilty
you don't generally
of
see, you can see
first-degree
emotion,
recklessly endangering safety
tears,
as charged in
sometimes
count
people shout,
36 of the
but
information.
not name calling and
Another
stuff.
reading,
Like,
we, the jury,
not
find the
shout,
defendant, Darrell E. Brooks, guilty
emotion,
of first-degree
yell,
recklessly endangering safety
tears,
as charged in
but
count
not,
36 of the information. If you find
not
the
yelling
defendant
names and stuff
guilty
like
of
that, if that makes
first-degree
sense.
Recklessly endangering safety. Answer the following
Does
question,
defending
yes
yourself
or
ever
no.
end well? I mean,
Did the defendant
in
commit
traffic court
first-degree
sometimes,
recklessly
maybe?
endangering safety while using
maybe in a
dangerous weapon?
small civil case,
Count
but no.
37, one reading. we, the
Question,
jury,
why is he
find the
allowed
defendant,
a Bible? Probably the
Darrell E.
rules in the
Brooks, not
jurisdiction that
guilty
allow you
of
to
first-degree
maintain your
recklessly
religion
endangering safety
while you're in
as
custody.
charged in count 37 of the
I think the jury
information.
was probably offended. The chat
Another
was
reading,
offended. We could take a
the
poll,
jury find the defendant,
but I
Darrell E.
think
Brooks,
the
guilty of
majority, and we had
first-degree
what,
recklessly
almost
endangering
40,000
safety
people in
as
here
charged
before my
count
computer crashed.
37 of the information. If you find the defendant guilty
People were
of
offended.
first-degree recklessly endangering
People were
safety,
offended. Yeah,
answer the
wailing,
following
not shouting
question,
is
yes or
appropriate.
no. Did the
So,
defendant commit first-degree
and people try to rein it in.
recklessly
Normally,
endangering
there's quite a lot of
safety while
bailiffs.
using a dangerous weapon? Count 38, one reading, we the jury.
It doesn't
find
mean it doesn't happen.
Darrell E. Brooks,
I'm sure it
not
does on
guilty
occasion.
of first-degree recklessly endangering
Criminal court has a lot of
safety as
emotion.
charged in count
Family law
38
court has a lot
the
of emotion.
information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty.
Do
of
judges get to bring their own
first-degree
chair?
recklessly endangering safety as charged in count 38 of the information.
So
If you find
jurisdiction
the
by
defendant guilty
jurisdiction,
of first
it's going to
degree
differ.
recklessly endangering
But
safety,
often
answer
the
following
judges can
question,
pick their
yes
chairs
or
with the
no.
court administrators.
Did the
Like an
defendant
episode of The
commit
Office where they're fighting over
first-degree
chairs.
recklessly
But often
endangering
judges
safety while
can
using
order a chair.
dangerous weapon?
Though when the
Count
old Long Beach
39.
courthouse was closing and the
One
new
reading,
Long
we
Beach
the
courthouse
jury
was opening, a
find
lot of the
defendant,
judges were like, no,
Darrell
I
E.
am
Brooks,
taking my
not guilty
chair
of
to the new
first-degree
courthouse.
recklessly endangering safety
So.
as charged in count 39 of the information.
His little speech would tick me off at
Another
the end.
reading, we,
Trump
the
has
jury,
said, as a
find the
Christian, his
defendant,
little speech would
Darrell
tick
E.
me off at the end. He
Brooks,
forgot the part about
guilty of
in the
first-degree
Bible about man
recklessly
having free
endangering
will.
safety as charged in count 39
His whole
of the
approach is very Michael
information.
Scott, I declare
If
bankruptcy.
you find the defendant guilty of first-degree
Why didn't he
recklessly
crash the
endangering
car
safety,
before getting to the
answer the
point?
following
If it was
question,
faulty,
yes or no.
a wall would have
Did
stopped
the
him.
defendant commit first-degree recklessly
A
endangering
lot of
safety
things would have
while
stopped
using a
him.
dangerous
And
weapon?
he slowed down and
Count
accelerated.
40.
It's not.
One reading,
like,
we the jury find the
he
defendant,
couldn't slow
Darrell
down.
E. Brooks, not guilty.
Do you
of
think the fact that he was
first-degree
denied a
recklessly
change of
endangering
venue will
safety
work in his favor
as
for an
charged in
appeal?
count 40 of the information. Another reading.
I
we
think
the
it will be
jury
grounds
find the
for appeal. I
defendant,
don't know
Darrell
if it
E.
will
Brooks,
help.
Guilty of first-degree recklessly endangering safety as charged in count 40 of the information. If you find the defendant guilty
Oh,
of
I can't.
first-degree
My
recklessly
computer's not reading my
endangering
keyboard
safety,
well. Miguelina,
answer
it's
the
okay.
following question, yes or no.
I don't think we need to put one up.
Did the defendant commit first-degree recklessly endangering safety while using a
Can the
dangerous
judge go home tonight and finally relax?
Count 41.
No.
One
The jury's
reading,
still
we
out
the
there.
jury find the defendant,
More.
Darrell
Can
E.
relax
Brooks,
more.
not guilty
But
of
it still has to get through this
first-degree
man
endangering safety
being in
as
court while a
charged in
sentence
count
is,
41
or a
of the
verdict is read and
information.
then sentencing. So it's
Another
not,
reading, we the jury
can't
find the defendant,
relax all the way
Darrell E.
yet.
Brooks, guilty of first-degree
Wisconsin does
recklessly
not
endangering
have a
safety
death
as
penalty.
charged
This
in
is not a
count
death
41
penalty
of the
case.
information.
Big Bearded Life said, I'm a
If you find
Christian
the
and this
defendant
infuriates
guilty
me
of
to no end.
first-degree recklessly endangering
The Brooks
safety,
defense, it was God's fault.
answer
It's
the
like the
following
Shaggy defense. It
question,
wasn't
yes or
me, me, it was God.
Did
The Shaggy
defendant
Brooks
commit
defense.
first-degree
He's mocking the
reckless
Lord, the
endangerment,
audacity.
safety,
Well,
while using a dangerous
it shows
weapon.
he's maybe not what he says he is. Worst closing ever. Jesus wants no part of this. The comment
Count
in the chat
42.
that I appreciated
One
so much
reading,
was
we the jury find the
uh,
defendant, Darrell E.
Jesus
Brooks,
and God,
not
Taylor Swift
guilty
style.
of
I would like to be
first-degree
excluded from this
recklessly
narrative.
endangering safety, is charged in count 42 of the information.
I've not gone through all of Taylor
Another
Swift's new
reading,
album yet
we the jury find the defendant,
because
Darrell
I've
E.
been down a
Brooks,
TikTok
guilty
rabbit hole
of
and I have a new
first-degree
book.
recklessly endangering safety, is charged
Did he
in
really
count
just
42
say
of
that
the
his
information.
choice to go do something
find the
so
defendant
evil
guilty
was
of
God's
first-degree
will
recklessly
and they
endangering
should just have
safety,
faith? I'm going to
answer the following
hyperventilate.
question, yes or
Leslie
no.
Ann, yeah, that's kind of
Did
where he
the
was.
defendant commit first-degree recklessly endangering
No,
safety
Luis
while
Lemon,
using
see,
a
the
dangerous
only things
weapon?
he wants to apply to him. That's how his
Count
logic is
43.
working.
One reading.
His face has been full of
The
contempt and
jury
disgust,
find the
and it's
defendant,
against the
Darrell
DA
E.
and jury. The
Brooks,
fake
not
sorrow and
guilty of
blaming God is
first-degree recklessly endangering
OMFG.
safety, as charged in count
How are judges
43
assigned or
of the
chosen to oversee a
information.
case?
Another reading.
Normally,
we the
cases are
jury find the
assigned
defendant,
either by
Darrell E.
last name or
Brooks,
by
guilty
number
of
to
first-degree
courtrooms. Each court has its own
recklessly
random
endangering
assigned
safety, as
system.
charged in count
What's going to
43
be
of the
interesting at the end of
information.
this
If you find the
is,
defendant guilty of first-degree recklessly endangering
they're
safety,
choosing alternates.
answer
There
the
are
following
15
question,
people
yes
there.
or no. Did the
12 will
defendant commit
deliberate.
first-degree recklessly
So they're going to
endangering
use the
safety
like
while using a
the
dangerous
little
weapon?
like bingo
44.
spinner thing that
One
that
reading,
we've seen
we
in
the
other
jury
cases,
find the defendant,
like the
Darrell
Rittenhouse
E.
case,
Brooks, not
and the
guilty
alternates
of
will be
first-degree
picked.
recklessly endangering safety, as
And
charged
I
in
imagine
count
those
41
alternates
of the
will be
information.
pissed that they don't
Another
get to
reading,
deliberate. I'm going to go
we
look
the
at Twitter
jury
real
find
quick
the
and see what
defendant,
Chanley Painter
Darrell
said.
E.
I can't pull it up on my
Brooks,
computer because my
guilty
computer
of
is like
first-degree recklessly endangering
just
safety, as
hanging
charged in
on
count 41. Sorry,
to this
44
very long
of the
stream.
information. If you find the
the
defendant
phone.
guilty of first-degree recklessly endangering safety,
Do we have any more weather
answer
coming?
the
Let's look at that
following
first.
question, yes or no.
Did
the defendant commit
Oh no,
first-degree
just
recklessly
talking about the
endangering
epic sunset.
safety
It
while
was an
using
epic
a
sunset.
dangerous weapon?
I
Count 45.
agree.
One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of
Chanley said
first-degree
powerful.
recklessly
Prosecutors
endangering
concluded their
safety, as
first
charged in
closing by
count
playing
45
6
of the
minutes of
information.
graphic videos showing the
Another
terrifying
reading,
carnage of
we the
November
jury
21st,
find the
2021.
defendant, Darrell
Inside
E.
the
Brooks,
courtroom, jurors
guilty
cried, grabbed
of
tissues.
first-degree
A packed
recklessly
gallery,
endangering
victims, families,
safety,
witnesses,
as
and
charged
public
in count
audibly
45 of the
reacted
information.
in shock
If you find
and
the defendant
sobbed.
guilty of first-degree
Yeah, it was a
recklessly
power. It was
endangering safety,
powerful.
answer the following question,
It was.
yes
It
or
was
no.
absolutely
Did
powerful.
the defendant commit
So that's what
first-degree
Chanley,
recklessly
who it
endangering
seems like
safety
Chanley's
while
in the
using a
courtroom, said.
dangerous weapon?
Objection. Make it
46.
stop.
One reading, we the jury find the defendant, Darrell E. Brooks.
Susie
not
Q. People
guilty
who lost
of
their
first-degree
children will never
recklessly
ever be able
endangering safety,
to
as charged
hug,
in
kiss,
count
hold, see them
46 of the
graduate, watch them get
information.
married, have children.
Another reading,
My blood
we
is
the
boiling.
jury
Yeah.
find the defendant,
Well, he
Darrell E.
talks about a
Brooks
letter from his.
guilty of first-degree recklessly
Brooks laughed during a
endangering
witness
safety, as
testifying,
charged in
laughed
count
at her,
46
and
of
she
the
was his own
information.
witness.
If you find the defendant guilty of first
I don't think this jury is going to come back tonight. I think they're
answer the
exhausted.
following question, yes or no.
Is he even going to mention the people he killed? He said he throws up prayers every day. The car is not as wide as the street. Yep, that's true.
One reading, we the jury find the defendant.
If he appeals,
Darrell
does
E.
that mean he
Brooks,
gets a new
not
trial?
guilty of
No.
first-degree recklessly endangering
You can
safety,
appeal,
as
and you
charged
can
in
win on
count
grounds
47
of
the
appeal
information.
and still have them found
Another reading,
harmless error.
we, the jury, find the
Finding,
defendant,
appealing,
Darrell E.
and
Brooks,
having an appeal
guilty of first-degree
warrant a new
recklessly
trial on
endangering
every single
safety,
charge is
as charged in
exceedingly
count
rare.
47 of the information.
And
If you find the
I've not
defendant
watched this
guilty
entire trial,
of
so
first-degree recklessly
if he's
endangering
convicted, he'll
safety,
file an appeal and we'll
answer
go
the
from there.
following question, yes or no.
Intent was clearly
Did
described in the jury
defendant
instructions he
commit
threw away.
first-degree recklessly endangering safety
How can you just
while
find
using a
intent?
dangerous
They
weapon?
can.
Count 48. One
Jennifer said,
reading,
thank you, Emily.
we the
You've kept my
jury
spirits
find
up.
the
That's what we're
defendant,
here
Darrell E.
for.
Brooks,
Question, if
not
the jury
guilty
decides
of
tonight,
first-degree recklessly endangering
will they all
safety,
come back
as
tonight?
charged in count 48 of the information.
We'll see what the judges,
Another reading,
I think
we the
everybody's had a
jury
long day.
find
We'll
the
see what the
defendant,
judge's final
Darrell E.
instructions
Brooks,
say.
guilty of
I think the
first-degree
jury will
recklessly
pull up the
endangering
car
safety, as
operation.
charged in count 48 of the
That to me
information.
was his biggest
If
excuse.
you find the defendant guilty of first-degree
They had that
recklessly
testimony. They can
endangering
absolutely
safety,
go back and look at
answer
it.
the following question, yes or no. Did the defendant commit first-degree
The
recklessly
alternates
endangering safety while using
will
a
be
dangerous weapon?
sequestered during deliberations. They can't listen
One
in.
reading, we the jury find
So the
defendant,
alternates will go to the hotel and be
Brooks, not
sequestered
guilty of
so that
first-degree
they're
recklessly
not
endangering
exposed to
safety,
media
as charged in
or
count
the
49
flu
of the
or whatever.
information. Another
But they
reading,
will
we
not
the jury
deliberate
find
with
the
the
defendant,
jury.
Darrell E. Brooks,
So
guilty of
they will
first-degree
be
recklessly
around, but they will
endangering
not be
safety,
deliberating.
Charged in count 49 of the information.
Brooks is a master class in how to gaslight. It was very gaslighty. Do you think this will be done tomorrow?
Following question, yes or no? Did the
I wouldn't be
defendant
surprised if the jury
commit
came back
second-degree
tomorrow,
reckless
considering they don't
endangerment
have to be
when
dismissed
using
at the end of court. They're
dangerous
sequestered, so they can talk tonight. I wouldn't be surprised.
Count 50.
What's the risk of
One
him
reading,
flipping out
we,
at
the
verdict?
jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly
He's been-
endangering safety.
I mean,
as
there will
charged
be
in count
bailiffs there.
50 Of the information.
He's shackled. He
Another
can be
reading,
completely
we, the
shackled for
jury,
verdict
find the
because it
defendant,
won't matter
Darrell E.
that
Brooks,
he's
guilty
in custody. I mean, he already mentioned he was in custody, so they don't have to keep up that pretense. There's nothing he has to do as an attorney. He could be shackled for that if they're really worried about it. If the jury's worried about it, they can always send a note saying they want to be escorted out.
Did the defendant commit first degree
I don't know.
endangering safety while using a dangerous weapon?
I think he'll have some
Count
response.
51.
Does he automatically get an appeal or does he need to file? It's Wisconsin. I don't know if he's convicted, if it's automatic or if he has to file. Generally, you have to file. That could be different.
Another reading.
I feel sorry for the
We, the
victims
jury,
and their
find the
families who have to sit there and listen to
defendant,
this.
Darrell E. Brooks,
I just hope they have
guilty of
someone
first-degree
there to hold their
recklessly
hands. I hope so
endangering
too.
safety as charged in count 51
And I
of the
hope
information.
for anyone's
If you
mental
find the
health,
defendant
if it's
guilty
too
of
much,
first-degree
you can turn it off,
recklessly
come back or
endangering
not.
safety, answer
It's
the
okay.
following question, yes or no.
The recall on cars
Did the
actually
defendant
caused them
commit
to
first-degree recklessly
stall,
endangering
I
safety
think,
while
not
using
speed
a
up
dangerous
uncontrollably.
weapon? Count
And this car
52.
wasn't subject to it.
One reading, we the jury find the
So,
defendant. Darrell
rage
E.
equals
Brooks,
slamming your fist on the
not
decks and
guilty
staring down the
of
judge like he
first-degree
did.
recklessly
Just my
endangering
thoughts. Also,
safety
hi
is
from
charged in
celebrating my
count
birthday in
52 of the
Italy. Hi,
information.
midwife Crystal,
Another
celebrating your
reading,
birthday in
we, the
Italy. Happy
jury,
birthday.
find the defendant,
Trying to respect
Darrell
chat
E.
rules. I'm
Brooks,
not fond of this
guilty
gentleman.
of
See,
first-degree
you
recklessly
did it. Good
endangering
job.
safety as charged in
It is
count
very hard.
52 of the information.
It is very, very
If
hard.
you find the defendant guilty of first-degree recklessly
This seems
endangering
like a
safety,
sentencing
answer
statement, and the
the
jury's got to be
following
sitting there
question,
going, why
yes
do we
or
have to go
no.
through this again?
Did the defendant
Do you think the
commit
DA didn't
first-degree
address the
recklessly
recall?
endangering safety
She had the
when
facts
using
and
a
evidence. They
dangerous
don't
weapon?
have the facts and
Count
evidence.
53.
Um,
One reading,
I don't
we,
think
the
it
jury, find
matters.
the
I think it
defendant,
seems like a
Darrell E.
delay
Brooks,
tactic,
not
and
guilty of
the
first-degree
evidence is the
recklessly
evidence, and they have the
endangering
evidence.
safety as charged in count 53 of the information. Another reading,
Can he be
we,
sued
the
by
jury,
people he
find the
hurt in civil
defendant,
court?
Darrell E. Brooks,
He can. I don't know
guilty
to
of
what end, though.
first-degree recklessly endangering safety as charged in count 53 of the
Can
information.
insurance, the car insurance
If
be
you find the
involved? Yes, it might
defendant
already
guilty of
be,
first-degree
but I don't think he
recklessly
has
endangering
the
safety,
money
answer
to
the
be sued in
following
civil
question,
court
yes
to
or
any
no.
end that's going to help. They're going to
Did the
spend more
defendant
money
commit
suing him than I think they'd
first-degree
get.
recklessly endangering safety
Natalie, oh, shout
when
out to the
using a
amazing mods for
dangerous
keeping up with us. The mods are
Count
incredible.
54.
Um,
One reading,
our mods
we,
follow
the
the
jury,
chat rules,
find the
follow my
defendant,
rules,
Darrell
and help
E.
make sure
Brooks,
that when we
not
have
guilty of
30 plus
first-degree
thousand people,
recklessly endangering
that we
safety
all
as charged in
can
count 54 of the
can
information.
follow the rules, and we can
Another
help
reading,
all
we,
of
the
our
jury,
our
find the
new law
defendant,
nerds kind of
Darrell
get up
E.
to speed on
Brooks,
how we do
guilty
things
of
here,
first-degree
even when it's hard.
recklessly
It's hard
endangering
not to
safety
name
as
call
charged in count
someone
54 of the
whose
information.
behavior
If
and
you find the
closing
defendant
argument
guilty
was
of
so
first-degree recklessly
offensive.
endangering safety,
Can I get a
answer the
birthday shout out,
following
please? Emily, love
question,
watching.
yes or no.
Bethany, happy
Did the
birthday.
defendant commit first-degree recklessly endangering
Annette, that's very
safety
kind.
when using a dangerous weapon? Count
These
55.
DAs did a
One
great
reading,
job.
We, the jury, find the defendant.
Really, really
Darrell
great
E.
job.
Brooks, not guilty of first-degree recklessly endangering
Okay, let's see
safety
what-
as charged in count 55 of the information.
55. All right.
Another reading, we, the jury, find the defendant.
We gotta
Darrell
go to
E.
70.
Brooks, guilty of first-degree recklessly endangering
Janet said
safety
it's not different.
as
He's
charged
still
in count
playing with his
55 of the
emotions, pulling the
information.
ones he thinks he needs to get what he wants.
Another reading, we, the jury. find the
Teresa said
defendant,
if he was
Darrell E.
not
Brooks,
enraged, then
guilty
that
of
means he was a
first-degree
cold-blooded
recklessly
killer
endangering safety as
and
charged
fully in
count
control of
55
himself in that vehicle.
information. If you find the defendant guilty of first
They can
degree
forgive and
recklessly
convict. I don't
endangering
think,
safety, answer the
truly, I
following
don't know if
question,
forgiveness
yes
is
or
for
no.
this jury
Did the
or
defendant
for the
commit
families.
first-degree
It's the jury to decide the
recklessly
facts in the
endangering
law,
safety while
not the
using a
law, the
dangerous
facts as they apply to the
I'll give my
law.
jurors one more stand break before I conclude, so please stand. and-
My butt's tired too, Your Honor. Y'all stand up with the court. We're standing. I had cat hair on my shirt earlier. I was very embarrassed, but I like the stand. I love the stand break. We're gonna just, all right, we're done dropping it like it's hot.
If you want these.
He's not standing. So, let's see. A lot of feelings during closing. That his closing sounded hollow. It did. What is not guilty, then guilty? Oh, why is it not guilty, then guilty? It's the judge's practice to put not guilty on the top. I think it's to not prejudice the, I think it's to not prejudice the jury.
All right, thank you, have a seat.
Do female judges always wear rather muted makeup? Is there such a thing as a judicial dress code? Are the black robes a requirement? The black codes are a requirement
One reading, we, the jury, find the defendant.
and also a tradition.
Darrell E.
Also, you
Brooks,
don't have to
not
worry
guilty
about
of first-degree
what you wear. It's
recklessly endangering
an
safety as
equalizer.
charged in count 56 of the information.
I've seen judges that wear
Another
stunning
reading,
makeup.
we, the jury,
In a
find the
trial like
defendant,
this,
Darrell E. Brooks,
judges
guilty
aren't going to wear a lot of
of
makeup because they don't
first-degree recklessly
have the energy in the
endangering
morning.
safety as charged in count 56
Truly,
of the
I didn't wear a
information.
lot of makeup when I was in
If you
trial. I
find
just
the
didn't have the
defendant
energy.
guilty of first-degree recklessly endangering endangering safety. Answer the following
Emily G said,
question,
is it
yes
rare
or
for the
no.
actual DA to
Did the
try a case?
defendant
It
commit
shouldn't be, but in
first-degree
larger
recklessly
jurisdictions it
endangering
can be.
safety while
It's
using
not
a
something we
dangerous
always see,
weapon?
but in smaller jurisdictions, you're going to see it more. I
One
think it's a
reading,
great
we,
thing.
the jury,
I
find the
absolutely
defendant,
think it's a good thing to see
Darrell
the
E. Brooks,
elected
not
DA
guilty of
be more than a
first-degree
political
recklessly
figure and
endangering
know that they are
safety as
actually a
charged in count
prosecutor.
57 of the
But
information.
I'm a former
Another
prosecutor, so.
reading, we, the jury, find the defendant,
Ken
Darrell
Baum
E.
gets
Brooks,
sued. It's her
guilty
car.
of
It's
first-degree
possible.
recklessly
I don't know if that
endangering
will happen,
safety
but it's
as charged
possible.
in
That
count
might already
57 of
be
the
happening.
information.
Megapint needed tonight.
If
You
find
rock.
the
Thank you.
defendant
You're welcome.
guilty
I
of
need a
first-degree
bath
recklessly endangering
and a
safety,
whiskey.
answer the following question, yes
Where
or
do I
no.
order the shirt? This one hasn't been
Did the
released yet.
defendant commit
The objection
first-degree
one hasn't been
recklessly
released yet.
endangering safety
I
while
will.
using a
It will be
dangerous
released.
weapon?
It has not been. I got behind.
Count 58.
We'll get you
One
objection
reading,
shirts. Don't
we, the
worry.
jury, find the defendant, Darrell E.
I might
Brooks,
put grounds. I might do one that says
first-degree
grounds on the back.
recklessly endangering safety as
They're
charged in
reading the
count
closing
58
jury
of the
instructions. So there's
information.
jury instructions
Another
before the
reading,
closing
we,
and then
the
the
jury,
final jury
find the
instructions.
defendant,
So they're
Darrell E.
reading
Brooks,
all the verdict forms.
guilty of first-degree
What is he looking at? It
recklessly
seems like the
endangering
Bible.
safety as charged in count 58 of the information.
I'd
If
say
you find
because
the
innocent
defendant
until proven
of
guilty. That's as
first-degree
good of a reason as
recklessly
any, but
endangering
it's
safety,
it's
answer
really
the
about
following
prejudice.
question, yes or no.
Which ones go on
Did
top
the
and which ones go
defendant
underneath.
commit first-degree
So.
recklessly endangering safety
But no, judges
or
get to
using a
read
dangerous
or wear
weapon?
whatever kind of makeup they're
Count
comfortable
59.
with.
One reading.
So.
We, the jury, find the defendant, Darrell E. Brooks, not
We need
guilty
a
of
lawful law
first-degree
one, too. We'll
recklessly
see.
endangering safety as
We'll
charged in
see.
count 59 of the information. Another reading.
Do we know if his
We,
mom's
the
in court? I
jury,
don't
find
know.
the defendant, Darrell
I know
E.
we all
Brooks,
want to know what
guilty
lip the
of
judge is wearing.
first-degree recklessly endangering
She can rock a
safety
nude lip.
as
I
charged in
can't.
count
I
59 of the
I
information.
cannot rock a nude lip.
If you find the defendant guilty of
Exhibity.
first-degree
I practice
recklessly
lawful
endangering
law.
safety, answer the following question, yes
All
or
right.
no.
We've
Did
noted the
defendant
lawful
commit
law.
First-degree recklessly endangering safety while using a dangerous weapon.
So
Count 60. One reading. We,
I
the
just
jury, find the
spilled
defendant,
on
Darrell E.
my
Brooks,
boobs.
not guilty of first-degree recklessly endangering safety
So,
as
yes.
charged in count 60.
I want to know what
of
the judge's
information.
lip color is as well.
Another reading. We, the jury, find
Do
the
judges,
defendant,
prosecutors,
Darrell E.
lawyers have
Brooks,
access to good mental health
guilty of
resources?
first-degree
Imagine
recklessly
they see a
endangering
lot and that
safety
could mess
as
you up.
charged in count 60 of the
Everyone
information.
deals with things differently.
If you find the defendant guilty of
My health
first-degree
insurance through
recklessly
work
endangering
had
safety, answer the
mental
following
health
question,
coverage.
yes or
I did
no.
not use it. I
Did the
paid
defendant
independently.
commit first-degree recklessly
I think
endangering safety
I
while
think it
using a
depends on where
dangerous
you work
weapon?
as to whether you
Count
have that
61.
provided for you or not.
One
In my
reading,
experience,
we, the
people
jury,
chose
find
therapy
the
on their own.
defendant,
It's also
Darrell
been my
E.
experience
Brooks,
that people
not guilty
in
of
particularly,
first-degree recklessly
you know, the
endangering
DA's
safety
office,
as
et cetera, et
charged in
cetera,
count
et cetera,
61 of the information. Another reading, we, the jury,
that
find
finding
the
time
defendant,
to
Darrell E.
take care of
Brooks,
oneself can be
guilty of
difficult
first-degree
depending on how
recklessly
busy you are.
endangering safety as charged in
Emily,
count
does he
62
have
of the
YouTube in prison? I have no
information.
idea. Could
If
he
you find
use
the
content
defendant
created
guilty of
about him to
first-degree
formulate his
recklessly
appeal?
endangering safety,
I
answer
think
the
that would be
following
very
question,
difficult
yes or
because
no.
appeals are so
Did the
specific.
defendant
I don't
commit
know if they have access
first-degree recklessly
what
endangering
they can
safety
watch
while using a
wherever
dangerous
he is.
weapon?
Generally, they have access to
Count
the internet,
62.
but he
One
should have an
reading,
attorney for his
we, the
appeal.
jury,
That
find the
should be the
defendant, Darrell E. Brooks,
information
not
he
guilty
gleans for his
of
appeal should be get a fucking
recklessly
lawyer.
endangering safety as charged in count 62 of the
62.
information. Another reading.
Okay,
We, the jury,
62.
find the defendant, Darrell E. Brooks, guilty of first-degree
From the
recklessly
UK, Colin
endangering
peeking in your
safety as
background is
charged in
making
count
me
62
hungry.
of the
Cake.
information.
Yes, we
If you
covered
find
Colin
the
and
defendant
Cuthbert quite
guilty of
thoroughly.
first-degree
This has
recklessly
started to
endangering
become a
safety,
ode
answer
to
the
cases
following
past. We've
question,
got some
yes or
Miraval
no.
wine.
Did the
And
defendant
we have
commit
some
first-degree
things from
recklessly
other
endangering safety while
cases. We
using
need
a
like
dangerous
some
weapon?
Sauvage in here or
Count
something.
63.
Lots of stuff.
One reading.
Calling
We,
from the
jury,
UK, these
find the defendant,
jury
Darrell
instructions
E.
have already
Brooks,
lasted longer than
not
our last
guilty
prime
of first-degree recklessly
minister.
endangering safety as charged in count 63 of the information.
The trust shade.
Another reading, we the jury. find the
Susanna, that's funny.
defendant,
Thank
Darrell
you.
E. Brooks, guilty
Appreciate it. That's
of first-degree
true.
recklessly endangering safety as charged in count 63.
No matter what he
of the
did or how bad it was,
information.
true Christians
If
don't
you
judge
find
or
the
refute
defendant
anyone
guilty of
at any
first-degree
time.
recklessly
Blessed be.
endangering
Okay.
safety, answer the following
If I was on a
question, yes
jury,
or no.
I'd feel
Did the
insulted and
defendant
or a lot of
commit
"Are you fucking
first-degree
kidding me?"
recklessly
or
endangering
probably
safety
completely
while
tune
using
him
a
out.
dangerous
I think a
weapon?
lot of "Are you effing
Count
kidding me?"
64.
And those who don't want to sit in
One
judgment, we
reading,
did have
we the jury find the defendant, Darrell E. Brooks,
jurors that would say,
not
"I
guilty
cannot sit in
of
judgment of
first-degree
someone else
recklessly endangering
due to my
safety
religious
as charged
convictions,"
in count
and they would be
64
excused from the jury. Like, I cannot
Another
and will
reading,
not render a
we, the
verdict and
jury,
sit in
find
judgment of someone.
defendant Darrell E. Brooks
So,
guilty of first degree.
need a shirt that says, "You have the
reckless
power."
charged in count
Yeah, with like
64 of the
by the
information.
castle of Grayskull.
If you find the defendant guilty
On
of
it.
first degree recklessly endangering safety, answer the following question.
Isn't
yes
it bad
or
that the
no.
jury didn't see his
Did the
behavior?
defendant
No.
commit first degree
It's protecting
recklessly
his rights to a
endangering
fair
safety while
trial.
using a dangerous weapon.
So I don't think it's bad.
Count 65.
I think
One
they've probably
reading,
seen
we,
some
the
of it.
jury, find the defendant, Darrell E. Brooks,
Will the video
not
of the
guilty
proceedings
first
be allowed to
degree
be part of the
recklessly
appellate
endangering
record?
safety
No,
as
just the
charged in
written
count
transcript.
65 of the information.
How about a poll
Another
on whether
reading,
he
we,
will
the
have
jury,
an
find
attorney for the
defendant,
appeal?
Darrell E. Brooks,
Oh,
guilty
we're
of
such a
first
far way
degree
away. I
recklessly
think
endangering
that
safety
assumes
as charged
guilt.
in count 65
Plot
of
twist,
the
what are the
information.
chances of a hung jury due to
If you
one
find
juror
the
thinking he
defendant
shouldn't
guilty
have been
of
allowed
first
to represent
degree
himself?
recklessly endangering safety,
Always a
answer all of
possibility.
them. Answer the following question,
Shouldn't
yes
be.
or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 66.
All right,
One reading,
66.
we the jury find the
Thank you for
defendant,
sharing your
Darrell E.
passion for
Brooks,
law with us
not
all. You're
guilty of
welcome. Thank you
first degree
for
recklessly
letting me
endangering
nerd
safety
out with
as
y'all.
charged in count
Yes, sir, we all have a headache.
66 of the information.
We all have a headache. All of us. Every single one. Every single one. Every single one of us has a headache. And we're tired.
I'll just repeat count 66. One reading, we the jury find the defendant.
Oh, I'll
Darrell
put
E.
Amica
Brooks,
cream back there. I
not
don't have it
guilty of
yet.
first degree recklessly endangering safety as charged in count 66 of the information.
Enchanted
Another
Wolf
reading,
shared,
we
I
the
lost my
jury
son in
find the
2017 due to
defendant,
medical error.
Darrell E.
It was
Brooks,
5 years
guilty
of us
of
keeping
first
our
degree
heads and hearts up.
recklessly endangering
We were
safety
always
as
having to
charged in
fight,
count
and the
66
vid
of the
made it worse.
information.
Worst part
find the
had to
defendant
have
guilty of
one of the
first
other
degree
associates
recklessly
sit with us.
endangering safety,
Was weird.
answer the
I
following
imagine.
question, yes or
But
no.
thank you for sharing.
Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon?
If he had not fired his attorneys, what do you think they would have
Count
argued? I think they would have
67.
argued intent
One reading, we the jury find the defendant.
more effectively than he
Darrell E.
did.
Brooks,
He didn't even
not
ask to be found not guilty. He was like,
first-degree
do what's
recklessly
in your heart. And they're
endangering
like,
safety as charged in count
we got
67
you.
of the
We
information.
got you.
Another reading, we the jury find the defendant.
Yeah, this
Darrell E.
is
Brooks,
tough.
guilty of
The
first-degree
yawns.
recklessly
Ooh,
endangering
ooh.
Safety is charged in count
Sorry, they got me. I
67
looked up
of the
just as he was
information.
yawning, and it got
If
me.
you find the defendant guilty of first
Hey, Liam,
degree
thank you for the
recklessly
compliments.
endangering safety, answer the following question, yes
Exhibity.
or no. Did the defendant
Thank
commit
you.
first degree recklessly endangering safety while
Through
using a dangerous
all of
weapon?
this, he never said, I'm sorry you
Count
lost loved ones.
68.
He did not.
One reading.
He's
we the
sorry for what
jury
he's
find the
lost, it
defendant,
seems.
Darrell E. Brooks.
Can't wait
not
for this to be done.
guilty of
Same.
Hit and run as charged in count 68.
He's
of
using the Elaine
information.
Bredehoff playbook. Yeah.
Another reading, we the jury find the defendant, Darrell E. Brooks.
Mad props for
guilty
the
of
bailiff
hit and run as
has
charged in count
had
68 of the information.
amazing.
If you find the defendant
Stone-faced
guilty
the
of hit
entire
and
time.
run, answer the following
Very well
question,
practiced.
yes or
Bailiff
no.
face.
Did the accident cause
Tora,
death to
1 a.m. in
Virginia
civil law
Sorensen?
test tomorrow. Sleep or watch? Sleep.
69.
The jury's just getting, these are instructions and then they're getting dismissed. Sleep. Sleep.
Darrell E.
Go
Brooks,
sleep.
not guilty of hit and run as charged.
And he
in
said, my
count
husband retired
69
after
of the
28 years in
information.
correction. We need a moment of
Another
silence for the
reading,
poor
we the
officer
jury
who will have to
find
deal
the
with this guy
defendant,
daily
Darrell E.
forever.
Brooks, guilty of hit and run as charged in count 69
Yep.
of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no.
Can the
Did
jury
accident
deliberate tonight?
cause
They
death
can.
To Leanna Owen.
We'll hear what the judge
Count
says.
70. One reading.
Oh, yeah, these are a
jury find
template.
The defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 70
Dude has started to
of
sleep.
the information. Another reading, we the jury
like,
find the defendant.
Nobody saw me, right?
Darrell E. Brooks.
No, we saw you.
Guilty of hit and run as charged in count 70 of the information.
We're almost
If
there,
you find
guys.
the defendant guilty
Hold
of
on.
hit and run, answer the following
We're on
question,
70.
yes or no. Did the
You went to commercials? What? You can't go to commercials? We're almost at the fucking end. No. Sorry. Let me go find another stream. Oh, don't make me. No, disfavored stream. All right, at least they won't cut to commercials. Oh my God, there's ads because I'm not signed in. Sorry. I'm not playing these for all of you. I will skip this ad in just a second. We had to go to the disfavored stream because at least they're not going to cut out on us. All right, hold on. Let's see. Oh, I am so angry that whatever newscast that was went to commercial. The level of anger. All right.
One reading, we,
Let me-
the jury.
let me
find
know
the
you guys can
defendant,
hear.
Darrell E. Brooks, not guilty of hit and run as charged in count
Almost done.
73 of the information. Another
I will
reading,
find
we, the
another stream
jury,
in a
find
minute.
the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 73 of the information. If
I
you
swear to
find
God,
the
law and
defendant
crime.
guilty of hit and
This
run,
is this
answer
is
the
a
following
community
question, yes
feed. You
or
do
no.
not have copyright in
Did
this.
the accident cause death to Jackson Sparks? Count 74. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty.
So
of
I have
jumping
thoughts.
as charged in
I would need to go through and look at the charging
count
documents.
74
I
of
imagine the hit
information.
and run causing death carries more time in Wisconsin.
Another reading,
than the
we,
other
jury, find
options.
the defendant, Darrell E. Brooks,
So.
guilty of bail jumping as charged in count 74
All
of
right,
the
we're almost at
information.
the end of the counts.
Count 75. One reading, we, the jury, find the defendant.
So we're
Darrell
almost at
E.
the end of the
Brooks,
counts.
not guilty of
Oh,
bail
sorry,
jumping
bailiff. Here,
as
we'll put this
charged
over
in
here.
count 75 of the information.
so I
Another
think
reading, we,
the-
jury, find the defendant,
This is my
Darrell E.
speculation.
Brooks, guilty
I
of bail
imagine
jumping
that if they
as
don't find
charged-
intent,
as
the
charged,
hit and
excuse me,
run
in
causing
count
death with a
75
deadly weapon probably
of the
carries more
information.
time than the lower level
76.
homicides. That's my guess.
One reading. we,
I have
the
3 bottles
jury,
from Pink's
find the
Vineyard coming
defendant,
this week. I plan on
Darrell
drinking
E.
one
Brooks,
and
not
displaying the other
guilty
2.
of
Perfect.
battery, as charged in count 76 of the information.
I'm
Another
surprised he's
reading,
staying
we,
quiet
the
and not
jury, find the
complaining.
defendant, Darrell E. Brooks,
I
guilty
think
of
the
battery
jury's in the
as
room.
charged
He
in count
tends
76
He
of the
tends to
information.
keep it together when the jury's in the room. Dear
It
Law and
for
Crime,
you
this
to
is not your
determine
copyright.
whether
Exactly.
the defendant is guilty
fuck with
or
us, Law
not
and Crime.
guilty of each of the offenses charged.
Let me turn this up
You
a
must
little.
make a finding as to each count of the information.
Can you guys hear okay?
Each count charges a separate crime, and you must
Mara,
consider
thank you.
each one separately. Your verdict for the
I
crime
appreciate the
charged
compliments.
in one count must not affect your verdict on any other count. This is a criminal, not a civil case.
I don't know about that.
Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously.
Unanimous. Yep.
In a criminal case,
These are the
all 12
final
jurors must agree in order
instructions.
to arrive at a verdict. When you retire to the jury room, select one of your
Yay,
members
final
to
instructions.
preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note.
Yeah, because it needs to be on the record.
If you have questions,
can
the
make this
court
a little
will talk
louder.
with the parties before answering, so it may take some time.
Oh, I don't have my plug-in on this one. Sorry, y'all.
You should continue your deliberations while you wait for an answer. The court will answer any
And then it
questions
froze.
in writing or orally
computer is
here
not
in open court.
Playing with me. Hold on.
When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdicts will be read into the record in open court. The court may ask each of you if you agree with the verdicts. Before I swear the officers, we will determine the alternates, and then I
This
will
is the
have
end
all
end.
the
This is the end.
civilian
It's
bailiffs and
6:20.
deputy bailiffs that
Central.
will be in charge of the jury.
This is the
during
end-to-end.
deliberations and sequestration.
We've got the last final rules. This is the end.
Wait, hold on. Yeah, let's-
I have no idea what he was talking about with the newborn. I don't. Question, will you do a verdict watch? I will go live for the verdict if I can, depending on when it is. But I don't think I will stream just nonstop for a verdict watch. We're going to give the mods a break. Today's been a real long day. We've got a podcast episode that comes out at some point tomorrow or Thursday. They're going to get the alternate going in the little spinny thing.
So we have placed each one of your numbers in the tumbler.
Your number's
I'm
up.
going to draw 3 numbers. Those numbers will be the alternates,
They're going to be pissed.
who will
To sit through-
nonetheless be sequestered. in
to
the
sit through all
event
this.
We would need to call upon one of you to replace another juror. first number that I am pulling out is 10.
Juror number 10 is the first alternate.
The second number I am pulling out is 30.
30. Oh, her rings are lovely. He doesn't know what's going on, and I don't think he wants to
The
ask.
third number I am pulling out is 1.
And juror number 1.
I want to confirm that I still have 12. I know Madam Clerk did it, but I will also do that to be sure.
Yeah, he looks really mad. So I've never seen this part of it. This is my preferred way of picking alternates. You don't tell them at the beginning who's going to be an alternate. You wait and you pick your alternates at the end. So there's 15 jurors sitting up there, and then they pull out the alternates. He's not quite sure what's happening, but he doesn't really want to ask in front of the jury. He doesn't want to be removed again. So he's like, what is happening? You're picking alternates. He probably doesn't know what alternates are. She's counting the last of them to make sure there's 12. He thinks it's a problem. I'm sure he's going to object at some point. But I like this because
Confirmed that the other 12 numbers were in.
are 12. Lawyers don't math. So this is all the jurors are sitting there thinking they
All right.
could deliberate. 3 of them get selected out.
I will need all of the deputies
The
and
alternates,
civilian bailiffs to come up and be sworn on the record
the alternates will be sequestered.
for the sequestration,
Yes.
and I'll go ahead and do it.
And they're swearing the bailiffs for the sequestration. My podcast is The Emily Show, because this is. You can also find it under The Emily D. Baker. The Emily Show episodes are up here on my YouTube channel where I live stream for now,
The court pause one
and
just in case
on
you
your
need it.
favorite podcasting app. Oh yeah, you can see how angry he is by not understanding what's going on and feeling like he can't ask. So he's frustrated. He's frustrated.
All right, would you all please raise your.
Nothing else
right
that can be done.
Do you swear
Yeah,
that
lawyers
you will
don't
keep
math.
all jurors on this trial together in some private and convenient place, and that you will not allow any person to speak to them or you speak to them yourself, except to ask whether they have agreed on their verdict, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God? All right. and
All of
then
this being done on the
Madam
record.
Clerk will just make a
So
record.
how are juror numbers
You all
decided?
are.
Normally when the
We'll
list is
take
given
us
to the
a moment
judge,
Just to have all the finalized,
there is a randomized
Paperwork.
list generally that's given to the judge.
the jury.
And then the numbers are whatever you are when you get called on that randomized list. So random. It's random. And then that's the number you stick with, and they call you by number instead of calling you by name. So if you're on the randomized list as number 1, you're number 1. If you're on the randomized list by number 30, you're number 30. And then sometimes you will call them by their seat number, depending on where they're sitting in the courtroom, but that's
Here are
their seat number, not their juror number.
jury instructions as well.
No more mask. Yeah, he took it off when he got mad earlier and didn't put it back on.
24. All rise
So.
for the jury as they're excused to begin their deliberations.
There they go. And they're off. We just like that, we've reached the end, y'all. Oh, I can't hear my. That's interesting. I couldn't hear my I don't know if y'all heard that. I couldn't hear my voice changer. Interesting. I don't know if you heard it or not, but
Yeah, no, I know.
they're all going to go out. They're going to go to the hotel. They're going to deliberate. I don't think they're going to come back tonight. I'll be shocked if they do. Verdict countdown clock start. Yes. They've been dismissed at 6:25 Central. There will be some last things they need to clear up with him. We'll see how that goes. With Mr. Brooks, I'm sure everyone in this courtroom's
Thank you.
exhausted.
You may be seated.
This would never happen in
Just
California.
so
Courts
the
close at
record is clear,
4:30.
The alternates, of course, will not be
That is it.
participating in the deliberations. They will be in a separate jury deliberation
mask.
room, and will only be called upon.
We made it, fam.
Needed, of course, after consultation with
Yeah, it didn't.
the parties. As far as how late, I will let
I'll
them
figure that out.
deliberate tonight. We have ordered dinner for them. I believe it will be here shortly. And
not
I
today.
really will leave it up to them as to how late they want to deliberate before they would want a
So he
break
has to
and
stay at the
then
courthouse. He's gonna be
retire
pissed.
For the evening. They are under a sequestration order, so they will be kept separate and apart. Their electronics have been confiscated. and they will not be going home until verdicts have been reached or they are discharged from the court, whichever would occur sooner.
Does the jury sit in the same seat every day? Yes, they do.
Anything else the parties would want me to address at this moment
They could come back tonight.
from the state? Anything from you, sir?
Yup. Did you hear him? Yup. Could you just take the mask back?
I'm gonna have to stay here while you're delivering.
Yup.
Be able to go back to my unit, use the phone, shower.
Nope. 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 Nope.
It is shower day for my pod. We only get 2 shower days.
I don't, so here's what could happen though, sir. I don't have a problem with you doing that, but they could have questions and then.
You have to
so-
be here.
And then you would need to become available so we could address any questions.
You're not
they
getting
may
a shower
ask for
today, homie.
Exhibits, things of that nature. So as long as you're willing to come back for those things, I don't have an issue if, I probably should talk to the COs. Or
Yes,
at least the sheriff.
you
and make sure
should.
I'm not stepping on their toes since they're in charge of all of that. But it's possible that we get a request for exhibits, some exhibits initially. That
Normally, your
wouldn't be
lawyer would just
surprised
be
if we got
here.
that. So let me do this. Let me confer with the sheriff's department. I don't initially see an issue with that, but I want to make sure that.
They might not
they
be able to
have a
get him, what,
protocol
he's
in
got
place.
private
That's what they
transportation?
would like to do as well, okay?
Because normally your lawyer would stay there.
And one more thing.
She's going to try to accommodate you.
I was curious. 61 charges for the reckless. 61 injured parties did not testify.
They don't have to.
So how does that work? How
So that was for closing.
essentially how are charges able to be charged if all of the injured parties did not testify?
Ask your lawyer.
From my perspective, sir, the state
Ask your lawyer.
presented their theory of the case, and there was sufficient
He could have argued that
evidence regarding the charges.
He could have argued that
to go forward to the jury.
in his closing.
I can't further explain it from there because that would, for me, that would require me to explain
Yes.
the law.
Ask your lawyer.
And I guess that's all I can really say about it at this point.
I got a point though.
I'm sorry?
I got a point though.
You could have argued it.
I'm not gonna comment on that, sir.
You think you do.
Of course, the state bears the burden of proof, and they have to convince a jury beyond a
Yeah,
reasonable doubt.
you didn't say that in your closing, sir.
For better or for worse, sir, I was not presented with any motions to dismiss, either at the end of the state's case
No,
or
she
the close of
wasn't.
the evidence regarding any legal arguments you may have had regarding those issues. And so at this point,
This goes forward.
the jury has the case, and they will determine.
Oh, he
their
thinks he's
verdicts.
done
If
something.
there are issues of law that you want to raise.
He thinks he's
after the
done
verdicts
something.
Are received, then you'll have to make that determination.
Yeah, that has to be raised because essentially you can't, if no injured party testifies, then it shouldn't be a charge.
Well, sir,
I disagree with that characterization, sir, but there is
Sir,
frankly no motion.
you
in
didn't make
front
a
of
motion
me
to
based in
dismiss.
law or fact, so for me to comment any
Bye.
further would require me to give an advisory opinion, which
he
I'm
did not make a motion to
willing do.
dismiss.
So you're
The,
saying I need to make a motion?
So what I will
She's not telling
say
you
at
what to
this
do.
point is I do have one issue that I
His
would like
behavior.
to raise with the parties. I frankly I need a break a little bit. I mean, obviously the court has to stay open. I know my dinner is coming. And I think it's reasonable. I need to put a few things together, but I do need to make a record of some information that I received earlier today.
oh, shit.
So that the parties are advised of that, but I will do
shit.
that.
When?
I'll
Now?
confer with the sheriff's department about your requests.
You're
I'd
taking-
like to take in about 30 minutes, address the issues that I need to address, or the issue. And I want to find out if that would interfere with your request about taking a shower. And
You're
all
taking a
that.
30-minute
So,
recess at 6:30 at night?
If you can hold tight and stay with us for a little bit, that would be great, and I'll confer with the sheriff's department and have a more definitive answer for you shortly, okay?
Can I get my filings?
What is this
Not
face?
the You want the originals back. If Madam Clerk has scanned them all in and they're uploaded, I don't have an issue giving you the originals
What?
back.
We
They
live
will
here
have a
now.
date
We're
stamp.
never leaving.
They don't have a time because they were filed in court.
When he put the time on them. I also, so that you knew they were in there, printed them after I scanned them, so it has a document number.
What she said was there's info she has to put on the record. We need to know.
See, I didn't interrupt you, see?
I'm sorry?
I said, see, I didn't interrupt you.
Oh, he wants a cookie
Thank you, I
now.
appreciate that. Unless I would like the parties back in about a half an hour.
Fucking hell.
Thank you, unless they have a question sooner.
Do I have to go in that holding cell or do I get to go?
Oh, you want a better holding cell now? We're on a 30-minute. We're on a 30-minute recess. We're on a 30-minute recess. Something is up and we're on a 30-minute recess. Okay, y'all, here's what we're going to do. Since my computer has given me total fuckery again and I need to go check on my kids, I am going to end this stream and start a third stream so we're not running into the same buffering issues with the stream. Did you see his face at the end of this? He was like, I didn't interrupt you. Look, I can play nice if you play nice. Stop. Stop. So we're in a 30-minute recess. I'm going to grab another snacky snack. I got some peanut butter crackers, some more, health snacks with my gummy bears. We're going to get a little bit more water. We're going to set up a stream for 7 p.m. I'm going to start at 7 p.m. and we're going to mods. I'm sorry, take a break, take all the breaks you need. You guys are welcome to rotate and just troll patrol. We will do the best that we can. Our community understands. They point things out and they are so good. I guess we'll see you in 30 minutes. I'll send out another text to the text crew. I can't believe I'm saying this. We're going to set another stream. I guess I'll see you back in 30 minutes. We're going to stretch. I'm going to stretch. We're going to go to the bathroom. Everybody take a minute. And Mika, we're not done. We were so close. We were so close. The jury's been dismissed. I don't know how long we're going to be here because if she takes a 30-minute break and comes back and puts things on the record that need to be addressed and he freaks out, the jury could have questions. Could that jury come back tonight? I'm beginning to wonder if that's a possibility. Oh my God. What is happening? Things that don't happen in California. Court closes, jurors deliberate in court. That's it. We were so close. I'm going to roll the outro. I'll see y'all at 7 p.m. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.